Hello, good morning. Good morning. Welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the Commonwealth of Massachusetts versus Karen Reed. So, what's up, y'all? It's bright and early here, Chicago. It was so early, I didn't even have myself on screen. Can you guys hear me when I was talking before I was on screen or no? Is that not a thing? It's probably not a thing. So, yeah, it was so cold out. I had to give Scout a ride to the bus because it was freezing. It was freezing. So I was up against it time wise. I missed you guys. It's been a minute. It's been I don't think I've been live since. Thanks, Diz. I knew it was almost a rhetorical question. I knew you guys couldn't hear anything that I was saying. Yeah, no, it's been a minute. It's been a minute since I've hung with y'all. I think the last thing we did, we've put a bunch of shorts up, but we haven't been live for a hot minute. So I'm glad to be with y'all. You know, I miss you guys. So let's see. I'm gonna pull up. We were gonna go live last night because I wanted to do a primer. Dizzy had sent me a bunch of stuff for the primer, but I was kind of looking and like I had to finish this Garcia episode, which I had written over the past few days, and then I had to get it recorded, and I ended up that took me longer than I thought it was going to. So I don't know. It would have been like a late live, like 8 o'clock or 9 o'clock, and I was like, you know what? We'll just jump on a few minutes early here and kind of see where we're at from there. All right. So you guys know what we're doing today. Today we've got part 2 of the Commonwealth's motion to exclude Dr. Russell. And that's going to be interesting. And there's a lot going on in this case. The Commonwealth is much more aggressive than they have been in the past with respect to motions that they're filing, trying to keep things out of evidence. And it's one of those things that I'm always telling you guys, always telling y'all that the battle in any criminal case is always before trial. Always. It's where we decide what's going to come in and what's going to stay out. That subject matter is actually the beginning of my new Garcia episode, which should be dropping the next day or two. But it's something that I say consistently because it's true. It's absolutely true. When we're watching the trial, that is the end result of months, many times years of them arguing motions in front of the judge, seeking to either keep things out of evidence or get things into evidence. And it's always a challenge. It's always, frankly, one of the biggest challenges is trying to figure out how we're going to get things in and how we're going to keep things out. And that goes for both sides, whether it be the prosecution or the defense. It's always that battle, because what you're seeing at the trial is the end result of all the fights that took place leading up to it. So it's pretty interesting. All right. I don't have any of my mods back here. Dizzy, would you come back here for me? Or Dizzy, if you don't want to come back, could you pull me up the link? My preference would be to use like maybe like Boston 10, like one of the Massachusetts stations, so I could get the stream kind of up and ready, because I was running behind this morning. I'm gonna also pull it up. I've been fighting this little throat thing, which the timing sucks, of course, but what are you going to do? What are you going to do? Life is such. Life is such. So, hello, beautiful humans. I see you guys saying hello. I love you guys. I'm so excited to be back with you. Oh, you like the little hat? Yeah, I'm pretty excited. We've been talking about doing some like rebranding for the podcast cover art. So I don't know. It was one of those things where like I like our logo. Like, this is one of our logos, the Just Facts logo. This thing was our OG. Like, I had the old knife. I decided my original, if you guys have followed the podcast, if you know way back when I started in 2021, my original image when I was starting the pod, I'm like, you know what I want to have? I want to have, because it's Defense Diaries. And I was like, I want to have like kind of a legal diary or like date book, which kind of look like diaries. And yeah, you know what, PB? I think that's what it is. I think it's some kind of sinus thing, because it's like I'm constantly having to clear my throat, which I know is dripping down from my sinuses. So it's super annoying. But it is what it is. All right. So wait, Dizzy dipped. All right. Where's Mandy? Mandy might be getting the kids off to school. That's definitely a possibility. So let me pull something over here. All right, you guys bear with me. I'm gonna pull this thing. I gotta find it. Gotta find it. Oh, there she is. Good. Diz, if you could just lead me to where the best place to watch it is. Even if you email it to me, and just so I can get the link up. And then I'll pull it up. But we're a little bit early. I wanted to start a little bit early. Some other things that were filed, which I'm assuming there's going to have to be, and this is what they would consider to be a Daubert hearing, right? So Commonwealth here is arguing that Dr. Russell, who I think we'd all agree, I mean, she is an absolutely breathtaking human being in what she's accomplished in life. I mean, she's done it all, like quite literally. Like she's been everything. And she appears that she's really, really good at everything. So I think that the question becomes, is she qualified as a dog bite expert in the sense that she can provide the jury with information that will be helpful to them? Yes, of course I want you on. Oh my goodness. All right, I got to pull, like, Allie's going to get to the bathroom. So I'm going to jump off screen, yet I'm going to keep talking. So, if you're wondering where I went. So it was a very lengthy first hearing. Brennan was really going at her. And, one of the things that Allie and I DM chat. Let's see, where's C link in SY DM chat. Let me see. Oh, you're the best. You are the best. She put in all the abbreviations. You know me. I'm like trying to figure it out. It was tough. It was tough. All right. You did amazing work per usual, Diz. Thank you very much. Appreciate that. All right. So we got that raring to go. Oh, it's not starting until 7:25 a.m. All right, good. Good. Oh, wait. Are we 7:25 a.m.? Huh. That's weird. There's no way they're starting court at 7:25 a.m. there. That is so wild. There's nobody in the chat there yet. That must mean, I don't know what that means. 7:25 a.m. would be 6:25 for me. And obviously, I've got the screen up. It's not rolling. So, all right, I think we're safe. I think Allison's in and out. So, she wouldn't be happy with me. All right. So, again, with Dr. Russell, kind of what it boils down. I mean, obviously she's learned. She's a very learned woman. She's done it all in terms of, forensic pathology. She's worked in emergency rooms. She's, clearly the woman has seen a fair amount of dog bites, dog scratches, things of that nature, just injuries caused by dogs. I don't know if that necessarily makes her a dog bite expert, but I mean, if that doesn't, what does? I don't know that there's a doctor on the planet that specializes in just treating dog bites. That's not how doctoring works. You have to be able to treat all kinds of maladies and illnesses and injuries when you're a doctor, right? So, her ER experience certainly is legendary. So Allie and I were having the conversation. I think I'm going to probably wait to have the full conversation. The question becomes, there's no question that she's going to be testifying in my estimation. She should absolutely be testifying. This is one of those things. Yes, Garcia, I just recorded it last night, Kale. Just recorded it. That's why I didn't do a live. You must have been a little late. Good morning. Thank you for asking. Garcia should be out in the next day or two. It's in Darren's hands. He's doing the post work, taking out all my breathing and, all the things that he cleans up. So it's a nice, clean podcast stream. But really, to go back to Dr. Russell, I was thinking, it's 100% not an issue of admissibility. It goes to weight, right? And again, like, it's funny that we're talking about this is because this is exactly what I'm talking about at the beginning of my new Garcia episode. And it's one of the favorite things that the state likes to say. The prosecutors typically like to come in and say, you know what, just let it in. It's clearly admissible. Just let it go to weight. Let the jury weigh how much weight or credence they're going to give her testimony. You'll have, Brendan's going to obviously have the ability, and we're getting a preview of what he'll do on cross-examination with respect to her. She hasn't written any articles about dog bites and injuries. I mean, there's definitely things that he can poke holes in her expertise on dog bites. I mean, there's no question about that. So, this is definitely a situation where she should be allowed to testify. And the judge just says, you know what, I'm going to allow her to testify. It's going to go to weight. And it's the same thing with Green. And Green is the phone guy, the forensic phone guy that Yannetti and Jackson used in the first trial. He's the guy that was coming in and trying to delineate whether or not House Long to Die in the Cold happened at 2:27 a.m. or not. Like that question drove me nuts. That drove me nuts. Like the one thing I wanted from that trial, the one thing that drove me nuts about that trial, amongst many, many things, was that we just didn't get a clear answer as to whether or not that sentence was Googled at 2:27 a.m. It's like, and I don't need people in the chat. Like unless you work for Apple and or Google and you can give me a super defined answer, save it. I've heard all the arguments. I want somebody that actually knows whether or not that was Googled at 2:27 a.m. It's simple. It was simple. And we just didn't really get that answer. You know, it's like, why is that so hard to figure out? I don't understand why it's so hard to figure out. All right, so let's see. Right, I'm gonna pull this thing up. We'll just keep, I'm gonna put it on the screen just so we know. Hey, Dizzy and Mandy, check around, make sure that we're not missing it, because this thing's kind of freaking me out that it says it was starting at 7:25 a.m. That would be a long time ago. Long time ago. All right, so there we go. Got that going. I mean, nobody's even in their chat yet. It's like 8 o'clock. It's after 9. Let's see.
So much. There's been so much.
All right, so they got.
Oh my goodness! Morning from ice cold Iowa. I bet it's cold.
I threw up Brandy's stream, and there's some movement. She's watching. Let me see. I'm gonna
welcome. I think.
Yeah, everybody else
like
has it
here.
up.
Good morning to Kelly Reed. Good morning, Kelly Reed. Prayers up for you and your family today.
All right, so okay, Boston's late, so there's movement in the courtroom. You guys get me, if you would, one of the two of you, get me the new link. All right, okay, yay! Dizzy's killing the game today, per usual. All right, let me pull this guy over. All right, there we go. Man, Dizzy, that was amazing. God, that was good. So good. All right. Pull this up. Oh, they got a screen in there. Oh, there's demonstrative evidence is going to be happening today, y'all. Who doesn't love that? Ooh, look at that. Can we all have a round of applause for Dizzy, please? Thank you. Thank you. I want to see all the claps, all the Dizzy claps. Let's go. Let's go. So again, it's going to, like, there's going to have to be a very similar motion hearing for the green issue. Kind of another Daubert thing. They're going to be basically letting us see, get a preview of, and it's the same thing with that guy. He's clearly got expertise. Clearly he's going to have to be able to testify. He's going to go to wait. He's going to have to go to wait. Yeah, this was the OG courtroom. This is, they're back in the courtroom that they tried the case in. So I'm sure you guys have all heard Judge Bev has gone full gull. She has declared that YouTubers are not real media and is not going to be allowing streamers into the courtroom. I agree. I agree, Mandy. I agree. 100%. So we got the reads there. They're in place. Got, I mean, like, I wasn't sure. Is she, like, what does that mean? Like, she can't ban YouTubers from the courtroom, can she? She's just not giving out press passes to YouTubers. That's what she's doing. So you're not going to see Turtle Boy sitting up there as a press guy, which I've got to say is utter bullshit. It's utter bullshit. It really is. I would put YouTubers' legal coverage up against anybody out there. As a matter of fact, I'd put it above it, without question. To me, it's unequivocal. Like YouTubers, I mean, there are enough lawyer YouTubers that know their shit that you're just getting better coverage, and it's unadulterated, unfiltered. You know, we're able to expand on thoughts far more. You guys know I've done a huge amount of talking head stuff with Law and Crime and Court TV, and I mean, you're limited. I get a minute and a half to try to puke out everything I'm trying to say, and it's always based on a question that somebody's given me. And and I love Vinny. Vinny gives me great questions, but it's like we're on a time crunch. So, you can't get into in-depth conversations here. So, I mean, like, I don't care that there's a logo that exists. Speaking of which, Mandy or Dizzy, can you get rid of that logo in the upper right-hand corner? Do we have anything that we could pull that off with or cover that with? Can you move that down a little bit? Let me see. I could probably. There we go. I just did a little adjustment on my end, y'all. You guys are amazing. So, yeah, again, I just this attack on YouTube coverage is irritating. And what we're seeing now is that they are all coming to YouTube now. Like legacy media is now attacking YouTube. Like they're invading. But the thing is it's going to be the same thing. It's not going to be any different. It's going to be legacy media just on YouTube. They're going to have the same parameters. They're going to have the same legal departments. They're going to have all the things. They're going to have the same owners of the companies that are pushing whatever their agenda is. It's like, it's a whole thing. It's a whole thing. So, like, that's going to become a real fight, I predict. And I'm up for it. At some point, those of us who stream trials are going to get sick of this shit, of judges trying to say that we're not actual media. And I mean, for me, it's hard. I mean, I'm a lawyer first and foremost. I certainly do investigative reporting, which I'm super excited, y'all, about tonight. Obviously, I am very, very excited about tonight. Jennifer's going to be on with us. Jennifer Auger, one of Rick Allen's defense attorneys, in the highly anticipated first interview that any of the defense attorneys have done, followed by Andy Baldwin on Wednesday, and then Brad Rosie, which I had to move up. This is fair warning. You have to pay attention. I had to move up Brad's interview until 5 Central Standard, 6 Eastern Standard, because Notre Dame is playing in the college football playoffs. And Brad definitely wants to watch that. So, I had no problem moving that up. So we'll be going 6 Eastern, 5 Central, and then everybody's and Notre Dame fans going to be able to watch the game timely. So, I mean, because he texts me, he's like, "Look, man, like, this game's going on." He's like, first he's like, "Do you want to move it to another day?" I'm like, "Nah, man, I put it out to the world. I'm not going to do that." So he's like, "All right." I was like, "I'll move it up. We'll move it up early." So, yeah, I'm really excited about that. And, like, I'm gonna just let y'all know there's probably going to be things, because there is an appeal pending. And I know everybody wants to get into trial strategy a ton, but, and I'll ask Jennifer, if there's things that She feels that she's not going to be able to talk about for two reasons. Well, you know what? I'm going to leave it all for tonight. You're just going to have to tune in. We anticipate that it's going to be a phenomenal series of interviews, and we're really excited about it. I want to be turning the chat off, y'all, but you guys have done a great job on the community page, leaving questions. And I've been so impressed. I mean, there have been some folks that have just left legendary comments in the comment section over on our community page with respect to questions. I mean, there were some that would qualify as a short pamphlet, I think, but it was. I'm impressed with y'all. All right, you guys have sound, yes? I don't know what the sound's like. Morning, Pammy. Pammy, I meant to tell you how much I love you. Like I never, because you're always sending me either Venmo or Cash App. I think, Pammy, you do Cash App. So I neglect to thank you for your incredible generosity all the time. So thank you, Pammy. I adore you as a human being. And I know Pammy in real life. She's wonderful. Oh boy, sounds sucks.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, is Dr. Russell in the courtroom? All right, so why don't we have Dr. Russell take the stand?
There she is. Oh, I bet you my mic's loud as hell. I have to remember.
Dr. I'll remind you, you're still under oath. Thank you.
All right, good morning, doctor. All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning, Dr. Russell.
Good morning.
Dr. Russell, it's fair to say that your opinions have changed between the time when you first testified at the voir dire to when you testified at the trial and then at our last time we met at the Lanigan hearing.
We have not.
Do you remember we spoke about when you testified at the voir dire hearing, you had uncertainty about what had actually caused the wounds?
I did not.
Do you remember using the words like most likely a dog?
No.
Let me remind you, in the voir dire, do you remember the court asking you what kind of animal caused the wound? And you said most likely a dog, a large dog?
May I say that?
Yes, you may. Counsel, page 51, line 18. May I approach, Your Honor?
Yes.
Dr. Russell, I'm showing you a copy of your voir dire transcript. I'm going to ask you to read it yourself when you're done reading it. When you're comfortable with that time, I'm going to ask you the questions again. You can look at any part of that you would like.
Yes.
Thank you. Do you now remember when the court asked you what kind of animal you said most likely a dog, a large dog?
Yes.
Do you remember at trial your perspective and opinion changing?
No.
Do you remember you were asked at trial whether or not the patterns appear to be injuries you would see consistent with an animal or a large dog, and you said yes? Do you remember that?
I see that.
Yep, you should may.
Her mic is not turned on. Somebody from Court TV called on the mic's not on.
Trial transcript, page 23, line 3. This is a copy of your trial transcript. You can look at any part you like.
Okay, I see. Yes.
Okay, thank you.
Is it loud enough?
It's cranked. It's like her mic's not on.
Do you remember now saying that?
I didn't say it.
Okay.
The question had that word possibly in it. I didn't say,
I'm sorry. You can finish, please.
I didn't use the word possibly.
You were asked, does this appear as a pattern of injury that you see appear consistent with an animal or a large dog? And you said yes. Do you remember that?
Can you show that to me again?
Yes.
Okay.
Let's read it together.
Okay, that's a good idea.
Your Honor, may I make a suggestion if I could, please? I realize it's crossed. Mr. Brennan and I have agreed that with regard to transcripts and the use of them, I have as well. Given that we've agreed for transcripts being in evidence, can the witness keep the transcripts and look at
Do you
them?
have an extra copy for her?
The answer is I have a copy, yes, that
Do
she
your
can.
colleagues each have a copy?
I don't know if they do, but I can give mine
Okay.
so that she
Problem
can
with that,
have.
Mr. Brennan? Okay.
Why isn't the state? They're crossing her.
Okay, I know what they say.
Oh,
Ah, I know what they
Feisty.
say.
feisty. I like it.
You might, I'm gonna go through a lot of it, so you might as well give her the whole trial transcript.
Okay.
What I'm going to do is I'm going to ask Mr. Brennan to make a copy of mine. All right, so that we can continue. You can give yours to the witness for a few minutes, and then when these are done, you can.
There you
give yours.
go.
Thank you, Your Honor. I appreciate that.
Thank you.
Thanks, John.
I mean, typically you got one spare for the witness anyway. I mean, come on, guys. Get it together. Get it together right now.
Why don't we take a 5-minute recess? Mr. Brennan, Mr. Alessi, why don't we take a 5-minute recess?
Y'all need a recess. Pull your
Mr.
shit
Tarrant
together.
will be back with clean copies of the transcripts that I have as part of your exhibits.
Thank you very much.
And the witness can
So
know.
Mr. McDermott doesn't have to do it twice. Mr. Brennan has just indicated to me he's going to go back to the June 18th. So is Mr. McDermott going to copy the June 18th and the June?
I have the voir dire and the trial testimony, so we'll take a 5-minute recess.
Thanks very much.
All right.
Yeah, you can hear.
She's not
Um,
happy.
Nah, I mean, Brendan should have had that shit.
Yeah.
Like she's trying to take the defense's copy of the transcript. It's the state's motion. It's the state's cross-examination. They're the one trying to impeach her on her own words. Have
Right.
a copy.
They should have had a copy for
Right.
sure.
That's what I'm
Right.
saying. You can hear.
In all
I don't know.
fairness, I think they both should have had a copy. Just gonna
Yeah.
say.
Yeah. I suppose so. So you can hear them trying to turn up the gain. They're cranking the gain on the mics. So like, because when Elise was standing up,
So who is this guy? Can you tell me this? I don't know what's going on.
he's the new addition to the team.
This young
So-
kid?
He's not young.
He's not?
No, he looks like to be in his 40s to me.
I mean, that's young these days, babe.
Oh,
I look at a picture of me in my 40s. I'm like, wow.
This
those were the
kid.
days.
Uh,
I mean, I looked at a picture of me 2 years ago and I was like, wow, those were the days.
you look equally beautiful. You haven't changed a bit.
Okay.
Told you that. That's
No,
true.
but it's okay. Thank you. babe.
Yeah, it is true. It's true. So Allie's looking at a picture of us like in Mexico after like 4 days of relaxation. And Allie, when she gets in the sun, she's got that Mediterranean skin. She gets dark, y'all. So she's got that olive complexion. So she's like comparing. She's like, look at this picture of me relaxing in Mexico, all nice and tan and rested.
I didn't say all
look
that.
at me now. But you implied it.
I mean, I guess.
Yeah. I explained that to you that evening. That is just
You did.
not a thing. You look, your best way to try to figure out how you're going to age is your mother. And your mother's spectacular.
That's true.
If you guys saw
So were my
Ellie's mom,
grandparents.
you would never guess how old she was. I have no idea how old she is because she looks like she's like 48. Like, no bullshit. She is like, so you age like your parents, you know?
She's 72.
I mean, dude, no. Like, you'd
20
never
years
guess.
older than my sister.
She's amazing. She looks fabulous. That's your
She's turning
genes, bro.
73, I think. So in 2 days.
Is it in a couple days? Yeah, it's coming up, right?
Wait,
It's
I'm
not coming up.
51. Lauren's 53. My mom's 73. She's turning.
So I was telling the people we're very excited about tonight. I think that it's going to be a great few nights. I think we're going to get some really. Okay. So I'm going to give you a little bit of bio on Robert Alisi.
Hey, wait! Don't let me forget. I've got to be on Zoom, Court, at 9. I'm actually going to plug this phone in, I think.
Okay.
Well, I can't plug the phone in because the computer.
Hey,
needs to
listen,
charge.
at 9 o'clock, don't forget, you got to be on Zoom for it. All right. So Robert Alisi, the new attorney on the Karen Reed's defense team, he's a partner at the New York-based firm DLA Piper. He's the global vice chair of the firm's energy sector. So this is not like his real purview. He's like a science nerd guy, so that would make this his purview. So he handles complex energy, environmental, and financial services matters for Fortune 100 clients. He also defends clients in criminal cases involving claims of constitutional and other rights violations by government officials and agencies. I love him already. So he joined the defense team. They filed a motion to add him in. I'm assuming he had to come in pro hoc to get him in. So yeah, let's talk about Alan's beard.
I wanted to talk about the motion, the newer motion, but
You know what I'd rather talk about is
yeah, Alan's beard. I hear you. This will be a hard one to make into a podcast episode.
Little patchy.
I mean, it takes some time to get it as.
He's been growing it
spectacular
for a hot
appearance.
minute. Like I can't tell if this section here just doesn't grow for him. No, I've
He's
got
like, look, this one's like, look, I don't need a beard. I have dimples.
yeah. Look, Sheila, I love beards, but I'm a beardsman. Like I've got a very well crafted, well taken care of beard.
Well
So
coiffed.
I'm going to be a little judgy.
Well coiffed.
I'm going to be a little judgy about beards. You know?
I mean,
And
my
it's like
man's got an amazing beard.
so I don't know what I'm trying to ask. What I'm trying to ask is, does he like? There are people that don't have the ability to grow the sideburns down to connect with the beard. So
Could be a California thing.
let's look at it. some more.
Simi's
See
mentioning California, so
It's strange looking to me, and I love beards.
no, that's not
Beards.
normal. I don't like that.
I love them.
I'm not a fan
And I
of that.
want Alan Jackson to have a beard.
It's like, is that the way Abraham Lincoln's beard was? Did he have like a full beard and no mustache and no sideburns?
Well, see, he's got like a goatee, like extreme. So he's got, goatee's just here. right?
Thanks. I think people
If
know.
I were to take all that off,
Oh,
but
he
his
does
is
have
like
a full beard. Yeah,
it's not a full beard because he
Well, it's a
doesn't have
mustache and a beard. You can't call that a goatee just because he doesn't have the sideburns, but that's weird. I don't like it.
No, but I can call it not a beard because it's not a full beard. Are you an expert on beards?
No, you are, but
Thank
it's.
you.
I think it's intentional.
You're an expert on many things, beards.
You know what it looks like if you like get it from a certain angle. It's like he's got a whatchamacallit mustache, a handlebar mustache, but he doesn't. You see what I'm saying?
Yeah, kind of like me. I have like a very full mustache. My mustache is
Because the beard comes up but doesn't go all the way up.
see from the front it looks great. That side shot, like it looks like he can't grow hair there. It's so like I don't know.
No,
Maybe
I
it's
think
just a choice.
it's
It's
a
just a choice.
It's a weird California choice. They do it in
choice.
California because it's hot and they need their ears to breathe.
Yeah, yeah. Oh, so which motion did you want to talk about? So you know that we've got obviously this motion's going, and you know that they filed a new motion seeking to bar Green, the defense's forensic cell phone guy from testifying. So we're going to have another
that's the new
dauber.
one. Okay, I thought they filed something additional on this specific witness. No, okay.
Yes, no, that's fine.
We have different stenographers.
I was making that up.
Might be different.
I think I was thinking about that other motion.
I'm
Okay.
working on because I don't want it to become confused. Do you mind?
No, I don't mind.
Yeah, now that you can see
Oh, we have
Elise here, you
holidays?
can see he's not a young kid.
Unfortunately, I
No,
won't.
I was thinking that.
How
Yeah.
about yourself?
I did some work too.
Did you?
Well, not I mean,
What? Look how the mouth versus the whose sound are we hearing? We were
that-
hearing two different people talk.
That hot mic was not any of those. It
Right.
was not the defense team. It was not the defense team. So, Core's on a short break.
She's chewing gum in court. Wow.
She don't care. She's like, I'm going to chew gum, and you're going to like it. That's what's going on right now. I'm
Not-
chewing gum,
Chewing gum in court.
and you're going to like it. Joy, we love you back. We love you back. Yeah, look, I mean, you can't talk about true crime all the time, right? Can't do
I
it.
mean,
Can't do it. So we got a couple of exciting things going on. So we're rebranding.
you mentioned
So
that, didn't you?
This is our logo. Wait, I didn't mention it on the live.
I
don't
thought I
think-
heard it. I was laying down, but
Oh, maybe
I
I
was
did.
listening to
Maybe
you.
maybe I did start talking about it.
But before you go there,
Oh my
we
God.
said we're gonna do no comments on our interviews, but we are. We're just gonna save them to the end. They're not gonna look at them during the episode.
Oh yeah, for sure. Like, we're just because we are converting these into straight podcast episodes, so we want them clean. Like, there's not going to be any of my typical nonsense,
Yeah, none
my
of that.
tomfoolery,
It's tomfoolery.
my ballyhoo. I'm not going to do any of that because it's going to be. We want them to be really tight, fantastic interviews. So we elected that's why I did the whole thing with the community page and questions, because we love you. We know there's a million questions out there. There's going to be things that they can't answer, that they won't answer
Right.
because there's an appeal pending. So,
And there might be a retrial.
there,
So
there might be a retrial. Right. So, I mean, that's the hope from their side of it. So,
can't get all the juice, but we'll get whatever we can.
yeah, we'll get trust me, we will squeeze every bit of juice out that we can that they're willing to let drip. So, I mean,
And we'll just have to do like we did on the live with Lauren for the murder on Songbird Road, where I was like, and if you can't answer and you're going to have to tell me, I'm just going to have to wait. And then
Yeah.
she's like, yes, you're just going to have to wait. And
Ooh.
this is Lauren. I can't
good
do a
Lauren
voice
for
like
it. That was pretty good, actually. That was pretty good. So yeah, we're excited about Murder on Songbird Road as well. I see you, Dr. Bonda. Yeah, thank you. We're really proud of it, and it's a banger. It like that first episode's nothing. like I really don't come into it like heavy, I'd say until episode 3, right, babe?
Yeah. Well, that's like, yeah, that's where it's like, boom.
Yeah, because that's when we start going down. Like the first 2 episodes are really a lot of background, trying to give you guys the background about the case, about the trial. So it's, you know, it's a story. So
Ah, jeez.
we're really
As
proud
soon
of
as
it.
this gets moving, I'm gonna have to hop off.
How does
Hey.
Proctor's shitstorm affect his trial moving forward? That's a great question. He if he's terminated after his hearing, and like I don't know why people were confused about whether or not he was terminated. Allison and I told you he was not terminated. It is very difficult to terminate a cop.
He was relocated, right?
I mean, he was suspended. He was suspended pending, you know,
Right, but
pending
then
a hearing.
ultimately, what was he? He was
He
sent.
was. They moved him too.
Right.
They took him out. Yeah, they moved his position, but he was suspended. And
They're like, we don't really mind, but the freaking
the
public
cop
whining.
unions are
No joke.
legendary ball busters. It is really, really hard. Yes, exactly, Ems. He was rehomed.
He was rehomed.
Yes, he was. Yes, he was.
Oh, I wish I was back in bed. I'll tell you the truth. I've got
Oh,
this
do
headache.
you?
It's killing.
Do you?
Killing.
Really?
Mm,
You don't like being with our beautiful humans? Aww.
I do.
Aww. So yeah, the next episode is going to drop. All right, so I'm going to crank up our mics, babe. We got to go back to whispering so as not to
Okay.
blow out eardrums.
I'll
All right,
just
we're
turn
cranking
mine-
it up, y'all.
I'm turning mine down.
Yeah, that's a good idea.
Someone let me know if that sounds right.
All right, if I'm talking normal, how's that?
I'm sorry, Your Honor, I'm just conferring
very
with
soft.
permission, Mr. Brennan, I want to make sure.
Well, are you whispering or talking normal for real?
Only one person can speak at a time. I don't
It's
know.
good though.
All right, so you were speaking to me, Mr. Leslie. I think Mr. Brennan was speaking to
What
his
about my sound, babe?
co-counsel. No, that's okay.
I just want to let you know what we were doing, Mr. Brennan and I
Up a little bit.
conferring to make sure we maximize
You sure it's
the chances
boosted?
of the exhibits being right. So I've offered to Mr. Brennan something he wants to consider and look at what he has to make sure we do this efficiently.
Okay. So the copies that Mr. McDermott made are the attachments to the motions that were filed.
And provide a copy with the court's permission of the voir dire testimony, the trial testimony, and Lanigan hearing.
Sure. Okay, I did not have Mr. McDermott do a copy of the Lanigan hearing.
I've had an extra copy that I've given to
Great.
Ms. Russell.
Wow, babe.
Is there a problem with that, Mr.
No
Leslie?
problem.
Okay.
I'll be right back.
May I again approach the witness?
Yes,
May I speak, Your Honor?
yes.
Dr. Russell, I'm handing you 2 documents. You have a third. The one before you is a transcript of the last hearing called the Lanigan hearing that you attended. This is a copy of your voir dire testimony. I've noted it on the top right for you, and also trial testimony.
Thank you.
Thank you. May I proceed, Your Honor?
Yes.
I had asked you if you had expressed any uncertainty in the past about your opinion as it relates to the opinion you gave at the Lanigan hearing, at the last hearing, whether your position has changed or evolved is what I'm getting at. And you said that your position has not changed. Is that right?
That's correct.
You were asked at the trial about the injuries and how you think they happened. I want you to turn to the trial transcript. If you turn to page 19, line 21.
19,
Page
Line-
19, line 21, may I approach, Your Honor?
Yes.
So the page number is here?
Yes.
And then line would be. Sorry. My apologies. This one is the trial.
Wow, state, pull it together. This is the special prosecutor who's a criminal defense attorney? I don't get it, what he's doing. This is shocking.
Do you recall at the trial, you were asked about the injuries, and you said, I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of injuries? Do you remember saying that?
that's not here in front of me.
Okay, but I'm asking you, do you remember saying that at the trial, that you believe the injuries were sustained by an animal, possibly a large dog?
Something to that effect, yes.
Okay. And when you said that, you used the word possible because you weren't certain, were you?
Can you show me where that is?
Well, I'm asking a question, not asking about the transcript. The reason why when you were asked and you said it was by an animal, possibly a large dog, is because you were uncertain.
You know, Mr. Brennan, I think I explained that before, that in medicine, there are no absolutes. And that's what, physicians are ingrained to think, is there are no absolutes in medicine. So that's why I expressed it that way. But
Yeah,
I was certain that it was a dog.
Yet you were testifying as an expert witness, weren't you?
Yes, I understand that, but I was thinking like a doctor.
I see. And you understood as an expert witness that you were asking the jury to rely on your opinion. You were trying to be as accurate as possible, weren't you?
Yes, I usually do, yes.
You were trying to be precise in your testimony under oath, weren't you?
Yes, and I don't see a difference really between those.
And when you use the word possibly a large animal, that's different than an opinion to a reasonable degree of medical certainty, isn't it?
Objection, Your Honor.
In this witness's view. She can answer that.
That's not what the transcript says that he's referring to.
So he's not asking about the transcript. I'm going to allow the question.
Would you like me to repeat that?
Yes, please.
When you chose the word during your testimony to precisely describe what you thought, and you said possibly a large dog, that is different than to a reasonable degree of medical certainty, isn't it?
No, I don't think so.
You were asked whether or not you could tell what type of animal left these marks, and you said you couldn't with 100% certainty. Isn't that true?
With 100% certainty, that's correct.
And the reason why you don't have certainty when you first testified is because there really is no methodology in identifying dog bite wounds, is there?
That's incorrect.
I see. When you talk about methodology, is there any standard you're comparing your comparisons to?
There are multiple published peer-reviewed articles that describe what dog bites and dog injuries look like.
Is there any standard that you use? Is there any particular things you look at with specificity that you compare to a standard model?
The pattern.
The standard model of patterns, where do you get that from?
Pattern recognition is used throughout medicine. And, it's something that I have been trained on since actually before medical school, but certainly in medical school.
Pattern recognition, you understand, is different than a standard of comparison. You understand
No.
there's a difference between those two things, don't
Oh,
you?
yes.
Okay, we'll talk about pattern recognition analysis in a minute. But what you're saying is that there's a
Yeah, I know more about medicine than I've forgotten more about medicine than you know. Brendan.
That's what she should say.
That should be your answer.
Methodology in identifying dog wounds. I'm asking you, where does that standard come from?
It
Training
comes
and
from
expertise.
multiple published peer review articles.
Okay. Tell me one.
Munich.
I'm sorry?
Munich. We talked about that one last time.
The gentleman who studied human teeth.
No, he wrote about dog bites.
Okay. What's the name of the article that you've relied on?
The name of the article, I have to refer to my report, but it's something to the effect of forensic evaluation.
Do you have any specific memory about what you're relying on as a standard of comparison to identify dog bite marks?
Yes.
Okay, share that with us.
Again, the standard would be what the wound looks like, and the pattern recognition that goes along with it, along with the configuration of the wounds. It's a multifactorial
I'm
process.
trying to have you assist us in distinguish between pattern recognition analysis, which we're going to get to, and when you're looking at a wound, the standards in the science, the standards, the methodology you would actually use to look at it and see if there's points of comparison, to see if there's similarity. What standard are you working with?
I'm not so sure I understand what you mean by standard then, because I know how I evaluate wounds.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside, aren't you?
I actually find
Why
that
is she
offensive.
No?
even
Okay.
letting
Is that
the
what you're doing?
right? Why
No.
is she even letting the
So if you're comparing it to an actual science, a standard, a methodology, I want to learn that methodology from you. So what I'm asking you is tell us, where does that come from? The methodology where you have a point of comparison, where you look at a wound and you compare it for similarities to another item.
There are several published peer review articles that describe what to look for, how to observe, evaluate, and then sometimes treat wounds, dog bite wounds. There are, several authors that have published similar things. And in terms of there being an organization that says, here is the standard for dog bite wounds,
Right.
I don't think that there is one.
When you say you don't think there is one, if you're an expert in this field, you would know that there is not one, is there?
There is not one that I know of, correct?
Well, you're not guessing there might be one you don't know of.
I don't know of any published standard by an organization.
So it'd be fair to say, when you are giving an opinion, what you personally believe to be a dog bite wound, there is no standard in dog bite science that shows you what the standard is.
I
There's nothing to
disagree,
compare
you
it to.
asshole.
Again, it's based on a combination of the experiences that I've had over the last 30 years, observing, evaluating, and treating dog bite wounds, plus the numerous articles that I have read on dog bite wounds, their characteristics, morphology, patterns, and other things like complications,
Right,
et cetera.
right. Okay, so to get back to my question, I know that you're using your experience and your memory, but there is no standard of comparison. There's no methodology that is accepted as a practice.
I disagree.
Okay. Can you share with us one of those articles that you've been relying on to combine with your personal experience to come to conclusions in dog bite analysis?
Well, there's the Munich that we talked about.
I didn't talk about. Can you tell us a little bit about it?
Oh, certainly.
Okay, please.
Okay, would you like to go through it together?
I'm asking you to tell us about what you're basing your opinion on, and you said it's Munich, so I don't know much about.
Okay, that's one of them.
Well, tell us a little bit about that.
Okay, well, in that article, the authors described a fatal case, but also described what some of the characteristics are in dog bite wound cases. What types of wounds you see, their appearance, their distribution, their configuration, the different aspects like that. Many of them are parallel. things that would affect the appearance of wounds that physicians know about, such as elasticity of skin and other ways that wounds can be distorted from from one to another wound. So you have to know a little bit about wound characteristics, and basically things to look for in the forensic evaluation of dog bite wounds.
Did that article lay out a standard of methodology?
I guess I don't understand what you're getting at.
Rather
They-
than having a particular case study where that article talks about a person that was attacked by a dog and deceased, correct?
Can you
In that
pause
case,
this?
Yes.
however, it
And
referenced.
based, and
I'm
it's,
sorry, Your Honor, if you could finish the question.
Yes. I'm going to let her finish.
I'm just surprised that the judge is not chiming in. What if everything he was saying was a knife wound? What is the methodology, though? What is the science? Well, you see,
Right.
you look at the length and the depth and the where the wound is, and I mean, like, what
What's
is
the
this
standard
asshole
of a
talking about?
knife wound? That somebody was stabbed with a knife. See, here's what the problem is with the what he's looking for is he's looking for tool marking type analysis and
I don't
peer
think they
review
have that for
articles. There
forensic.
isn't
I
because
mean, for knife wounds, even like a forensic standard, to
right,
a
but
methodology.
right, but here's what I'm saying. The rare thing about this case is that 99% of the time when somebody's attacked by a dog, you're not having to try to figure out if they were attacked by a dog. That's the problem with this case. That's why you're not going to find peer review articles about determining what somebody was attacked by. I mean, I'm sure there's articles relating to wild animal attacks, like
Thanks, Andrew.
predation, like post, like posthumous predation attacks. Like, what was this? Was this done by a wolf or a turtle? So as far as like what he's looking for, I don't think it exists in the world. I mean, again,
She can
this
say
goes
what
to
her
weight.
methodology is. Her
It
methodology
goes to
is,
weight. It
I
goes
look
to
at it.
weight. We're both talking at the same time. It
Sorry.
goes to weight. Right? This isn't an admissibility thing. Like he can say all this shit in front of the jury and they can give it whatever weight. They could say, all right, well, you know what? The woman's
Oh,
been
I would
doing
be
this for
fine.
30 years. She's been treating dog bite, dog scratch injuries for 30 years. She knows what they look like. That's her opinion. But the thing that I was going to ask you, like when they use the term, with a reasonable degree of medical certainty, it's what they call a term of art in the law. Okay. And like when you have an expert come up. So just explain a little bit that I wasn't being rude, law junkie. We can't both talk at the same
Yeah,
time.
you were
What
talking
about
first.
saying don't be rude to Bob?
Right.
But like we have to take turns talking. Like we can't hear each other when we're both talking at the same time. So and we've been married for a long time. Like please don't start that shit. Or I'm gonna cut the live. Like we
Oh,
can't talk at the
geez.
same time. Jeez.
Now you're going a
Like
little
every time I
overboard.
see it on there, I get like it upsets me. Like, am I being rude to you, babe?
You're being rude to the listeners right now. That's what I have to say about it.
I'm not being rude to the listeners.
Or the viewers.
So, but like explain the difference, like why that matters when you're having an expert testify. Like that's who you hear use that term of art is within with a reasonable degree of medical certainty. This is my opinion. So like explain the difference, why that matters in a court of law, because she's not in a doctor's office. She's on the stand. And what the opinion she's providing
Right,
is
that's just the standard in the law that the expert needs to get on the stand and be able to say, I have made this determination to a reasonable degree of medical certainty, which she is saying is the same as her saying it was a large animal, possibly a dog, if in fact she used those words, because there is no 100% certainty. Um, and I just think that I don't know why the defense didn't use that term. I think at some point they tried to, and then there was like an objection, if I remember correctly. But I think it's very typical to ask, and have you reached an opinion to a reasonable degree of medical certainty? Like that's the question that is asked
Right.
usually, so that she
Exactly.
doesn't have to say what it is. And if she's not used to testifying, she's not used to having to spit out the legal standard. Um, yeah, I'm gonna hop on my live on my Zoom on my phone, and I'll stay on until he calls my case.
All right, cool.
But I would also be filing a motion in limine if I was them, so that he can't do this shit about asking for questions that have no place in this arena or, you know, science,
And
because this isn't how did you extract freaking DNA. And if
and if I'm Dr. Russell, I'm boning up on this DeMunic article because like that's the advantage for Dr. Russell in having this hearing now is that she knows what he's going to come at her with. So bone up on that article so that when he asks you, okay, well, what did DeMunic say in that article that allowed him to be able to identify a dog bite injury from because that's really what the question is, right? The question is, how are you able to delineate between a
a
dog
dog
bite
bite and a
injury
wolf.
or say like road rash, right? Like how are you able to tell that was a dog that did that as opposed to somebody who dumped their motorcycle and wasn't wearing a leather jacket and just tore their arm up? Like what allows you to come to that conclusion? Is there some kind of science behind it, or is it just an eyeball test and common sense? You know what I'm saying? So I don't know. To me, like if Bev doesn't let him or let her testify, I want to be stunned.
Please.
And Mr. Lessie, for objections, just simply objection.
I'm sorry, Your Honor, well, thank you.
Okay. That article, it was a case report, but it was also a review of previous literature. So in the review of the previous literature that had been published, they came up with recommendations. So yes, there are recommendations in that article.
In that article, it talked about a wound to the neck where the deceased bled to death, correct?
Yes,
Okay. It didn't talk about pattern recognition analysis.
I
in that article, did it?
disagree.
Okay. And did it talk about a standard of practice of methodology?
Recommendations.
No, but that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
These were authors that were practitioners, and I don't believe they were in a position to create a standard.
In fact, you can't point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites. You can't point to one article, journal, book.
That's correct.
And so because there is no methodology or standard for you to look at, it involves a great deal of your subjective opinion based on your experience treating dog wounds, doesn't it?
With all due respect, Mr. Brennan, I'm not somebody that just came in off the street. I have at least 30 years as a physician, and I use that information in helping me form my opinions about wounds. I've seen all types of wounds.
Okay, so my question,
I want
was
to get up and
because there is
slap
no
him
methodology,
in his face.
because there is no standard.
I don't know why the judge is
comparative
letting him
analysis,
berate her like
you need
this.
to rely almost virtually on your personal experience treating wounds.
No, I believe you're again mischaracterizing it. I'm relying on my personal experience plus what I've learned from these numerous articles.
And so because there is no methodology and standard to compare to, you've introduced the idea that you have used a process known as differential diagnosis.
That's one of the processes used.
And as far as differential diagnosis, what that suggests is when, as a doctor or a person looking at symptoms, you try to rule out other conditions that have
Pause in a
similar
second.
symptoms.
Correct.
Okay. And so you said, although that's traditionally used in a doctor assessing a cause of a patient's symptoms, you're using that in identifying dog bites, this differential diagnosis you speak of, right?
I used it to assist me, yes.
Okay. And so when you're using differential diagnosis, it means that there are many other ways or reasons why the same symptoms can occur.
Not always. Not always. It could mean that there's just one or two other conditions that would
Okay.
resemble this,
Okay.
but it's a process that a responsible physician would go through.
And in this case, you went through differential diagnosis to exclude other causes of these abrasions on Mr. O'Keefe's arm.
I did.
If you had used your training and experience and you were certain to a reasonable degree of medical certainty that these were dog bites, you would not need to go through differential diagnosis.
Oh, that's so incorrect.
Okay.
I'm not perfect. I'm not 100% perfect human being. And so so I have to, as a responsible physician, in every case, go through a differential diagnosis to make sure I'm evaluating and treating the right thing if there's treatment involved.
When you chose to go through differential diagnosis, you recognized that these abrasions could be caused by a lot of different mechanics of injury, didn't you?
I considered that they could have been caused by others, but I went through the process.
Well, you were uncertain, weren't you?
No.
Yet you went through this process of differential diagnosis anyways.
Yes, absolutely.
Okay. And when you did that, you decided that you should focus on car accident.
No, I didn't focus just on car accidents.
Well, what other subjects did you focus on in differential diagnosis other than car accident?
Could these have been self-inflicted?
Babe, 3-minute Zoom warning.
I'm on.
All right, love you.
For instance.
Thanks,
You went
guys.
through that process?
I did.
I didn't see that anywhere in your report
It's in my
whatsoever.
head. I didn't write it down.
Well, aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report in discovery and disclosure?
Yes, but
Okay. Is there anything else in your head that you thought about that you didn't put in the report or tell anybody? So we have car accident, we have suicide, we have dog bite. What else did you think of in your differential diagnosis?
well, I thought, could it possibly be road rash?
Okay. What else did you think?
Oh, I don't remember all the things I thought of at the time, but it wasn't a very large list, but it was a list, and it was a differential diagnosis.
Well, if it was important enough to think about and distinguish and go through differential diagnosis, can't you remember what it was that you thought it could have been the cause other than suicide, road rash,
Okay.
car accident?
Well,
You know what I thought it couldn't be is a taillight shattering and exploding on his arm and causing all those wounds through his layers of clothing. I didn't think it could be that. So I ruled that one out right away.
of course, I mean, there were some things I thought of and immediately ruled out. Were these stab wounds inflicted by someone else? No.
Okay.
So the list, there was a list that I went
Okay.
through in my head. Would it be worth writing down? No, I don't think so.
Well, was there any other significant causes that you went through and vetted through differential diagnosis that you didn't write down?
Not that I remember at this time.
And that's why it helps to write it down. Okay. So one of those causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes,
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
I thought I could clarify the issue of what those wounds were caused by.
So you were learning about information about the case publicly before you got involved in this case,
No.
didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan,
And I want to touch upon this because this comment here, and Emily is absolutely right. And it's funny that you wrote that because I was thinking that exact thing at that moment in time when I saw that comment, because this is the impact of streaming hearings in big high profile cases to the public at large, where there is a large amount of public interest. Like typically, like what's so off-putting to Allison and I is, usually when you're in court and you're fighting a Daubert motion, you don't need to undress the opposing side's expert in a pretrial hearing, because you're just trying to make your arguments. What Brennan is doing here, because of the interest in this case, because so many eyes are on it, because public opinion matters to them, that's why he's treating her as if there's a jury in the box. It's a really strange phenomenon, and it is a direct result of the fact that these pretrial hearings, which never used to be streamed, like all we ever used to watch for decades when they started streaming trials was the trials. Nowadays, which I love that we stream pretrial hearings, because like I was saying before you got on, babe, it's where the real war is fought. But that is your answer. He's being a condescending prick because he's trying to undress her. He's trying to make her look like you can't trust her opinion to us, to the public, to the world, because he understands that this case is one of those cases that has so many eyes of the public on it. It's a weird thing. It's a strange phenomenon, and it's not going away, because he would be acting in a much different manner if there were no cameras in the courtroom, because nobody's going out and paying for the transcript. I mean, maybe a couple LawTube streamers would, but you're not seeing it this way. His demeanor would be completely different if the courtroom didn't have the cameras in it. I guarantee it.
I wasn't following the case at all. I don't even subscribe to the Globe for information about this general region.
You don't have to be defensive about it. I'm just asking you.
Okay.
You knew
Just
enough
clarify.
that you wanted to get involved, and you made some phone calls to offer your services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming what at that point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again, I know that there are very few people in this country that have the combination of experiences that I do. And I thought that I could just clarify the issue and maybe, help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
I knew that a police officer had died. I was a former police officer, so I knew a police officer had died. And I knew that there was a trial, and I didn't know details really. I just knew that I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Had you seen any photographs?
No,
And so just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
correct.
Okay. So when you ruled out motor vehicle accident, is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you considered car accident as not part of the cause of these abrasions?
That was not the only reason.
That was one of the reasons?
Yes,
Did you look at the wounds and you thought based on the accident, there would have been broken bones or other injuries?
that was one of the reasons.
Okay. So based on those two reasons and other reasons, you decided to exclude car accident as the cause of these wounds, correct?
Correct.
And when you made that decision to do that and exclude car accidents, you didn't really have the experience in car accidents to decide whether a car accident was the cause of these injuries, did you?
Mr. Brennan, I've seen thousands of car accident victims through my emergency medicine career. So I had plenty of experience.
Have you ever been trained as an accident reconstructionist?
No, I'm trained as a physician to treat car accident victims.
But that's not what I asked. What I asked you is, you ever been trained as an accident reconstructionist?
No.
Have you ever taken classes and certifications in accident reconstruction?
No,
Have you ever gone to a scene of an accident and been asked to give your opinion and help reconstruct the accident?
no,
Have you ever served as a witness in court as an accident reconstructionist.
No,
In fact, when you decided that this accident couldn't happen, you hadn't even read the investigative reports, had you?
no, I didn't decide that an accident didn't happen.
Mhm.
What I decided was that those injuries
Yep.
were not from a motor vehicle accident.
When you first gave your opinion in this case, she was done.
Hold on, Mr. Lessie. Next question, please.
When you first gave your opinion in this case, excluding car accident, you had not even read the investigative reports in this case, had you?
That's correct.
Yeah. And when you were asked about materials that you reviewed to give your opinions, you said you were just trying to focus on the wounds and you hadn't read those reports, right?
That's correct.
Have you read the reports to
Yes.
date? You now have read the reports.
Yes.
Okay. When you excluded the car accident, did you know anything about this collision between the Lexus and Mr. O'Keefe? Did you know anything about it?
Objection, Your Honor.
Can you answer that question, Dr. Russell?
Did I know anything
Yeah.
about?
Did you know anything about how it happened?
I was, somehow I knew that, well, I believe I knew that the car was backing up. That's what I was, somehow I got that information.
So
The
when
car
you were
backed up.
excluding the collision and this differential diagnosis, did you know how fast that Lexus was going back when it struck Mr. O'Keefe?
No.
Do you know how far it traveled when it hit Mr. O'Keefe?
Objection, Your Honor.
So it's a question, the question's proper. Let's see if she can answer it. She may not be able to answer it as asked.
Do you know how far the Lexus traveled backwards when it hit Mr. O'Keefe?
Your Honor, I'm objecting to the.
I
the assumption.
understand, counsel. Can you answer that question as asked, Dr. Russell?
As asked, no, I don't know.
When you excluded this collision as differential diagnosis, did you know the angle of the collision between the car and Mr. O'Keefe?
I'm
Objection,
going
Your
to
Honor.
see counsel at 7.
Sidebar. Yeah, like that. Allie's on her Zoom. So, yeah, the question, assuming that he was struck, I think is improper. I'm surprised she's allowing it. It's assuming a fact that's not an evidence. It's a theory. Certainly isn't a fact. I mean, that's the entire point. The state needs to prove that beyond a reasonable doubt. I'm surprised that she's allowing the question, frankly, because I mean, it's really what the trial's all about, right? Whether or not John O'Keefe was struck by the vehicle. So for her to allow for him to ask that question, they're going to have to get that one sorted out before this is in front of a jury. That would be an absolutely improper question in front of a jury, where he's stating as if it's a fact, because it's not a fact. It's a fact in dispute. It's what it is. So yeah, it's this is a really, really interesting hearing. But that concept, do you guys know what I'm talking about? Like in terms of his like shithead demeanor, we can blame ourselves. Like if we weren't all watching, if potential jurors were not watching, if the eyes of the world were not on this case for this pretrial hearing, he would not be going at her like this. This is typically limited to trial, like where you're going to attack an expert, so I can tell from our chat, you guys are not going to be loving Brennan during this trial because he's a condescending, snarky son of a bitch. And he's going to be going at all their experts like this. And so I can just imagine what the chat's going to be like during that trial, and look, I get it. Like it's funny from a lawyer's perspective, like reading chats. Like you guys would have hated me when I was cross-examining Cecilia Hoffman, like in the Garcia case. You would have hated me. You would have been like, this guy is the biggest asshole in the entire world. But she was getting on the stand and she was really, he's not doing it for fanfare, CH. You're missing the point. It's not about fanfare. He's trying to sway potential jurors into thinking she ain't worth a shit. That's what he's trying to do. It's not about fanfare. This guy has a job to do, just like every lawyer in that room. I think he's a condescending douchebag too. However, I also understand that he has a job to do. And his job, even though he's a defense attorney by trade, this guy has a job to do, and that's his job is to get a conviction. And part of his ability to be able to get a conviction is to be able to try to keep this evidence out. Because this evidence, I mean, like Dr. Russell's opinion is going to be essentially the same. I mean, sometimes you do have to be a jerk. You just do. Like this is when people's liberty are at stake.
Science.
You know, we're not. This isn't a tea party. It's not a tea party. Sometimes it get like, you know, I mean, you always want civility, but you know, sometimes it gets acrimonious because this is an antagonistic process. I mean, that's what trials are. They are antagonistic processes. That's why we have so many rules about civility.
May I?
Yes.
When you engaged in differential diagnosis, excluding a car collision as the cause of these abrasions, did you know or learn any information about the angle of the strike between the Lexus and Mr. O'Keefe?
No.
And neither do
Do you
you.
know whether or not the person, John O'Keefe, who had these abrasions on his arm, do you know if that person used his arm in any way to defend himself from an oncoming vehicle?
I considered that.
You did?
Yes.
And in considering that, did you consider the body position of John O'Keefe?
Oh, yes. I considered various possibilities.
Okay, what was his body position at the time the car allegedly collided with him?
There you go. Dad.
Use the word allegedly and go with it.
Are you done, babe?
Yeah. They just set a settlement conference.
Oh, good. Yeah, so Judge Bev obviously told him he's got to use allegedly. He can't quit talking as if it's a fact that John O'Keefe was struck. I mean, her answer to this question is simple. There's no bruising, dude. If his arm had been struck by a motor vehicle, there would have been bruising, dude. There's no bruising.
It's
No
just
one gets hit by a 6,000-pound Lexus and doesn't have any bruising on their body. It's been my biggest problem with this case forever. Forever. When I fell down the stairs, when I had like Harry in my arms and I slipped and I was trying to protect the baby, the bruise on my ass was incredible. You remember it? Like I didn't even realize I had the bruise until I was showering, and you're like, oh my God. Like and that was just from my own body weight hitting the stairs and bouncing down on my butt. Imagine getting struck by a 6,000-pound vehicle. Even if it's just your arm and you've pirouetted, that arm is going to be purple, all like just a big purple mass. It's like she needs to say there's no bruising, sir. That's how I ruled out the motor vehicle accident aspect that you're so adamant about.
What was his body position?
I considered several possibilities. I considered if he was standing, if I considered if he was kneeling or sitting or even lying down. I considered multiple
Was
possibilities.
he standing?
I don't know, but I considered all of those possibilities.
Was he kneeling?
I don't know.
Was he
He
lying
wasn't
down?
struck by the
You don't
car.
So
So
you considered all these things, but you have no information, fact, or understanding of what body position he
neither
was.
do you, sir.
Right.
I went through the process of what the wounds would look like in those various positions.
I see. So if John O'Keefe was trying to defend himself, pulling his arm up to brace himself, what would the injuries have looked like?
For what?
Well, if they penetrated his clothing, if
If
there was,
what?
if there was penetration of his clothing.
Uh-huh.
From broken parts, for instance, they would have been quite irregular. There would not have been multiple parallel abrasions and punctate wounds that were seen in those pictures
How do you know that?
from my many years of experience.
Did you do any comparison analysis of the broken tail light in Mr. O'Keefe's arm
Actually, eventually I did.
before you gave these opinions, did you?
I didn't need to because I've seen thousands of accident victims.
Every accident is dynamic and changes, isn't it?
Yes, but I
Every-
also,
Where is the DNA on the taillight pieces
I wanted to like
dug into John O'Keefe's arm? If that's what their theory is, how so the taillight explodes and in a uniform fashion is able to puncture his hoodie and get in there and cause the, I mean, common
But
sense,
none
dude.
still in the
That's how I
skin.
know. I know by common sense that that's not what happened.
I wanted
mean,
to
like,
I almost wanted to rewind what because I heard while I was waiting for the judge, um, Bev say it was a proper question. I don't know if she can answer it as asked. Was it a proper question? Was it I felt so much of his questions were improper.
Well, I agree. I agree. And you know, I mean, the bigger thing is I think that he thinks this is helping him. Anybody who looks at those injuries, because we all use our common sense, and
Well, you can't
that's
say
in jury
anyone.
instructions.
I can't
No
say
one's
any you,
going.
you can't say anyone. We just had a jury who couldn't say it.
Yeah, it's crazy.
Yeah.
This goes to weight, not admissibility.
I also had that in consideration. That's
Every-
why people train for the number of years that I trained.
Every accident is different, isn't it?
Yes, probably.
And so you can have a number of people in an accident and they can have different injuries from the same accident, can't they?
Oh, absolutely.
Right? If a car drives down the street and runs into 20 people, they may all have different injuries.
I agree.
Same car,
I agree.
might be the same speed, but they could hit people differently. Some people, unfortunately, they could kill, right?
Yes,
Some people could be catastrophically injured but still alive.
correct.
Some people could have scratches and bruises.
Correct.
Some people could be in that type of situation, bounce off the car and escape without a scratch.
No.
Possibly, yes.
Right. So there's no science or standard when you say car accidents would have had a certain result. The truth is you don't know.
I disagree with you.
Okay. And so when you were excluding these causes, you have no idea his body position or angle, correct?
I went through various scenarios in my head.
But I'm asking you, not the scenarios in your head, Dr. Russell. I'm asking you about detail, fact, science, okay? I'm asking you, do you have any idea the position of John O'Keefe's body when he allegedly was struck by the car?
Objection, Your Honor.
I'm going to allow
I
it.
considered multiple scenarios.
Tell me the facts you have. Tell me the facts you have. You can tell us how is his body postured on fact. What facts do you have?
Oh my fucking
Again, I
God.
considered
I am
multiple
going
scenarios.
to literally explode.
When
You've got to pause it. What
Your
in
mic is a
God?
little too low.
Oh, good, because I'm fucking screaming.
I
All
like
right,
to
if I-
hear your rants full throat.
If we have it paused, I put the sound back to regular. Someone tell me if it's like I'm blowing out your eardrums because I'm going to turn it back down. Oh Lord. Now I can't even. Like I really want her like the fact that this is a pre-trial. Are you telling me in pre-trial in Massachusetts they do not talk about their objections? Like why should he be allowed? I mean, like, why? I wish she would say, why don't you tell me the facts? What the fuck fact does the state know? They know for a fact he fucking pirouetted and turned and hit his arm and threw it through the air. They don't know any facts.
I agree. Yeah, like, and again, I know there's people that love the whole conspiracy, went into the house, took the beat. If I'm trying this case, I'm putting Rensler and Wolf on and Russell, and that's it. That's like I am making it really easy for the jury where they don't have to buy into a theory that people like to dismiss or people love to get behind. I'm taking that out of the equation because I'm trying to win the case for Karen Reed, and I'm putting on the two experts that are not hired guns by either side, but are independent, who state, who do have the background in biomechanics, that state that John O'Keefe was not struck by a vehicle. And then I'm ending it there. Like, that's it. Like, to me, it's three witnesses on the stand defense, frankly. That's my opinion, and no one's ever changing my mind on it. It's like we saw the result. Like, you're just in my opinion, it is going to be impossible to get 12 people to believe that, as corrupt as Canton is, and we all know that they suck and they're corrupt, but it's going to be very difficult to get 12 people in a jury box to say, okay, yeah, they were planting this shit all around the front yard. It's just, it's really hard to do. It's really, really hard to do. You have
And
to
like,
think about things from a legal perspective when you're watching these cases. This, and I say it all the time, and I see it in our chat, how people, you guys are emotionally invested in this case. Emotion does not matter in the law. It does not matter. How you feel does not matter in the law. So when you take all that shit out of it and you're dealing with just the facts, you put Rensler and Wolf on, who were independent DOJ hired witnesses that went out and did their own testing, created pneumonic cannons, shooting potatoes out of it. That's it. You're trying to win the case for your client. That's what your job is as a defense attorney. If you think that your client is innocent, all that matters is not trying to exonerate her during a trial. Because I got news for you. If they get a not guilty, all the people that think that she hit John O'Keefe are still going to think she hit John O'Keefe. It is not going to sway public opinion one way or another.
no, they're just
Your
going to think
job
he
is to
was
get a not guilty.
wrongfully vindicated, or
Whatever,
whatchamacallit. I
man.
can't think.
It's
Acquitted.
frustrating.
They'll call it a wrongful acquitted.
It's frustrating to me. It just is. Like, I think there's a path, a clear
This
path.
goes in the same vein as the judge just saying you have to say allegedly. And he's asking her, what facts do you know that, they've got plenty of time to give her additional information, to let her review. I saw someone's comment, but did you read the
You're not
actual?
allowed, Amber. That's not the law. Like, we argue it all the time. Like, I remind jurors, I realize it. I'm a human being.
Right,
I
but
am a
she's
very
right. Even
emotional
though they're
human
not
being.
supposed to, they will. We all know that.
We all know that. That's why you have to try to take the emotion out of it. That's my entire point. You're making my point, Amber. When they go into the concept of the conspiracy, the Canton, the cover up, all that as a defense, you're bringing emotion into it. When you can avoid it by simply putting Wolf, Rensler, you have to think of it strategically. Like, realizing exactly what you said, Amber, that we are all human. Like, that's always the biggest thing. That's like what I'm saying about the crime scene photos in the Richard Allen case. What I was saying, like, no defense attorney would ever want those to get out, because that causes the public to come from a place of emotion as opposed to logic and the law. Like, we try to avoid it as defense attorneys because it's the number one weapon that prosecutors use, is emotion, is that they want the people acting in their normal fashion, in terms of we as human beings, we always come from a place of emotion. So, I mean, and the prosecution's always using that tool, and we are always trying to combat it, because emotion is very powerful. Very, very powerful.
I mean, he can't even say like objection, badgering the witness. I mean, I just don't.
I mean, like, that's what I'm saying. This isn't in front of a jury. You know what I mean? It's
Because I
like,
thought she said at some point in Massachusetts, we do not state the basis. Like I thought she said that on one of the last hearings, and I was like, in Massachusetts, that's like a whole rule, and why would that apply pre-trial?
yeah. Yeah, I mean, it's but like I said, I'd really like to have a longer in-depth conversation with you about this concept that I brought out about why he's treating this witness as such, because this is being streamed and because there's millions of people watching this, including everybody in Massachusetts is watching this. Like
Right.
that, this treatment in a pre-trial hearing is like, I'm telling you, like, we've been doing this a long time. I've never seen such an antagonistic treatment of an expert witness in a Dauber hearing. It's
Disrespectful.
not to say
Right.
that you can't. Well, he's disrespecting the shit out of her. It's crazy. In a pretrial hearing, there's no jury in the box, dude. But the jury is watching on TV. There are 12 people that are going to be picked out there. Them finding a jury in this second trial is going to be something else. Man.
Did you go to the scene of where Mr. O'Keefe was found lying on the ground? Did you go
Oh,
and visit the scene?
Jesus.
No,
Did you take and look at photographs of the scene?
I looked at some photographs.
What did you see in those photographs?
No, I want to. So Polly asked a good question. Bob, aren't the jury supposed to consider the entirety of the evidence and use common sense? Yes, they are. So when you do that, the conspiracy is ridiculous and there's no third option. Therefore, she's guilty. I disagree, because what you have here is two sides that were not there when whatever happened to John O'Keefe happened. Okay. You have two theories. And from the defense side of it, they have nothing to prove. Never forget.
Right. That's what Polly's question just reminds everyone how you just cannot convince a juror that the burden always remains on. I mean, Mandy's comment was right under that. Like, no, there doesn't need to be any option, Polly. It just needs to be this option is not beyond a reasonable doubt. They have not even proved to you a car hit them. They don't need to show what actually happened.
Right. And
But-
when and
But that's why I'm always arguing we can't rely on reasonable doubt at
Right.
every single trial.
because it's that same thing as emotion, right? It's like we
Right,
know
that's
that
what
all
Amber was
human
saying.
beings are emotional creatures. We all are. And we also know that people just don't understand. Lay people do not understand that the defense has no goddamn burden to prove anything. We don't even have to put a witness on the stand. We have no obligation to do anything. And that's why my entire point is, as soon as you introduce the third party culprit,
Right.
this
Then-
is what you get. You get
Exactly.
polygraph.
Exactly.
That's what happens.
And
Now
that's
you
why
all
Bob's
know.
saying you don't do it, because you don't want them comparing your two options.
If I could sit down with Yannetti and Jackson for an hour, I'd get them off that shit. Because like they had to do it in the first trial because of their motion to dismiss. You know what I mean? They were already too deep into it.
They might have changed their mind after the trial and seeing how it played out and hearing what people are saying, the mass public.
Yeah, I mean, but these guys are skilled lawyers. Like I just think they're creating a way more difficult case for themselves and for their client by persisting with the whole Canton thing. It's like
I think you can do it in an
police aren't
undertoned
on
way.
trial.
I think
I'm
you can
sorry.
do it in an undertoned way. There's some of it that kind of needs to be done. Like, why the hell are they? I mean, you can't have it not have been, right? Not have been a car and still have all those pieces of her taillight found at the scene without a conspiracy. It's the getting into what the
Do
house
you?
so deep. You can't.
I don't know.
How
if you
can you
do.
have all of those?
You're slipping
tail
into
light
we
there?
have to prove some shit.
But there's tail light there. How do you explain the tail light if you don't touch on a
John O'Keefe
conspiracy?
threw his goddamn rocks glass, which we know he had at the goddamn taillight when she was pulling away. That's how. Simple. That's why they created the pneumatic cannon, the potato cannon. Like, that's it.
Yeah, but they could, that was like a reach for them. Like maybe it could have happened if he threw his rocks. The rocks glass survived.
It's more plausible than his arm caused the tail light to explode.
Or the tail light never exploded and the police planted it. This is a cop. They're
Well,
trying to I think there's a mini part of the conspiracy that you have to put there, because that kind of does go back to what Polly's saying is, I guess that's your answer to the question, is that he threw the rocks glass at the, at the light, and they're unrelated.
is that the tail light broke when she bumped into John's parked vehicle pulling out of the garage.
Well,
but
that I
then
know.
if you
That
do
I got.
If you
Right.
do that, though, then you have to take that step that you're talking about. Because as somebody aptly noted, I forget who it was, if that impact was enough, and that was to me mind-blowing evidence when they focused our vision on the tire moving to prove that her vehicle had struck that vehicle. You saw it. It was the first time it took the debate on whether or not her vehicle struck his vehicle when you saw the tire move. It was game changer for me in terms of was there contact made there, right? So
You
question
could
that becomes is that tail light would fall inward into the hull or the cavity of the tail light. It wouldn't explode outwards. Same concept with it if it hit his arm. So, but if you have that in there in terms of the tail light pieces being in the hull, then that's what I'm saying. It brings us to what you're saying, that you have to put it in a place where they've now spread the fucking tail light in the yard, because it would have been in the cavity of the vehicle of where the tail light housing is. So I don't know.
I think they could do it with a lot less. Like, you don't have to do all the cover up by the people inside. I don't know. There's got to be a way to do less of it, but give it as an option, with just focusing on the the inverted video and two possible options. You've got two possibilities of how the taillight could be there, but it is unrelated to the death. And that is either the cops planted it there, or the taillight did break at that point, and he threw his glass at the taillight. I don't know.
All right, let's
I
keep
don't know.
this.
Were very difficult.
But I digress.
It was very difficult to see much useful information in the photographs.
When you're engaging in differential diagnosis and you're excluding causes of abrasions to Mr. O'Keefe's arm, wouldn't it be important to either go to the scene or look at
No.
clear photographs so you could see all the debris and the land and the
That's someone else's
turf
job,
and see what
buddy.
it looked like? Wouldn't that be important?
No, in the 30 years of or emergency medicine experience I've had, I've never gone to the scene of a car accident victim that was brought into the emergency room.
And you've never gone into court and testified as an accident reconstruction expert.
A reconstruction expert? No,
You've
but I've
never-
testified about vehicle accidents.
And you've never gone to court and
Victims.
testified as a dog bite expert before this case. Yes?
I was never asked.
And so when you say what you used to do, you treated people who came in with injuries. I'm talking about when you're going to exclude something as a cause. I'm asking if you have any experience in actually going out and looking at the facts and using science to exclude something fairly.
I used medical science.
Do you know what the ground looked like where Mr. O'Keefe lay that morning?
There was snow.
You know how many inches of snow were under his body?
Under his body?
Yeah.
No.
Do you know what the ground was? Do you know if it was smooth like a turf football field or frozen jagged like dirt? tends to do in the Northeast during the cold winter?
I considered several different possibilities: grass, dirt, asphalt. So I considered several different possibilities to see in my differential diagnosis.
You considered all these different possibilities, but you never even went and looked at the scene to see what it looked like, did you?
I didn't have to.
Do you know if there was twigs or roots or brush nearby?
I don't know.
Do you know if there was a fire hydrant nearby?
There was a fire hydrant nearby.
Do you know if there was a curb nearby?
That I don't know.
So you have no idea really, other than a fire hydrant, what this area of impact or alleged impact looked like, do you?
Well, again, a curb would not have caused those wounds. So that's irrelevant.
You have no idea.
I disagree.
Okay. Did someone tell you what it looked like?
No.
Okay.
God, I want to slap him in his fucking face.
Like when you slap me in the face all the time.
Yeah, right. That might be fun one day, though.
You said that you ruled out car accident or collision in part because there were no broken bones. Yes?
In part.
And we've
Except
agreed.
for, excuse me, except for no skeletal broken bones.
And we've agreed that car accidents are a dynamic process. Not all car accidents result in broken bones, do they?
That's correct.
It depends on how and where and a number of other factors in the collision. Yes,
Ooh, a
That's why it
fellow
was only
Allison
one of the
spelled the
factors I
same way.
used.
it's one of the factors you excluded. Do you know the difference in force between head-on collision and a side swipe?
I have a general idea.
Is there less force
Idea?
when someone is hit on the side of the car as opposed to being run over?
Is supposed to be run over?
Yeah.
Generally, yes.
And I'm sure in your thousands of treatments, you have treated people in the hospital who have come in contact with a car who did not have broken bones.
Oh, yes.
Plenty of times.
Excuse me?
Many times.
Yes, but they weren't dead.
What's that?
They were not dead.
Right. Okay. Well, you don't know when Mr. O'Keefe died that morning, do you? Do you know what time he died?
I have I have a range.
You didn't think he died from the abrasions on his arm, do you?
No, he did not die from the abrasions.
Okay. He died from a break in the back of his skull from hitting the ground, right?
I think hypothermia.
Oh, he died from a skull fracture and brain injury and
Yes.
hypothermia.
Hypothermia.
Yeah,
Okay.
not from an abrasion to his skull.
Right. The abrasion for his arm had nothing to do with his death, did it?
It did not cause the death.
Okay. And so, is there a difference between the force when a car hits somebody directly on or hits them on a side?
Generally, yes.
Right. And you've seen many times somebody has been in contact with the motor vehicle with no broken bones, many times.
Oh my God.
I have seen that, yes.
I mean, is it
Oh my God, I fucked up. Where was I? Oh, I gotta get live. So like this is driving me nuts. Dr. Russell say there would be a bruise though, dude. Like I want her to use the word bruise. Yeah, there doesn't have to be a broken bone, but you know what there would be, Brennan, is a bruise. His entire like whether he was grazed by a 6,000-pound Lexus or not, there would be a bruise.
You were very
sir.
close to live. Hey,
that's not
I've got
the
a
I asked
question.
you, but I will.
Who the hell is this guy? Is this the actual criminal defense attorney who's special counsel?
Yes.
I
He's-
just his tone is just too much.
It's
And
a
his
lot. Like,
somebody
that's what
said he
I'm
had a
saying.
character voice or cartoon voice. He does. I
Yeah,
hate
he
him.
sounds like he's like Mo. He sounds like Mo from The Simpsons. And he looks like he's a throwback from 1950s. It looks like I'm looking at like Kevin Costner's character in JFK. Like when I see him, like with the with the 50s style glasses with the black plastic and the metal. It's like the dude.
And I would have
That's what I'm saying.
expected Bev to.
People, I never thought I would say this. I never thought I would say this, but people are going to be wishing that we had Lally back. Watch.
And
You heard it
I'm
here first.
I'm surprised the judge is allowing him to treat the witness so disrespectfully. It's a little much.
I am too, frankly. It's like the judge should be chiming in saying, hey, Brennan, calm the fuck down, buddy. Like, this is a pretrial hearing. There's no jury in the box. She should be reminding him
Right.
that I understand what you're trying to do here, sir, and I'm not going to allow you to do it. Ask your questions, quit demeaning the witness, move along.
Right. Stay on freaking topic.
She's not doing it.
We'll invite you to talk about that in a second. Looking forward to that.
No, you
What I'm
wait,
asking
you got to
you-
rewind it. What this asshole's
No,
looking
when
forward
dogs
to.
bite, they can froth at the mouth.
Keep going. Keep going. You
Back?
didn't hear this yet. Yeah.
Okay, how far
Let's
back?
try here.
Yeah, I forgot I paused significantly.
Let me try here.
Try here.
Shards or broken
I
taillight
think-
plastic shards.
You can go forward a little more.
You understand they were found
You can go forward a little more.
in Mr. O'Keefe's sweater,
No.
right?
Doesn't surprise me.
Well, I know it doesn't surprise you, but the
I didn't
question
hear
I'm
that.
asking you is when you decided to engage in differential diagnosis and you decided to exclude collision as the cause of this abrasion,
Okay.
I
I'd
meant
be
back a little
objecting
more, I guess,
to
not forward.
mischaracterization of the evidence. There were no shards found.
Right, but I didn't hear
Like
that
this
yet.
cop- What?
I didn't hear him say that before. I meant you could
Oh,
rewind
back
more.
Yeah.
Yeah.
didn't you want to know all the facts? And
I want to hear all this. Let's see. Yeah, I went on a pretty long rant. It was probably about a 10-minute rant there. So
Let's hear where we're at.
and inside, were there other parts other
Nope,
than just the
we didn't hear
casing, like
this yet.
wires or metal sticking out?
Yes,
Still
How
back?
many pieces?
I
Yeah.
don't know how many.
Did you ever measure?
The characteristic injuries.
Okay, tell me about your experience in Lexus rear taillight.
Of wounds that's on the arm.
You've done advanced studies on wounds related to car accidents and broken taillights.
I've seen thousands.
Have you done any studies?
I-
Do you have any journals that you rely on to say that there's a expected pattern that's going to happen when a taillight intrudes through a sweater and into one's skin?
Yes, there are many textbooks that I have relied on.
Okay.
It's a fundamental area of study in forensic medicine and emergency medicine. And in fact, the examination of the exterior of the body in a motor vehicle accident case is emphasized, and special lectures are given about that topic to the
Y'all think
forensic
you're much further
doctors.
back than this?
You never.
I think so. The last thing I heard her
By
say,
photographs, yes.
he kept
I mean, this-
asking about broken bones, and she said no skeletal broken bones.
in the
I really do talk.
turf and see what it looked like. Wouldn't that
There
be
you go.
important?
Now blip,
No,
now blip, blip.
in the 30 years of or emergency medicine experience I've
You
had,
go-
I've never gone to the scene of a car accident.
Now you can go forward a couple little bloop bloops.
You think? A little
Yeah,
bit-
but do the bloop bloop, not what you're doing.
Okay. Yes, ma'am.
Okay. Did someone tell you what it looked
Okay.
like?
I wish I could bloop.
Do I need to bloop forward?
Now we need to go forward a little bit. Did
Okay.
someone tell you what it looks like? Just click the button and hear where you're at. Hit the arrow button. Here where you're at.
Vision in part because there were no broken bones.
Okay.
Yes.
In part.
It's
And
close
we
enough.
agree-
Except for no skeletal broken bones.
There you go. You did it.
And we've agreed that car accidents are a dynamic process. Not all car accidents result in broken bones, do they?
That's correct.
It depends on how and where and
Good job, babe. Oh no, what happened?
Something that you fucked up, I'm sure, at this point.
I didn't
I'm
do
just
it.
kidding. I'm just teasing. Oof.
Oh my God. What's going on? Why is it frozen? Oh man, I really fucked it this time. Am I
You're
blooping?
Fucking up, babe.
Oh wait, like bloop.
Wow.
All right. Shoot.
it's one of the factors you excluded. Do you know the difference in force between head-on collision and a side swipe?
I have a general idea.
Is there less force
here?
when someone is hit on the side of the car as opposed to being run over?
As opposed to being run over?
Yeah.
Generally, yes.
And I'm sure in your thousands of treatments, you have treated people in the hospital who have come in contact with a car who did not have broken bones?
Oh, yes.
Plenty of times.
Excuse me?
That's what
Many
you wanted her to
times.
say, but
Yes, but they weren't dead.
What's that?
They were
That's-
not dead.
Right. Okay. Well, you don't know when Mr. O'Keefe died that morning, do you? Do you know what time he died?
I have an I have a range.
You didn't think he died from the abrasions on his arm, do you?
No, he did not die from the abrasions.
Okay. He died from a break in the back of his skull from hitting the ground, right?
Oh, he died from a skull fracture and brain injury and
Yes.
hypothermia.
Hypothermia.
Yeah,
Okay.
not from an abrasion to his skull.
Right. The abrasion for his arm had nothing to do with his death, did it?
It did not cause the death.
Okay. And so, is there a difference between the force when a car hits somebody directly on or hits them on the side?
Generally, yes.
Right. And you've seen many times somebody has been in contact with the motor vehicle with no broken bones, many times.
I have seen that, yes.
I mean, there's a difference between being run over and hitting the side of a car, isn't there?
That's correct.
So if someone didn't hit them, they just clipped them, that might be different than being run over in the middle of a crosswalk in the middle of the car. Yes?
Yes, that'd be correct, but you have to put it in context.
Now, you said in addition to your experience treating injuries, you also have experience as a police officer.
Yes,
Yes. And you responded to many car collisions as a police officer, didn't you?
I did.
And when you respond to car collisions, whether it's a pedestrian or another car, there are certain things as a detective you detect that are in the street, right?
wow.
As a detective,
Yeah, a detective or a police officer, as you go to a scene
mhm,
and there's a collision, you certainly see things often as a
yes,
result of the collision, don't you?
yes.
Tell us some of the things that you'll see as a police officer after a collision. What do you see?
Objection.
After a collision, you oftentimes see debris from the car,
Right,
from the
debris from the
vehicles,
car.
yes.
You can see rubber, right?
Probably, I don't know if I have, but yes,
Sometimes metal pieces, parts of the car.
right.
And sometimes when there's
Ooh.
a collision, maybe
Ah.
often, you see glass, don't you?
Yes, you do.
Yeah, glass breaks when a car collides with something, oftentimes, doesn't it?
Yes.
And so when you were doing this, engaging in this differential diagnosis,
Oh,
did you consider the circumstances, the physical evidence at the scene from where Mr. O'Keefe was found?
I considered the possibilities. Yes.
Okay, well, there's a phrase, getting knocked out of one's shoes. You've heard that phrase, right?
I've heard the phrase.
Well, you've heard the phrase in relation to car collisions, haven't you? A person getting knocked out of their shoes.
And other things, yes.
Yeah, but not other things. We're talking about car collisions.
Okay.
That's what
I'm
we want to
gonna
talk about
just,
today.
Okay.
You've heard the phrase knocked out of one's shoes in car collisions, haven't you?
objection.
Yes.
Yes, because the force is so great when a car hits a body, it moves the body, and the shoe from friction on the ground can sometimes be left behind. Yes?
I don't know the actual causation, but yes.
Well, you did know in your review of this case that at the very area where that car backed up and Mr. O'Keefe was found, one of his sneakers was found next to the curb on the street. You know that, don't you?
Well, you do know. Pause
Are
it.
you aware of that?
Pause it.
No.
Okay, next question.
You were never given.
Actually, what I was going to say doesn't help, but I was just going to say you do know that the snowplow pushed everything to the curb, don't you?
Lucky. Good old
But-
lucky.
I don't know if that really helps one way or the other, but Jesus.
Helps with the smashed taillight from the glass.
Well, except that woman reconstructed the hell out of that taillight. I mean, she put all the pieces. Oh, let's see what Wendy said. Thanks for your generosity. Is the Commonwealth allowed to mischaracterize the evidence? I know. I'm like, seriously. Why is Bev allowing him to question her as if she's an accident reconstruction expert or detective? And why isn't Alyssa objecting? I know. Is he just trying to see where her breaking point is? That's part of it. And like Bob said, trying to demean her in the in public because he knows everybody's watching, because it's sure as shit not making a difference as to whether Bev allows her to testify or not.
100%. And beyond that, like I think one of the advantages for attorneys on both sides of the aisle in pretrial hearings is getting your people up on the stand ahead of time, because it gives the defense, like they're probably, they know there's no jury in the box. They should be objecting as to his candor and demeanor. But in terms of the questions, I mean, if you're the defense, you want to hear all the shit that he's going to ask, because
Yeah.
that just allows you to prep for it better. Does that make
Right.
sense, y'all?
It does, and I would still be wanting to object just out of emotion, but you're right. Strategically speaking, let it go. Hear what they're trying to do, hear what they might sneak in at trial, all the
100%.
things.
But I think you can still do that, but object as to his candor.
Well, you can't
and-
tell her
and-
why you're objecting, Bay. There's a problem.
Well,
But I would also use this as a means to decide what I want to file a motion in limine to prevent him from doing to her at trial.
Exactly. Well, and I think you can. I mean, there's no jury in the room. You can certainly, I mean, you make a badgering the witness. He's demeaning her.
You can't say the
consistently.
words. She said
Why?
just say objection, so you can't say badgering the witness.
Okay, well, tough shit. I'm saying it anyway, and I'm
Right, me
planting the
too.
seed with her, and then she's going to have to deal with that.
And
I'd be asking for a sidebar.
Physical.
Sidebar.
Yeah, Your
Right.
Honor, you're gonna
Whatever
let
the case
him
may be.
you're gonna let him ask her questions that have no place in what she did, and like,
Right. Well, you're asking her. She is not a biometric person. She's not an accident reconstruction person. So why are they right? I mean,
these questions are irrelevant.
they're totally irrelevant to her analysis and opinion.
Physical evidence at the scene where Mr. O'Keefe was found to help you engage in this differential diagnosis?
I eventually saw reports.
So you do know. You do know about the sneaker.
I also, well,
What
I
about
don't know that. I don't know where the sneaker was found. No.
Well, what do you know about the sneaker? It sounds like you know a little bit about the sneaker. Tell us
No,
what you-
well, I know that in hypothermia, there's a condition called paradoxical undressing, where people are sometimes are found without their clothes and shoes.
With
Because
material-
and in this case, there was hypothermia.
Do you have any opinion that Mr. O'Keefe undressed his shoe before he died?
I have no opinion about that.
Do you have any information, evidence to support such a comment like that?
I'm just advising you that there is a phenomenon called paradoxical undressing. So that is possibly a cause.
In that phenomenon, does somebody take off one shoe and leave all their other clothes on?
It's possible they
Yeah.
could, yeah.
Right, and you have a case that you've seen
No,
just like that?
I have
No?
not.
No. Okay. And so in this case, at what point did you learn that Mr. O'Keefe was knocked out of his shoe?
I don't know.
Objection, Your Honor.
Phrase it differently.
At what point in this case did you learn
It's not
that
different,
Mr.
Dick.
O'Keefe's body was about 7 feet off the street, fully clothed, not undressing himself, and that his sneaker was on the roadway right next to the curb?
We can object
Objection,
compound
Your Honor.
questions.
Say wait.
So, did you learn that fact?
No.
Next
Fact.
So you sit here and test.
So did you learn that fact?
Ugh,
I need an
killing me.
S, Your Honor. It's compound.
she's killing me. She's killing me this
Ugh.
morning, Judge Bev is. She's fucking killing me. I
Because
don't
you know what? The problem is that then he can use this transcript to ask her if she was asked this stuff before. So that's the other side of this freaking sword, you know?
Yeah. Do you know what cures this for Dr. Russell? Yeah, no, I didn't know he got knocked out of his shoe, but you know what would be apparent on his body if he was knocked out of his shoe, meaning that he
bruise.
was contacted by that vehicle with such force that he flew 7 feet through the air and was knocked out of his goddamn shoe, would be a bruise.
Right. And
There's no
that's
bruising on his body, Brennan.
this is redirect. So, and they might want to save that in their pocket, right? I'd be so tempted
It's
to say it,
fucking
to
driving me
ask it
nuts.
right now,
It's
but you might just want
driving
to
me
put that in your pocket
nuts.
and save it for trial and then say, you were asked on cross about understanding the force someone could be hit with, such force that they're thrown out of their shoe. Can you tell us with such force what corresponding injury you would see on the goddamn body? But a good lawyer puts it in his pocket and saves it for trial. So
Here.
Testified today, you didn't know that?
That's correct.
When you're ruling out car collision in your differential diagnosis, wouldn't it be helpful to know a little bit about the physical evidence of where it was found at the scene?
Again, my focus is injuries. Injuries caused by car accidents, not the scene itself,
Right.
injuries. So, so that's what I focused in.
A dog wouldn't knock somebody out of their shoe, would they?
Excuse me?
A dog wouldn't knock somebody
it one
out
more
of their
time.
shoe, would they?
I don't-
So I'd be like so desperately wanting to ask these kind of questions of their experts at trial during their case in chief, but it would seem so stupid, right? You can't ask the medical examiner. By the way, and I'd try to sneak in just anticipating some of the state's questions on, and then of course, objection, how dare you say such a thing, but whatever. Did you go to the scene before you, I don't know, did the medical examiner go to the scene? It would be very, very unusual, but
What,
like,
for the ME to go to the scene?
yeah,
Mm,
of in this scenario of a car accident,
Right.
of what they think is a car accident, or
I can't remember if the ME came out there. I don't think so.
don't think so.
Okay. When you are excluding car collision as the cause of these abrasions, and you consider circumstantial evidence as a police officer, if there was trace evidence on that shattered taillight, would you want to know about that?
no, asshole.
Yes, I would.
Yes.
Oof.
And
Yeah, but beautiful messy ball. We know that hypothermia was one of the primary causes of death. He didn't die right away. So I think the bruising would have started to happen. But I'm no doctor.
Right. How long does it take for bruising? I mean, it and the freezing process, could that slow down the bruising process?
I mean, medically speaking, I mean, they can typically tell if wounds have been inflicted posthumously or not. I would think that there would be evidence if he was struck anywhere on his body by the vehicle. Because I mean, bruises are broken blood vessels. Like, I mean, there's science behind it. That there's going to be a way for them to determine if blood vessels had been broken, like a massive amount of them. Like, because he didn't die instantly. Like that.
Well,
that we
one
know.
thing I don't recall during the trial hearing the medical examiner say something like, if he was hit by a car, I wouldn't expect to see bruising, or one explanation for the lack of bruising could be that it was so cold and the slow, like I don't remember that being an explanation, except especially since the medical examiner was like, well, kind of would have expected to see some other injuries if he had been struck by the car.
Yeah, it's interesting. Right. Yeah. And Mary P's got a good point. He did have the bruising on his face. Right. So that's interesting.
All right, I got to hop off a sec.
Why? I'll miss you so
Your
much.
daddy.
Oh, I love you. Bye.
DNA is a form of trace evidence, isn't it?
Yes.
It's a pretty sound piece of trace evidence, wouldn't you say?
Yes, if collected properly and chain of evidence, yes.
Right. One of the most formidable pieces of scientific evidence that is used in medicine and science, isn't it?
In forensics, yes.
Yeah, forensics. And so when you used differential diagnosis and excluded the car collision as the cause of the abrasions to John O'Keefe's arm, did you know that there was DNA on the taillight of the defendant's car?
I did not know that.
Would you wanted to have known if there was DNA, particularly would you wanted to have known if the DNA on the taillight of the shattered taillight was John O'Keefe's DNA? Would you want to know that in your differential diagnosis?
That would be helpful. However, again, that the car accident did not cause that configuration of wounds.
And when you're considering the cause of the wounds and you're trying to rule out car accident, you know that that taillight had been shattered, leaving glass and jagged edges. If you had known there was John O'Keefe's DNA on that taillight, would have you wanted to have taken a closer study of the taillight casing and the broken glass?
I don't think it was necessary. Those wounds are so characteristic of a dog attack.
Do you know there was other trace evidence on the back of Miss Reed's car that morning?
Can you be a little bit more specific? And we're talking about touch DNA. Like, was it blood? Was it saliva? I mean, like, it's like, this is a car that is
Touched by people.
no keep all the time. It's like, who gives a shit? Was it bloody? Was it blood DNA? Was it blood? Did they get the DNA from blood that was found on a piece of the taillight? Was it skin? Was it skin from the taillight causing the abrasion?
Such as?
Hair?
No.
You didn't know that one of John O'Keefe's hair was left on the bumper?
No.
And engaging in your differential diagnosis, considering the mechanic of injury, wouldn't it be important to know that the trace
I wish
evidence
she would
coming from
say
John
no
O'Keefe was
again.
left not only on the defendant's car, but in the particular area where the damage to the car, the taillight?
Objection, Your Honor.
Were you aware of that fact, Dr. Russell?
No.
Next question.
When you were excluding a car collision as the cause, did anybody share with you the digital forensics, the black box information showing and demonstrating where the car was, the speed it went back and the distance? Did anybody share that with you?
No.
Did you know that John O'Keefe had a cell phone?
Not surprised.
And do you know that at a certain point when that car left, his cell phone, which was found near his body, never moved? Did you know that?
I read that, yes.
And when you were using differential diagnosis and thinking about the potential causes of the abrasions in the arm, did it seem important to you that all these facts coincided? The car reversed, the damage, John O'Keefe on the ground, the phone under him.
Objection, Your Honor.
I'm going to allow that question.
I want
Consider those
to.
things, Dr. Russell?
As I mentioned earlier, I considered various possibilities of a car accident and a pedestrian accident, I should say. And I went through many scenarios in my head, and no car accident scenario could
Explain the
create that
injuries.
configuration of wounds that's on the arm.
You've done advanced studies on wounds related to car accidents and broken taillights.
I've seen thousands.
Have you done any studies?
I-
Do you have any journals that you rely on to say that there's a expected pattern that's going to happen when a taillight intrudes through a sweater and into one's skin?
Yes, there are many textbooks that I have relied on.
Okay.
It's a fundamental area of study in forensic medicine and emergency medicine. And in fact, the examination of the exterior of the body in a motor vehicle accident case is emphasized, and special lectures are given about that topic to the forensic doctors.
You never examined John O'Keefe's body.
By photographs, yes.
You never examined his body.
Personally, no.
No, personally, you never examined his body.
I never touched the body. I examined
No,
the
no, you
photographs that
didn't.
were taken in the hospital and in the coroner's office, medical examiner's office.
When you're treating at the hospital and people are coming in telling you there was a dog bite, you're relying on that reporter's history, aren't you?
Usually, yes.
Or an eyewitness who saw it and told you about it.
Correct.
When I asked you before, when we were here the last time, about any cases where you had to make a diagnosis without information, you couldn't point to one. I asked you to give me one example, and you couldn't give me an example, could you?
I don't remember patients' names.
And so when you rely on the reporter as a medical expert, you take what they say, right? And you assume it's true.
Oh, not always.
I
No.
see. You
No,
look and see if it's
absolutely
not.
not.
Objection,
What,
Your Honor.
excuse me, One person speaks at a time. Let
Please.
her answer, Mr. Bryan.
No, I don't always take what they say as true because there's many reasons why people do not tell the truth.
Did somebody ever come in and say it was a dog bite and you did differential diagnosis and pattern recognition analysis and determined they were lying, it was not a dog bite?
No,
In all the hundreds, thousands of cases, never has anybody reported to you a dog bite and you determined independently through your powers that it wasn't a dog bite.
not dog bites, but other wounds, gunshot wounds, stab wounds,
Yeah.
many other kinds of wounds. People report that they occur a certain way and actually they have occurred a different way.
With respect to dog bites,
Mhm.
every time you've treated a patient, they've either told you what happened or somebody with them has told you what happened.
Or they didn't know what happened.
Okay. In this case, when you were excluding the collision as the cause of the abrasions on Mr. O'Keefe's arm, did you look at witness statements?
As far as I know, there were no witnesses to the event.
Okay, well, did you read the testimony of Officer Sarif? Because the witness who talked to him was Karen Reed. Did you read that?
Objection, Your Honor.
So ask the question differently, Mr. Bryan.
Okay. Did
Why
you know that
should
Officer Sarif
he
reported
be
that Karen
allowed
Reed
to
said,
ask
"This is
the
all my
question?"
fault. This is my fault. I did this. Did you consider that or know about that when you made your differential diagnosis regarding the collision?
At some point, I did know that there was a statement like that.
Not like that. Did you know about this statement? This is all my fault. This is my fault. I did this. Did you know about this statement?
Objection, Your Honor.
Did you know that statement? I'm allowing a question.
No.
Let's move on.
Did you know
Mr.
about the statement to Mr. Flamati? I hit him. Oh my God, I hit him. Did you know about that statement?
Not that statement, no.
Did you know about the statement that she repeated repeatedly? I hit him. I hit him. Did you know about that?
I learned that there was some question about whether there was a statement or a question, did I hit him? I learned that, but that doesn't, I mean,
Where
okay,
did you learn that from?
I don't remember.
Okay. You said that you had experience in domestic violence.
Well, your
cases.
stupid questions.
Did you know that it's reported that the defendant and Mr. O'Keefe got in an argument shortly before this happened?
Yes, I know that.
When you were considering the cause of these injuries, did you consider Ms. Reed's statements herself to not just witnesses, but to the public, to national magazines and programs? Did you consider any of that?
I don't read the national magazines.
Well, would it help you if you knew she told Boston Magazine that maybe John hit the back of her car, telling her to stop, and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out? Would that help in your differential diagnosis?
Objection, Your Honor.
I'm going to allow that.
It wouldn't help because those wounds were caused by a dog.
Well, if you believe that statement that she said about running over his foot and clipping him, it would help you conclude that it wasn't a straight-on accident, that it was on the side, right?
Objection, Your Honor.
I just noticed that too, like 5 minutes ago. Did you see Mandy made our what do they call this thing? The border down at the bottom. She's got
Techie wizard.
live trial coverage, legal analysis, commentary, and tech wizardry. It's so good.
All right, so
Oh, here.
I just need to comment because although he asked that question about have you heard of this saying, you're blown out of your shoes with social force, blah, blah, blah. What he just laid out is how they're reconciling that. She ran over his foot. So that's how the shoe came off. It wasn't that he was thrown with force. You got to rewind and listen to this question the way he asks it now.
Okay, yeah, I will because I was trying to find this here. This is who Hank sounds like.
When? But you told me you're gonna move
What,
to New York.
not-
Yes. How can you do The Simpsons and live in New York?
Oh, Jesus.
And for the table reads, I'm just.
I had it lined up.
I said it's
Jeez.
an honor, true honor.
You're
to sit-
fucking up again, babe.
Mo, you gave us. Mo, you had a little bit there. Don't get greedy. Larry.
Here it's
I only
Chief
treat you,
Wiggum.
Mo. Okay. All
Here.
right. How about Chief Wiggum? You don't have any legal problems that I should know about, do you? Any legal trouble? How about any donuts? Do you have any donuts?
He's definitely Chief Wiggum. All right, how far do I need to move it back?
Right. I think maybe like,
Couple bloops.
yeah.
Bloop, 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 bloop,
Okay.
bloop.
Okay. You're going crazy.
Read statements herself to not just witnesses, but to
Pay attention now.
the public, to national magazines and programs. Did you consider any of that?
I don't read the national magazines.
Well, would it help you if you knew she told Boston Magazine that maybe John hit the back of her car, telling her to stop, and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out? Would that help in your differential diagnosis?
Objection, Your Honor.
Wait a minute. Ran over
Wouldn't
his
help because
foot.
those wounds were caused by a dog.
Well, if you believe that statement that she said about running over his foot and clipping him, it would help you conclude that it wasn't a straight-on accident, that it was on
You
the
clip
side,
someone
right?
in the knee. That's not like the arm. That's not the
Even
arm
if it were
swinging
on the
away.
side, the car did not cause those injuries.
And we talked about
No.
when someone's hit on the side, they could brace or defend themselves, correct?
Oh, correct.
Right. And did you know that if John O'Keefe was standing up and his arm was bent, it would be about
Objection.
that taillight?
Yes, that I understand. I've been hit on
No,
the side.
we don't
I
understand
know about side injuries.
because
Besides
we
my
don't even know he's hit
Yeah,
by a
clip.
fucking car.
It's different, right? And so knowing that his height matches up with the taillight, what other evidence would you want to know before you excluded the taillight as the cause of the injury? To be thorough, what else would you want to know?
I can see.
Well,
eyeballs.
see pictures of the fragments of the taillight, which I eventually did, and were there any pieces of metal that had the configuration, anything that could cause those parallel lines with the punctate injuries in between?
How about taillight fragments?
Yes.
Little pieces of glass, right? When glass shatters, it
Plastic.
shatters randomly, doesn't it?
It's not
Well, it
glass.
depends on what kind of
Randomly.
glass. So
How about, I'm sorry, please.
it depends on what kind of glass.
I want you. I
Well,
didn't mean
motor
to interrupt
vehicle
you.
glass, a lot of motor vehicle glass is tempered glass, and that shatters a certain way
Okay.
and creates a characteristic injuries.
Okay. Tell me about your experience in Lexus rear taillight coverings. What is the pattern injury on that?
Babe,
I'm
you want a
gonna-
coffee?
I'm not aware of any pattern injuries.
And are you aware when the rear taillight of a Lexus breaks?
Do you want a coffee? I'm going to make a coffee.
I want something to splash in this guy's face. Oh God.
Is that a yes?
I would love some. But babe,
The different pieces.
maybe I should run up first and make you some ice.
I made ice. I put ice.
Oh,
in.
you did? Okay.
Yes, yes.
It breaks into, is it random or is there a standard in how it breaks?
I'm not sure, but I have an idea.
See what happened there, y'all? Allie knew there was no ice. So when she knew I'd make iced coffee, so she knew it was going to result in some Bob bitching later. Like, there's no ice. We
I
use
just knew it would result
we
in
use an ice
disappointment.
maker because I don't trust our water. So we have like a portable ice maker that we use for our ice. Just don't
I just
trust
didn't
it.
want your heart disappointed when you went to get your iced coffee
I
and you opened
know.
it up and then you're like,
So
oh,
So sweet. All right.
I'm sorry?
I'm not sure.
Okay. Did you look at any photographs of the scene in the debris field showing the different size taillight fragments at the very scene where Mr. O'Keefe was found on the ground? Did you look at any of those photographs?
I attempted to, but I couldn't see much detail.
Okay.
Photographs were not good.
Okay, so you don't really have a command of what the debris field looked like relative to the taillight fragments that were on the ground that morning.
Again, I imagine various scenarios of what broken glass and taillight would look like. And again, I could not come up with any scenario that would cause those parallel marks and the pattern that we described.
Well, I don't need you to imagine a scenario. I only want to talk about one scenario. That's the scenario that led to the death of Mr. O'Keefe that morning.
which you
That's
don't
the scenario
know,
I'm asking you about.
asshole.
And the debris field that actually existed that morning. So what
Which
I'm
we
asking you,
also
when you
don't
engage
know,
in differential diagnosis, and you
asshole.
take the position that this couldn't have happened,
Mhm.
I need to understand what you actually know about the physical evidence that's at the scene. So that's what I'm going to ask you about, that scene. If you don't know, it's okay.
Mhm.
But I want to ask you about that scene that morning. Do you know how many pieces of taillight were found on the ground where Mr. O'Keefe was found?
No,
Do you know the shapes and sizes of the shattered parts of the taillight that were found in that debris field where Mr. O'Keefe was found?
I've seen a picture of various safe pieces of taillight. Yes,
And if you've seen that, you would see that there are a number of different pieces of shattered taillight, yes?
correct.
Of different sizes.
Yeah.
Of different shapes,
Uh-huh.
different diameters, right?
Yeah,
Yes,
different
they're
being the key
irregular,
word
very
there,
irregular.
Dick.
Different, irregular.
Yeah.
Irregular. Many of them sharp,
Yes,
Ooh.
perhaps almost all of them.
Ooh.
Yes.
possibly. Yes.
Well, you say possibly because you never actually have looked at the physical evidence. You just looked at a couple of photos.
I looked at photos, correct.
And as far as the housing for the taillight, what is that made out of?
I believe it's made out of a plastic, and there's a metal around it.
It's metal.
Yeah.
What's the shape of the metal around it?
What's the shape?
Yeah, what is it, when you're describing the metal that you saw, what does it look like?
Well, it looked like there was some curves in it.
Curves?
Yeah.
Any straight lines in it?
Yeah.
Any jagged parts of it from the breaking?
Yes.
Okay. And inside, were there other parts other than just the casing, like wires or metal sticking out?
Yes.
How many pieces?
I don't know how many.
Did you ever measure those angles or study the angles of the pieces of metal and the casing?
No.
And you never studied the angles or took measurements of any of the shattered taillight, did you?
No.
Now, sharp objects can cause puncture wounds, can't they?
Yes.
Sharp objects can go through clothes and tear a, no, let me finish, you can answer. Sharp objects can puncture a hole through something like a sweater, can't they?
They can.
And if that object comes back out, it can pull the threads back out with it, couldn't it?
Theoretically, yes.
Yeah. And a sharp object, like glass, can poke or push a hole in a tear in a sweater and then rub up against the skin, causing an abrasion, couldn't it?
And, well, yes. Yes.
And if the glass and the angles and the shattering is irregular, it could cause irregular type abrasions.
Not like that pattern. No.
That's not what I'm asking you. I'm asking you, can irregular glass that penetrates a sweatshirt or a sweater and rubs up against the skin, can it cause irregular looking abrasions?
Yes.
And if there's two pieces of metal or glass that are straight, could it cause a linear abrasion?
Yes.
Would you agree with this statement? In a car accident, linear wounds are most commonly caused by contact with shattered glass from the windows, particularly tempered glass, which breaks into small, sharp shards that can create linear cuts on the skin when the body impacts it during the collision. These are often referred to as dicing injuries in forensic medicine.
Yes. And so they're not really very long linear. They are tiny linear abrasions or lacerations.
Abrasions come in all different sizes.
Right. But the ones that are caused by tempered glass are very, very characteristic.
Does glass cause a slicing pattern?
It can.
And it can cause a linear abrasion.
Yes, but there's a specific pattern with tempered glass.
I understand that you have an opinion.
Oh, no, it's fact.
Okay.
It's in textbooks.
Yeah, it's in textbooks that glass can cause linear abrasions.
The tempered glass pattern is in textbooks.
Glass from this broken taillight could cause linear abrasions.
That probably, yes, I agree.
Okay. So the glass that was in this debris field that you got a little look at, it had sharp edges, some of it, right? Yes?
Probably, yeah, I imagine so. I don't know for sure.
Do you know if it had parallel edges?
Parallel?
Yes.
I don't know.
Okay. Now,
Right.
when you're looking for trace evidence to see if something caused an injury, you look for remnants of that evidence, don't you?
Yes.
In this case, you didn't do any study of the clothes and you didn't do any study of the actual Mr. O'Keefe's body, right?
I did not have hands-on
Okay.
study,
Um,
correct?
But you did learn that there was something remarkable in Mr. O'Keefe's sweater, didn't you?
Can you be more specific?
Yeah, why don't we try that?
Glass shards or broken taillight plastic shards.
It's two different things.
You understand they were found in Mr. O'Keefe's sweater, right?
Doesn't surprise me.
Well, I know it doesn't surprise you, but the question I'm asking you is when you decided to engage in differential diagnosis and you decided to exclude collision as the cause of this abrasion, didn't you want to know all the facts and information in considering whether it was the taillight that caused the abrasion? Didn't you want to know that information?
Yes,
Okay. And when you were considering that information, did you know from the criminalistics reports that shards of that broken taillight were littered in his sweater?
I did not know that
When's the first time you learned of that?
right now.
Right now. And so when you've prepared for this case and you've received materials from the defense, nobody has ever sent you, ever,
And there's why you need
criminalistics
some
reports that
conspiracy.
show taillight shards were in his sweater where the abrasion was. No one ever showed you that?
I don't recall seeing that at all.
Oh, boy. Well, talking about being a detective, using circumstantial evidence and trace evidence, I want you now to consider this new evidence that you didn't know before you testified at the voir dire and the trial in the first Lanigan hearing. I want you to,
Let's hear the question.
What, are you afraid she's going to change her mind? Let her
when you
go.
were ruling out the taillight as the mechanism of injury, when you excluded it in your differential diagnosis, and you said to a reasonable degree of medical certainty that these injuries that you looked at were caused by a dog bite. Now that you know that there's a debris field of shattered taillight right near the body of Mr. O'Keefe, and now that you know in his very sweater where the abrasions, the same arm under them, is littered with shards of taillight from that Lexus, does that in any way change your analysis in your differential diagnosis, excluding the car as the mechanic of injury for that abrasion?
Objection, Your Honor. I'm going to allow that minus the police officer, the detective part.
No, it doesn't change my, my conclusion that those injuries, those abrasions were caused by a dog bite.
How do you think the shards of taillight got into his sweater?
They could have
Objection
got
calls
into
for
the sweater from
speculation.
an accident, correct?
From an impact with the taillight, yes?
Could be.
Right. And when the taillight breaks and there's jagged, irregular, linear, sharp edges from that break, what do you think is going to happen to the skin when those shards impact the skin?
They could cause injury,
They,
yes.
they could cause puncture wounds, couldn't they?
Yes, they could,
They could cause scratches, couldn't they?
but not in that configuration.
I need to ask you the question so you can answer my question.
She
They
just
could cause
did.
scratches, couldn't they?
They could cause scratches.
Mhm. And you have no studies on how abrasion looks after an impact with a taillight that is shattered. You don't have any studies.
Yes,
or
she does.
comparative analysis there, do you?
I have no studies. I just have my years of experience.
You know what wasn't found for trace evidence in that sweater?
Dog DNA.
DNA of a dog.
And that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it, but that's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that. What I'm asking you,
Sorry.
you know when dogs bite, they can froth at the mouth,
Yes,
sweat,
probably.
yeah, saliva,
Saliva, yes.
right? And when they get active and aggressive, it increases the production of those viscous materials, doesn't it?
I believe so.
Yeah. Well, it's in some of those studies and reports and books you've studied all these years, isn't it? That that's exactly what happens?
That they, That they increase their production
Yes.
of saliva? No, I haven't seen that, but
Okay.
it makes sense.
And so when the dog bites a person, if they're biting through material, that saliva naturally could be embedded in the material, couldn't it?
Could be, yes.
Yeah. And something like a sweater, right? It traps liquid, doesn't it? Been out in the rain in the sweater. You don't want to wear a sweater in the rain. You'd be soaking all day, right?
That makes sense,
Yeah.
yes.
There was no dog DNA found anywhere on the holes in that sweater, was there?
No,
You understand that the crime lab took swabs of every one of those holes, right?
I don't know how many holes they took, but
Well,
yes. they-
before you
multiple.
discount or allege a conspiracy about DNA taint, wouldn't you want to know what they did before you criticize them?
I know that they took swabs.
Okay. Do you know that they took swabs of every hole?
No,
Do you know
Was
they
the
then
sweater
packaged
under the
them
snow?
and they tested and they sent them to UC Davis?
I know there was an interval of time
Well,
between the,
people are exonerated.
Hold it, I just need to hear the answer. Next question. please.
People are exonerated decades after they've been wrongfully convicted based on DNA. Yes?
yes,
DNA lasts for a long time sometimes, doesn't it?
it
Well, not when it's
can.
put in
Okay.
water.
And so you know that the DNA or the samples that were swabbed from the sweater was sent to UC Davis. You know that.
Yes,
And you know when they did the analysis, there was no dog DNA,
right,
right, on any of those holes.
right.
And you've opined that these are bites, teeth going in and out of those holes all the way up and down the arm.
Yes,
Now, it is remarkable that there is no dog DNA on any.
Why? I like that. That's one part of this that I've never understood why she's like, to me, and I'm no expert, but those look like scratches. Like I've always said when I saw it,
Yeah, but she's dug in now.
the punctate wounds are one thing. The scratches, like that wouldn't leave saliva. I mean, to me, that's the workaround on that shit.
Right, but I thought, but she's already given an opinion, and I thought, now I don't know, maybe we need Melanie Little. Maybe I should send her a text, but I thought at some point at trial there was a mention of claws. I thought she did
Oh, people
include
have talked
claws as
about
a
claws, but,
possibility,
like, she
but I
hasn't
thought
mentioned them.
she did.
I don't know. Text her. Text Melanie. Melanie's live with this shit, obviously.
Any of those holes
Oh,
in the
yeah.
sweater, isn't it?
again, there's an issue with the collection and transportation of that.
I'd love to talk to you about that. We're going to, but you got to get through my questions first. It is remarkable as a doctor, as a scientist, that there is no dog DNA in any of those swabs. Are you sure? Are you
Remarkable would not be the word I use.
extraordinary?
No.
No.
I disagree.
Hard to believe.
I disagree.
Enough.
Okay.
Oh, look at that.
Now,
God, I hate
there
her.
is no dog DNA. Do you think
She was
somehow
loving
that
that
hurts
first. It
your
looked like
cause
she
or your
was
case
loving
for your
that.
opinion?
Objection, Your Honor.
Sustained.
Do you think that in somehow
Maybe she was hating it.
challenges your opinion that there's no dog DNA?
No.
Because many times you've interrupted and tried to talk about a suggested or a supposed taint that doesn't exist. And I'm just curious, why is it so important for you to discount dog? Why is it so important for you to discount the fact that dog DNA does not exist on any of those holes?
Objection, Your Honor.
I'm going along.
I'm going to
I'm
allow it.
aware of the many of the steps that are involved in the collection, preservation, transportation of evidence. And there are multiple places where that can go wrong. So the absence of the evidence is not as remarkable as the presence of the evidence.
What training and experience do you have with regard to DNA evidence? Your answer, not very much. Does that still stand today?
Correct. I've had lectures, but I'm not a DNA person.
Not very much, right? And so now you're suggesting, without any fact, that many things could have gone wrong.
Absolutely, with any specimen.
Right. So you're willing to come into court and just float an idea without a good faith basis of fact?
Objection, Your Honor.
Sustained.
It
What
was
went
in the
wrong in
snow
collection of this
out
DNA?
in the
What went wrong in it?
for
I can't
hours.
tell you what went wrong, but I can tell you that there were possibilities that there were errors at various steps.
Okay, well, if you want to claim and allege an error to demean or discount the evidence, tell us what the error was that happened with the production, the preservation and testing of this DNA. What was it?
I can't tell you the exact error, but there's, first of all, the decedent was in the snow
No,
for a while.
thank you.
So it may have washed off some of the evidence.
What evidence do you have that it washed off?
I don't
evidence?
have any proof, but I'm just, you
What
asked me
evidence do you have
possibilities.
that
I didn't ask you possibility. You're raising possibilities. I'm asking you what evidence, what fact do you have that DNA was degraded or taken from that sweater because
Pause it
he was
real
lying
quick.
in the snow?
It's
What evidence do
snow.
you have?
That's
Don't
the
have evidence.
No.
I'm considering different
Pause it a
possibilities.
sec.
What about the
Pause it a
preservation
sec.
of it? What evidence do you have before you make such a claim?
Don't make me yell at you, man.
Well, your mic's super low. I can barely
Oh, I
hear you.
forgot that I turned it low. Yeah, so that I wasn't
I don't
yelling.
mind. I don't think you're being mean to me when you yell at me.
Is there a sound for that?
I mean, the shit.
um,
Is Mandy on it now? Now Mandy's on it.
I was like, "Are you yelling at me now, Bob?" Well, now I can't say anything. Thanks, Mandy. All right, let me get my gosh. But this also helps them to know what to bring out on, their DNA experts going to be cross-examined before she takes the stand. So they'll be able to go through all of the possible things and put them into at least what she said here about the snow and about the collection. And, there's many things that can go wrong, right? So they don't need, the defense, don't need to rebut what this cross-examination with this witness directly. They can use all of these things. And again, this goes back to why you just kind of have to sit on your hands and bite your lip and let them ask whatever the hell they want, because it's going in your, I wanted to say vault, but not vault. I don't know. What's a word for it?
Rolodex.
I guess
Rolodex of
Rolodex.
information of what they're going to ask her at
Yeah,
trial.
your circular file.
Circular file is garbage.
Yeah, right. So that doesn't work. But yeah, it's all stuff that you can use with other witnesses and you can rebut in other ways, and you can start laying the foundation throughout the trial so that when he tries to hit these high points and his stupid little tone and his stupid little giggles, for example, but again, at the same time, it would sound stupid if you asked some of the questions that he asked. But this type of thing here, they will be able to sort of rebut just by the way that they question the state's DNA expert.
Well, as an aside and as an observation, I mean, she testified. It's pretty clear to me that in the interim, that Yannetti and Jackson have not prepped her any further.
Yeah,
than
which
when she
has to
testified.
happen before trial.
Right. I
Has
mean,
to happen.
like if there's a takeaway from Yannetti and Jackson and Elise, they need to understand they need to prep her better
Mhm.
because she's got to have quick responses to these queries at trial. Like she
Right.
can't sit there because again, we're talking about, and you guys have made the point in the chat, you're not lawyers, you're lay people, and so are the jurors. And I'm just telling you, a lot of this will be very effective with jurors. Tone aside, snark aside, shitty demeanor aside, the points that he's making are going to score points with the jurors in terms of like, you can't, like, this laundry list of shit that she did not look at in terms of coming to her evaluation. They've got to coach her up on how to answer that question.
I was going to say the same thing. Couple of key
Right.
phrases. That's irrelevant to my examination.
Right. That's like that. None of
That's
like all of that is super interesting, but it has nothing to do with what I was evaluating.
And I was also thinking of something that they need to coach her on. If he tries to bring up her answers in this, I think one of her responses could be, in all due respect, sir, your questions were bordering inane. I was feeling harassed and disrespected. And at some points, I just, answered quickly because
I would have coached her up to say, well, sir, with all due respect,
you're a dick.
all those questions that you're asking sound like that's your job. You have the burden of proof. All they're asking me is if those injuries were caused by a dog, and in my opinion, they were. End of conversation. That's what I'd be saying. So
Right.
but they're going to have to coach her up. And the one thing when we were watching, I forget where we were heading, but like we didn't cover the first day of this, but you and I listened to it. I think we were traveling.
Oh, yeah, we
Road-
planned on actually covering it before
we
this
were,
thing
we
began.
did, we did.
Oh, we
And
did.
like kind of no, we didn't cover it, but
Oh, we
we were
didn't.
going to, because we listened to it at like 2.5 speed. We were on a road trip somewhere. I don't remember where we were driving to, but we both kind of landed on
Concert in the city.
this opinion that the way that it appears in terms of Dr. Russell is that, like, I think if I'm Brennan, I'm making the argument that you can give whatever weight to her testimony that you want, ladies and gentlemen of the jury, but I would suggest to you that maybe they put her on the stand knowing what the warts are with the testimony, because there's nobody else out there on the planet that's willing to get on the stand in this courtroom and say that those injuries were caused by a dog. I mean, if I'm Brennan,
Well, but they don't know that. That would be that he couldn't say that shit. He could not
What?
say that
an
shit.
argument
Argue that there's not another person on the planet who would have
in
had her same
closing,
opinion. No, I think that would be improper. I think
you
that
could
would
argue
be,
it.
I don't know. That would be
I don't know.
improper.
How could it be? Can you
He could
disprove
say,
it?
ask why they would choose this expert, but I
Yeah,
don't think
DB, she is qualified, but she's not a dog bite expert per se. She's incredibly qualified. She's her CV is impeccable. She's done everything from law enforcement to doctoring. She's done it all. She's an amazing human being. Don't be argumentative just to be argumentative, DB. It's a bad look sometimes.
well, she
You know what I mean?
how is that?
Yeah, he likes to come at me. But
Oh. See,
I'm a DB expert. That's what I am.
I gotcha.
The contrarian. So, but you're missing my bigger point. I'm just telling you that she's got some issues on the stand, no matter how learned she is. Like we all love Dr. Russell. She's like, I feel like going in there and defending her and punching Brennan right in the nose because I don't like the way that he's treating her. That being said, from the legal perspective, Brennan's going to be able to pick her apart. She's got to be prepped better, is the bottom line. The lawyers have to prep her better.
And while you were making your coffee, babe, the questions about him having tail light under his sweater, okay? And I understand your point that they could just rest on two separate things happened, but is part of the reason why some form of the conspiracy needs to be there. I think you make it much less about what happened inside. You don't have to figure it out. You don't have to figure out how he got inside, who saw him inside, who didn't see him inside. Like, you don't have to ask anything about that. You know what I mean? You just need to establish. I mean, it could have been the goddamn neighbor's dog. You know what I mean? Like, it doesn't need to be. And the beating up in the house, like that part, I'd be done, gone, not doing. You know what I mean? I'd be laying it on but I do think there needs to be some conspiracy. And I think a conspiracy limited to a police cover up or a police attempt to just, they believe she did it. Like we've been saying before, they believe it was her. They want the person who they believe killed their fellow officer convicted. So they're adding to the evidence. as the conspiracy, but leave out somebody punched someone in the house, someone did this in the house, the whole people in the house are lying. She's Googling, well, I don't know whether you'd leave in she's Googling, how long it takes to long it takes to die in the cold. I think we'd need to see a little bit more, if they're able to pinpoint that better or to overcome some of the things. I think, but I do think that
Yeah,
there
no,
needs
I
to
hear
be
what you're
some
saying.
version of the conspiracy that I think it needs to back away from all of the people so much.
See, I always love the concept of lucky. Like, to me, like
Yes.
the easiest way to explain how the tail light, if in
No.
fact, for whatever reason it was on that road, is that when he came through with that blade down, that it like tail light would have been flying all over the place. That's why I love
But it
that's why
has to
I
be
love
her
the
tail light.
concept of the glass, the tumbler, the rocks glass being thrown at the tail light. Like, to me, it makes the most sense. I mean, that, like, if you and I were in beef, right? And you're like, I don't know why the fuck you need to go to this party. It's fucking 1 a.m. We're done. The kids are home. What are you doing? And I'm like, oh, fuck off. I'm going in. I'm having a good time. And you're like, okay, dickhead. And you peel off and you're pissed off and you ram it into reverse because you're taking off.
I don't even
And
know if
I'm
that
like,
happened.
oh, fuck you. And I whip the glass at the back of the tail. To me, like these are like Boston cop guys, like it is not implausible to think that a drunken John O'Keefe would have whipped his rocks glass, which he had. He
Right.
had glass.
And to tell you the truth, I was kind of thinking, oh, I don't know about this, but the more you say it, the more it explains why she's thinking maybe she did something. You know what I mean?
For
Because of
sure.
all the things that happened, all the things that happened that night.
Right. Because it explains if she thinks that she heard a noise or a bump or something, that would explain that glass hitting the taillight would 100% explain that. Because the one thing that's clear, and we could just base this on Karen's, like, her poor decisions to do interviews on Dateline and shit publicly, and say certain things that she has to deal with, where she says things that, don't help her case, is that Karen doesn't really know what happened that night. And that's not an indictment on her. Karen, they were drinking. Everyone was drinking. It started with day drinking and it bled into the, the early morning hours. So, like, let's not pretend like everybody wasn't hammered that night, because everybody was. Like, we've been there. Back in my drinking days, I was there plenty of times, So, and if we're being honest, she doesn't know what happened, So she was being honest in those interviews, I think. And that concept of John O'Keefe whipping that glass at that tail light, not even intentionally, just throwing the glass, and he just happens to hit the tail light, whipping it.
Well, that's true,
Like, it
Lamont.
explains an awful lot to me. Like, to me, like that, like those are the arguments. And then we've got Lucky. You put old Lucky, everybody loved Lucky, completely credible guy, sweet old guy, plow guy, been doing it for decades, getting on the stand. And he's like, yeah, I had the blade down. And if you live in an area that has
But
snow,
that's still her taillight. There, I went through every piece. I compared the pieces that were in the snow with the pieces that woman put together better than Lolly did in trial. And those pieces that she recreated were at least, I saw a large part of them in the snow and being recovered on that evening. Although, yes, as Lamont James said, there is also taillight that wasn't her taillight, and there's glass that was related to nothing, and that's all explainable by the snowplow pushing everything into the middle. I mean, to the
well,
side.
I'm not suggesting that it's the broken shards of the bar glass. I'm suggesting that, because remember, like, we don't, if that's the scenario, we don't have to have the contact made between the Lexus in John O'Keefe's parked vehicle that happens after the fact, we don't have to have that breaking the taillight then.
But
Because
I think two explanations. You
I
give
think
them
right. Like I'm saying that both of those things could have happened, because I think it's a harder argument that the speed in which she was backing up, coming out of the garage, which was very slow, that like, I think Rensselaer or Wolf was asked the question, and they couldn't opine that they thought that at that speed that the taillight would have broken. I think that handles the issue. You know what I'm saying? Because I think Rensselaer or Wolf, one of them said, well, at that speed and that she was in what she was backing up out of the garage, when it appears that she made contact with John O'Keefe's parked vehicle, I don't know that speed was fast enough for that taillight to have been shattered. Right. So again, you've got it where the taillight is already shattered from the glass being thrown at it earlier in the evening. And then you've just got this situation where the taillight would have been, because it's like when you look at that, like when we've all looked at the photographs and the video of her leaving the condo or the townhouse, and to me it does appear, it looks brighter. It looks like as if there had been damage done to that taillight. I'm just trying to create reasonable doubt here. You know what I'm saying? I'm not trying to exonerate Karen Reed, because as I've said,
and you're right.
Once, and I'll say it a million times, the people that think that she hit John O'Keefe are forever, for the rest of their lives. It doesn't matter what the jury comes back with, whether they come back with a not guilty, they are going to think that she hit John O'Keefe.
Wrongful acquittal.
Yeah. So, I mean, it's interesting. So I don't know, but I hear what you're saying with, but to me, Lucky can explain like that snow being thrown, some of it lands on John, it can explain why there's tiny fragments found in his shit. I mean,
Right. I think that you're right. That's the cleanest way to explain two completely different events. One that shatters the light and does not where his body does not come in contact with it. And most lawyers or, um, lawyers that do
I disagree,
commentary.
Richard. I don't think that the video shows that her taillight was intact. I just don't. I've got the same eyes. In my
It's
opinion,
unclear. Yeah. There's
it's
snow on it.
not clear, and frankly, but there's so many factors involved. In terms of lighting and angles and all those things, it appears to me that there is a brighter whitish light coming from the side that ended up having the damage when she's backing out. And I don't know how many times Allie and I looked at that video. You know what I mean? Like, I really don't. No, my LASIK is toast, but when I have my readers on, I see pretty clear. So I mean, that's just my opinion. That's my opinion. But again, I'm kind of fleshing it out for y'all. I think that the thrown glass by a pissed off John O'Keefe after they've been bitching at one another in the vehicle because he's decided to go into the party is a plausible explanation. It really is. So, I mean, that, like, Allie and I, if we were trying this case, we would really be thinking about all these possibilities. That's why I love trials.
And the downside to giving them two options and then it being the same thing. We're like, well, neither of the defense options really work, so I'm just gonna say guilty. That's why commentaries are like just the defense needs to pick a lane and not give out multiple possibilities, where I sometimes think you can do multiple possibilities and tell them, and if you're trying to think of another possibility, or if you're thinking another possibility, any possibility that you come up with is what we call reasonable doubt.
That's it. And that's all. Remember, kids, we don't have to, as defense attorneys, prove a goddamn thing. All right, let's watch this.
Right. Lamam's right.
There was an irregularity or
pause it
anything.
real
What
quick.
evidence do you have
That was
something about?
That cop was bombshell. That cop was bombshell. I think he said it was cracked, not shattered. And I forget when the when the tapping happened, I'm assuming it was before the cop saw it, the tire moving thingamajig. Right. So that was, bombshell. So
Yeah, I mean, there's so much testimony of people that saw that vehicle after the fact that's conflicting though. I mean, it was bombshell because was it the Dighton cop or was it the tow truck driver?
I think it
I
was
think
both, but definitely the Dighton cop.
because I mean, tow truck drivers, if you've ever had to have your vehicle towed, they're always worried about liability. So they'll always take a
But it was
gander at the vehicle.
snowing, and I remember you saying that while the trial was going on. Like, he had to look. Weren't they asking it, you know what I mean? And we didn't really get that kind of information from him, so I think it's because it doesn't, exist, but also the state didn't ask it either, so it could be a matter of don't ask what you don't know for both sides.
Yeah, right. All right, let's keep rolling.
The accumulation of this evidence, this
1.25.
item that was tainted.
I didn't say, or I didn't mean to say that there was a definite error in the process. I'm telling you that there could be. So that's why a negative finding is not all that remarkable.
When we're in a courtroom, as an expert witness and as a doctor, you can't speculate. That's not a reasonable degree of medical certainty, is it?
I'm telling you, with a process, just like when blood is drawn from a patient, for instance.
This is coming from somebody who says they don't know very much about DNA. You're floating an idea that you have no factual basis for.
I'm talking about a specimen in general.
I'm not
Not
talking about-
not specific. It doesn't have to be DNA specimens. Specimens in general there can be errors in the process.
But we're talking about DNA here because you brought it up last hearing. You suggested that there was an irregularity at the last hearing.
There could be. You asked, for an explanation why DNA was not found. Well, that's a possibility.
So when you're using words like something could
Pause
have
it a
gone wrong,
second.
you're not suggesting in good faith and in fact.
See, he's doing one of those things where you guys can, I'm sure, imagine how many times there is a lack of DNA. I think there's even a jury instruction that says the lack of DNA doesn't mean, the lack of DNA doesn't mean whatever. It's similar to when we have sexual assault cases. I guess I should have said SA, but and they say that the lack of any sort of semen or injury or that proves nothing. And the defense is going to be able, with their DNA person, to lay that down as like, it is a firmly held principle that the prosecution will sometimes put you on the stand just to explain to a jury that the lack of DNA evidence does not mean anything, that happens sometimes because of X, because of Y. And they call that the CSI effect, right? And you guys are combating that in your field and so that's where I was talking about be able to kind of combat some of this with the state. The defense would be able to combat some of this with the state's own experts.
Yeah,
And-
and they are not putting what's his fuck back on there, Trooper Paul. Like they've
I'd
retained,
freaking call him. Or
they have retained an actual expert at this point. And Joe,
I'd make
I'm
sure that
certainly-
expert was reading his testimony. I'd give him the chance. I need you to read this guy's testimony. I need you to do,
Yeah, and I don't know in mass if they're able to depose witnesses ahead of time. I have a sneaking suspicion it seems like they're not.
I think because there hasn't been any.
Like I haven't heard about any kind of like there was no impeaching on depths during the first trial, which if you have the opportunity to depose witnesses prior to trial, you're going to be impeaching them on inconsistencies made between the two times that they testified under oath. Joe, I am with you. Like again,
Yeah.
ladies and gentlemen in this chat, like no matter which way you fall on this case, you need to understand that lawyers have a job to do. This is not a congeniality contest. They don't give a shit. We do not give a shit if you guys like us personally based on the way we're acting in court. We have a job to do. And this guy is asking questions that I'm telling you are going to resonate with the jury. They are going to have to be addressed by Yannetti and Jackson with their witness. If they're going to put her on the stand at trial, if Bev's going to allow it, then they have to prep her.
Right. And
Like,
he's also
so you
asking some
understand
inane
that. It's like, as
questions.
much as you love Dr. Russell, I get it. Like we all do. Like I've said this 3 times now. The reality is he's asking pointed questions, scientific questions, which are creating an issue with the witness. And that's what you're like, that is our job. Like part of why we hire experts as defense attorneys is so that they can give us, they can give us some educational background of an area that we are not experts in, so that we are better prepared to cross-examine their experts. And this is one of those types of situations. So they're going to have somebody that's going to more effectively challenge Dr. Russell than Trooper Paul did with his whole theory. Like, I mean, they're going to be putting somebody on the stand that is highly qualified on the second trial. So you have to think about all these things when you are planning your attack at trial. Like you this is not a thing that takes place in a vacuum. You really like, his voice may be annoying. That does not matter.
All right.
Like,
Play it at 1.25.
I don't know. I think that it does, DB, if it's a really, really close case. I really do. Like if it, and this is a very close case in terms of,
I think the
go either
likability
way.
factor's
Like this,
there. Yeah.
you know, likability factor definitely comes into play, you know, but will likability outweigh points that were made during a cross-examination? I don't know. You know, it's hard to know. And it's like, that's the fascinating thing about trials, is that every jury's different. Every human being that sits in that jury box is different. There's no way that you can know how 12 individuals are going to perceive something, what they're going to decide matters to them in terms of applying the law and the facts that were put in front of them. You just can't know. That's
All
like,
right. 1.25. Let's go.
huh?
I think you got to put this at 1.25. We're really behind.
Why you got a hot date? Oh, you got to take my dad to the
Yeah,
thing.
but still, I mean,
All right.
none of
Yeah.
that's
125. You want me to go?
yeah, at least.
Okay.
Fact that you believe something went wrong, are you?
Objection, Your Honor.
I'm going to allow it. Are you suggesting that, Dr. Russell?
I'm suggesting there's a possibility that something could have gone wrong.
But you can't tell us what that was.
No, there are multiple steps.
Tell me one of the steps that went wrong. Tell me
She
anything.
said the
I
snow.
can't tell you definitively that anything went wrong on a particular step. I'm telling you that there are multiple steps where error can occur.
Not
That's
the-
all. So, and any physician, even not only scientist, but physician knows that not all test results are 100% accurate.
All right, let's wrap this up. So
Okay.
you've been through the UC Davis report.
Yes.
You've been through the now you know there's a criminologist report and they swabbed all the holes, right? There was an absence of dog DNA. We agree about that, right?
That's what you tell me.
Right. And we also agree that you have no actual science, medicine, or fact to suggest that there was anything wrong whatsoever with the collection, preservation, and testing of this dog DNA.
I have no evidence. That's correct.
She did say the snow. Why doesn't she say that again? Deterioration.
I
I hope they use restraint and save it for trial.
Questions about the photographs and about some of the statements you've made prior about those.
Okay.
Okay. Have exhibit 5, please. You've seen this exhibit before.
Yes.
You've testified about it a number of times.
Yes.
And
Yeah, and I'm sorry to keep pausing, but this is interesting. Like, this is why we do this. Like, if you just wanted to watch it on Court TV, go watch it on Court TV. Like we like to have a discussion. So I agree. Jen was an awful witness for the state. She was not likable, but let's not forget that despite all that, despite Proctor being the biggest piece of shit you could ever put on the stand, this thing was a mistrial. And if we're to
Some people
believe
said guilty.
right, if we're to believe what we've heard, a majority were leaning guilty or had come back guilty. So like likability is not that important. What matters is facts. Like I said, but DB made a great point. Like in terms of your ability to be able to get your point across as an attorney in a likable fashion, I think is always going to be preferable
And important.
to being a dickhead. Like, there's no question about that. Like, it's like sometimes, and like a perfect example was the situation with Cecilia Hoffman. Like I didn't know whether or not to go at her hard as hell because she was coming in saying some incredibly damning shit and like
Changing
trying
the
to break her
story.
on the stand, or to realize, all right, she's going to come off as credible because she's owning her warts on the state. You know what I mean? It's hard to know as a defense attorney or just as a lawyer in general how to treat certain witnesses. If you've got the ability to remain likable in terms of your persona, you do it. But sometimes you're going to have to come at witnesses hard, especially if what they're bringing is very damaging to your case, no matter which side you're on. So, but like the likability in terms of witnesses, because like, I guess the question becomes, does likability outweigh credibility? Like, are you going to, just because you like a person on the stand, they seem like a nice person, does that outweigh whether or not, or does that affect your opinion on whether or not that person is credible? Like, I mean, I've seen witnesses that are absolute jagoffs that I found super credible because they knew their shit. I mean, so it's all fascinating. It's why we all love to watch trials. You know what I mean? All right, they're about to get into the wounds here.
And you understand this is a photograph of Mr. John O'Keefe's right arm?
Yes.
You've described different abrasions on that arm on different dates in court, haven't you?
Yes.
I want to start from the left to the right. And although we haven't used numbers, I'm going to characterize it as a number so we know which wound we're talking about, so that we can discuss the different statements you've made about each wound. The wound closest to the shoulder, you see that wound?
Yes.
I'm going to call that wound number 1, if you don't mind.
Okay.
When you look at the wound closest to the shoulder, is it fair to say that you've given different versions or statements about what you think was the cause of that abrasion?
Not that I'm aware of.
Remember testifying in the voir dire in this case when you first came in before the trial?
Yes.
And you described that that is a pattern, saying there are 2 wounds with potentially a scratch in the middle?
Yes.
Okay. And do you remember saying in that voir dire that they were consistent with teeth marks?
With teeth marks?
Yes.
I believe I do.
And do you remember when you first testified in this case at the voir dire, you said they could also possibly be consistent with nail marks?
Paw marks.
Yes.
Okay. So when you were looking at this, and isn't this an example of no methodology in dog bite science? Because when you're looking at that, there's a very big difference between what teeth would have caused and what nails would have caused, isn't there?
No.
No. Teeth on a wound start with a puncture and then pull down, or the bottom teeth puncture and then pull up. Is that fair to say?
Not always.
And a nail, a dog's nail shaped kind of like a horseshoe, right? The nail. And so when it pulls, it's going to leave a very
Horseshoe.
different pattern than a tooth, isn't it?
Not necessarily. It depends on how deep the contact is between the nail or the tooth and the skin.
Suffice to say, when you first testified under oath about wound number 1, you expressed uncertainty whether it was teeth or whether it was nails.
Yes.
And so you didn't have any standard criteria to look at the wound to try to match up a comparative analysis. There's nothing specific where you would have a standard where you would say, well, this is what I would need to determine it's a nail, and this is what I need to determine it's a tooth. You didn't have that, did you?
There is none. And in the literature, authors have mentioned that it's very difficult to tell the difference between a claw wound and tooth mark sometimes.
When we look at wound number 1, when you originally said it was either teeth or nails, you then testified at trial, and you said the same consistent thing at trial, that this could either be teeth or it could be nails.
Would you repeat that?
Sure. After the voir dire, when you said that this wound, number 1, could have been caused by a dog's teeth or a dog's nails, you then testified a few days later at trial. And you said the same thing, didn't you? That this wound could have been caused by teeth or nails.
May I look?
You don't remember?
It sounds right.
Okay. Well, I want you to look and be sure. It is trial transcript, page 20, line 3.
Is that scabbing already? At the end there. See it, babe?
What, baby?
Is that scabbing already?
Yeah, it does look like it's happening, especially like that one down there, the one, the larger one. That looks like it's almost completely scabbed over.
Page 20. Line 3. Yeah, right there. Okay. Dr. Russell, do you have the same transcript as us?
Yes.
Okay. When you were talking about the number of patterns, you started with the upper part of the arm. You talked about the parallel lines, and you said they were inflicted by either teeth or claw marks.
Line 3?
Well, start at line 3. Teeth or claw marks is actually line 5.
Line 5 says the word photographs here.
Okay. You must have a different version of this.
Are you talking about the trial?
Nope.
I am. So you have a
Prelim.
different copy than we do. My apology.
20, line 3?
I'm going to have to show my copy only because there's different versions of the transcript going around.
All right,
It's not going to
so
reconcile.
what I have that Mr. McDermott copied on the trial transcript is what you just read from page 20, starting at line 3.
And that's what we have, but it's not the copy that Dr. Russell.
Oh, Lally spoke. We miss Lally. Lupin.
No, I don't think I said that.
Oh, you did on the last case, that between the time of the trial and between your testimony at the first hearing and this Lanigan hearing, you had not reviewed any further materials.
No, I don't think I said that.
Oh, you did review further materials,
In the process of writing my report,
which Mr. Lisi helped you with, yes?
Objection, Your Honor.
Wow.
in the process of writing my report, I did review articles. I
See, that shitty little comment right there is completely unnecessary. Like, there's no jury in the box, dude. Give it a rest. Calm down. Calm down. We all know how when you tell somebody to calm down actually affects that person, makes them become less calm because everyone hates being told to calm down.
reviewed the photographs, and my opinion even became a little clearer.
So when you testified in front of the first jury, expressing an expert opinion, you weren't very clear?
No, I was certain that these were either teeth or claw marks.
Okay. But things have evolved, haven't they?
Yes, I have in the course of reviewing and also being challenged. You know, I'm being challenged. I need to review everything. Yes, things have evolved.
So things have changed.
Changed? No, it's
Well,
one of the. I said teeth or claw marks.
well, it's not one or the other. You're supposed to testify with specificity.
Again, in the articles, in the literature, medical peer review literature, it's mentioned that it's very difficult in some sets of marks to determine what's a claw mark and what's a tooth mark.
So based on your reading of literature that tells you it's very difficult to distinguish, you nevertheless then come into the hearing and you change your testimony and distinguish, because what you said now at the last hearing is this wasn't claw marks. Your position now is that these were teeth marks, not claw marks.
I also mentioned that I saw some punctate wounds up here, these two little wounds up there, and that helped clarify.
That picture hasn't changed since you looked
Yeah.
at it before voir dire.
Perhaps I didn't see them the first time. They're very faint.
You made a mistake.
No,
Oh.
either teeth or claw marks included both of those.
So because you overlook certain things, your opinion you gave to the jury was not an accurate opinion.
At the trial? Is
Yeah,
this
at the trial.
Is this the trial?
Yeah.
This is the trial. It is inaccurate. It's
Well,
either
the-
teeth or claw marks.
Well, that's not what you're saying now. Now you're saying it was teeth, not just teeth. You're saying it was canine teeth.
Yes, I believe now
Right.
that they are more likely canine teeth.
Well, you didn't say more likely. You said to a reasonable degree of scientific certainty. Is it more likely or is it to a reasonable degree of scientific certainty?
Reasonable degree of medical certainty.
Is that what you're saying?
Yes,
To a reasonable degree of medical certainty, those are now dog bites.
those are, yeah, teeth marks.
These right here.
Correct.
All right, and to a reasonable degree of,
It's my opinion that to the reasonable degree of medical certainty, those are marks made by teeth.
and the teeth that you claim that these are now made are the canine teeth.
Yes, I believe so.
Well, not you believe so. I want to know if you're certain about this, a medical certainty.
Yes, to a reasonable degree of medical
Okay.
certainty, those are made by canine teeth.
Okay. And so your opinion from the time when you first testified at trial, the opinions you gave to the jury, it's now different.
I don't see it as different.
Yeah, and if you guys don't know the background of Brennan, he's a defense attorney by trade, and he's a mob lawyer. Like he represented Whitey Bulger. This guy's no chump. Hate him or not. Like it's going to be a very different trial. You're not going to have Lally up there floundering. You're going to have a guy. That's what I'm saying. The defense is going to have to really think very long and hard about how they're going to decide to try this case, because it's going to be a very, very different trial. A very different trial. Understand that. Yeah, I mean, he's not really a numbnut though, Pammy. He may annoy you, but he's a bright guy. I'm just telling y'all, you know, you're letting your personal opinion of him cloud whether or not he's an effective advocate. And right now he's advocating for the government, which I don't like.
But he did
judge
say a lot of things that make him officially a numbwat or numbnut.
He's a
Sorry.
jerk off. Like,
Yeah.
but those are two different things.
No, but some of the questions he asked, while some were scientific and blah, 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 some were officially numbnut status.
fair enough.
Okay. What else did you overlook in this wound when you first gave your opinion to the jury? What else did you miss?
What else did you overlook?
I don't think I missed anything. There's another abrasion in the middle.
Well, no, we're not going to move on. We're going to stay right here in one until we're done.
Excuse
Okay,
me.
no,
I mean,
Miss-
that,
Didn't
yeah,
move
there's an
on.
abrasion right there in the
Right.
middle.
What's that caused by?
It could be caused by one of the incisor
Well,
teeth.
when you say it could be, I want you to use science and not just speculate. How many incisors are on the top row of a healthy dog
6.
and the bottom?
6.
Okay. And if a dog has healthy incisors that are not irregular, that are even, you know it's not going to have one incisor leaving a scratch and the other one's leaving no mark.
No, I disagree with that. It's very possible. Skin is very elastic,
Mhm.
and teeth are not always the exact same
Right.
height and have the exact same configuration.
And if they're irregular, one's bigger.
Plus, you have to factor in whether or not the victim is moving.
Right. That's why
Like, there's a million different things. I mean, if John O'Keefe his arm is moving, there could be all kinds of ways that the
or
teeth.
missing, or there's a gap, it could leave an irregular mark. Could,
It could.
but you don't know that. You don't know anything about the dog that is claimed to have caused this wound, do you?
I don't know about his specific teeth. No.
And do you know whether there's any irregularities in Chloe's teeth that would cause this irregular scratch by the incisor in the middle and leave out any other marks?
Even if there were no irregularities, the fact that skin is elastic and that that it could mean that not all teeth made contact.
Do you know anything about Chloe's incisors on the top and whether there's any irregularities or missing incisors? Do you know?
I don't know.
Would it help you to know that?
It'd be
No.
nice to know, but
Well,
but
when you say
I don't
nice,
need
when you say nice, is that a medical term of yes, it would be helpful to know that?
it could be helpful.
And so when we look at wound number 1 that you now say is a bite mark, not a scratch mark, caused by canines, how many canines do you think caused these 2 linear lines?
I
agree.
believe that those
Round
are
marks.
caused by 2 canine teeth.
Okay, so did the canine teeth start at the top and work their way down, or did they start at the here and work their way up?
I can't say.
Well, wouldn't you, if you're going to say the canine teeth, wouldn't you want to look at the wound and see where the puncture starts and then where it tears from? Wouldn't you want to know that?
You know, excuse me. There is no puncture.
Uh-huh.
There is no puncture in this wound.
Right. And when a dog bites, the bottom jaw with the canines grabs and anchors, and then the top pulls and tears. That's how a dog bite works, isn't it?
Now, sometimes, if both the upper jaw and the lower jaw actually make contact, but not always do both jaws make contact.
It's a 3rd prong lever, a jaw, the way it works. It traps and pulls. Yes?
If there's contact, yes,
And so
with both jaws.
most animals don't just bite with their top teeth and drag.
It happens quite a bit.
What happens with frogs, right? There's
I
no
don't know anything
vertical in
about
the area.
frogs.
It
I'm
doesn't
sorry.
happen with dogs. Dogs bite and pull.
They try, but they don't always contact with their lower jaw.
Did you look at the underside of Mr. O'Keefe's arm to see if there was any punctures or abrasions as an anchor that would allow the top canines to pull on this?
I did.
Yeah. And what'd you see?
I didn't see them.
And so what would have had to happen in your version of events is that the dog would have had to not create a puncture, but just scrape with its top two canines and not anchor into anything else.
And that happens often.
Uh-huh. And you can't tell whether the canine started here or started here.
That's correct. I'm not
Right.
sure.
Well, here it's not a puncture, but it's a rounder wound. We're still on wound number one. The right linear abrasion, it's wider and rounder, isn't it?
It appears to be.
Okay. And this is a
Demonstrating
little
more
more narrow up
contact
here
there.
than it is down here.
Correct.
Right? But there's no way the canines from the top mouth could have started here and worked their way down here. There's no way that could have happened, right? Because this arc would mean that the dog's mouth is backwards. The dog's mouth is backwards if it went this way.
I'm not sure I'm understanding what you're
Yep.
saying.
You see that this here, two teeth,
Mhm.
if the dog's canines started here and worked their way down this way,
Up. Why don't you say up?
they don't line
I
up. They're
guess
not
it
even.
doesn't
It's backwards.
matter. Depends. You don't know what angle
It
the
would be
dog's
an
on.
odd configuration.
Well,
for them.
odd. It would be like Ripley's Believe It or Not. The dog would have to have the teeth the opposite way.
I could see how that could happen.
Really?
Yeah.
Okay. And these two scratches, there is no puncture, you say. You don't know what direction it's going in. There's no anchor on the bottom. But yet, your opinion is that these are dog bites,
I believe they are, yes.
based on just simply looking at them. And you've seen something before.
just
and
needs-
experience makes you think they look similar.
Again, based on my 30 years of experience.
But you don't have any comparative sample or any type of model where you're looking at this and matching up particular points of interest with specificity, like a fingerprint, a swirl, or a whirl. You're not looking at this and saying, well, this is endemic of a dog bite or a canine. There's nothing about this that is
Yes,
particular
there
or
is.
specific.
Dick.
The pattern is fairly specific. It's highly specific,
This
actually.
pattern here,
The
can only
pattern
be
of the
caused
whole,
by a-
the whole configuration, the whole arm.
let's start with this one though.
Yeah,
There's
but you have to
nothing-
take things in context.
We're gonna go through all of them, then we can talk about all of them in context together. Because I know what you said at the last hearing, but I'm talking about these. There's nothing about these that are particular or specific or endemic to a dog bite, is there?
If the arm only had those two
Right?
abrasions,
Uh-huh.
yes, it would be extremely difficult to say that those were dog.
Well, it's not difficult. There would be no objective evidence that it was a dog bite. It wouldn't just be difficult. It
There
wouldn't be
is
accurate.
objective
There's nothing
evidence.
about these. It's just dog bite. There's no puncture. The abrasions consistent here. They're different.
There's a
Objection, Your Honor.
Part of you shouting objection adds to the overlay.
What would you like to
So
do?
if you start to stand and say object, that's fine. Dr. Russell, you finish your answer, and Mr.
I'm back.
Brennan, wait until she finishes her answer before your next question.
I like to see the court.
Who asked for the sidebar?
I don't know.
Rewind.
No, we're blooping.
I wanted to see who asked for the damn sidebar.
Look at that. The whole crew's up there. See, she admonishes Elise for being too effusive
Objecty.
with his objection.
Right. But
she's,
lets him
like,
talk to
allowing
the-
this guy to
Yeah.
like shit all over the witness. She's showing a lot of Bev bias today.
Bev bias. Love it. Wait, what's happening? She
I don't know.
recessed?
Are they recessing?
I don't know.
Oh shit. All right. Oh. Oh, see, this is
Have all this
awesome.
beeping.
Bloop, bloop. This is amazing. Like I got to go past like blooping. Oh, we got the fan. Fan's back in the. Look at that. That was amazing. See, it really came back to help us out having all that talking time.
Yep. Wait, he finished? Oh no.
Who?
I thought never mind. Ignore me.
All right, Mr. Brennan, whenever you're ready.
Thank you, Art. I think we had exhibit 5, please.
Court is on a short break.
Dr. Russell, we were talking
Mm.
about these two
Are they, though?
scratches
Where
or
are they?
abrasions as wound 1. Want to continue asking some questions about wound 1.
This is going to go on forever.
And I had asked you, now that your position is that these were caused by the canines of the dog, Was it the upper or lower canines?
I can't tell 100%.
Well, not 100%. What's your opinion? Are these upper or lower canines?
I believe they're upper canines.
Okay. And why do you believe these are upper canines as opposed to lower canines?
Because when the mouth of the dog opens and attacks, it's usually the upper canines that grasp first.
And you're saying because there's an absence on the other side that this must be the upper canines? Is that your logic?
I'm saying because it's usually the uppers that grasp first.
There's nothing in methodology or comparative study that would tell you that these are consistent with upper canines. You're just deducing that based on there's only one pattern instead of two?
There's nothing that makes it definitive, correct?
Well, not just definitive. There's no cues. There's no clues. There's nothing here that says to a person or even an expert that these are caused by canine teeth.
Well, the other consideration is if the victim was trying to defend himself, it's the upper canines that would impact first on that surface of the arm.
What if the victim was defending himself from a 6,000-pound car?
I
That'd be a
don't think
different
this,
type
I
of
don't
wound than
believe
this?
this is not caused by a car. I
So
don't believe
what
so.
evidence you have that the victim was defending himself, which caused the shape of wounds?
Again, it's very common for someone who's under attack to take their arm and flex it in front of them to protect their vital organs, the
Okay.
neck, head, face.
So if Mr. O'Keefe is flexing his arm to defend himself, that doesn't answer the question, what identifying feature with specificity in these support any conclusion that it was a canine tooth that caused either of them?
Well, first, in general, it's the canine teeth that are going to impact because they are much longer than the incisor teeth.
Right. The question I have is, look at these two scratches here. What objective evidence do you have based on methodology, comparative analysis? What evidence do you have that either of these were caused by a dog tooth, a canine?
Again, the methodology is that I looked at the overall pattern of the wounds on the arm, not just those two wounds up by the shoulder, but the overall pattern.
So your testimony is, if I look at everything together, I can have an opinion. If I look at this separately, it means nothing.
If I look at it separately, I cannot be as definitive, correct?
Well, not as definitive. I'm asking you for an opinion. You don't have any evidence that this has any relation to a dog bite. Without looking at the whole arm and giving that general opinion we'll get to, you have nothing as far as facts or comparative analysis or studies that would say that this was caused by canines on a dog, do you?
It's consistent with two canine teeth. There's a distance between those parallel marks.
Did you measure the distance between where this begins or ends, because you don't know, and this begins or ends?
I would have loved to,
And
but
if I could just finish, I'm sorry. Did you measure the distance between this and this and this and this?
I could not measure it because there's no ruler in that picture.
You know that when a dog bites, the canines don't move. Unlike paws that might open or close, the teeth stay the same distance apart, don't they?
Correct.
There's nothing that you know of in any dog science that canines, when they bite, they open or close or get wider or more narrow. They're always the same distance, right?
With it, for that dog, yes.
Right, that dog.
Assuming that they're healthy teeth, yes,
And you don't know if they're healthy teeth or not because you never looked at Chloe.
correct.
Okay. And you're not saying there's any punctures anywhere in here, are you?
I don't see a definitive puncture.
Well, do you see a puncture that's not definitive?
At the very lower aspect of the photo, this area is not well defined.
So you're saying this is possibly a puncture?
I can't rule it out by that photograph.
Well, couldn't you rule it out through other analysis and evidence? Couldn't you rule it out as we just spoke about? Because if this was the puncture, that means the bite is going this way. And if it's going this way, the arc is in the total opposite direction. Couldn't you rule it out just on that?
I couldn't rule it out, but it certainly makes sense that it would not, that the punctures would not be down below.
Well, not does it not make sense. It makes no sense that it would go this way. It wouldn't be going up if the dog has an arc going this way. The arc would have to be this way.
It depends on the position of the victim.
A dog's arc is not going to change depending on the position of a victim.
No.
And the dog's canines are not going to move depending on the position of the victim.
That's right. But if he's bending over and depending on the position of the arm, the wound can change. The wound can have a different appearance than what you would expect.
Okay. Let's move on to number 2, which I'm identifying as these two linear scratches and then the scratch on the bottom. You've testified about this wound number 2, although you didn't characterize it as wound number 2, right?
Yes,
When you first testified under oath in the voir dire about wound number 2, do you remember what you said that you thought that might be?
I believe I said bites or scratches.
Teeth or claws, right?
Yeah.
Okay. Now at trial, did you change your opinion at all about teeth or scratches?
I'm not sure.
Do you think you said at trial that this was not scratches, but most likely teeth?
I may have said that.
Okay. And then you testified at this hearing, didn't you?
Yes.
And now definitively, you're saying this wasn't scratches at all, it was teeth.
Definitively, I cannot say that. They
Okay.
still could be scratches. There's a possibility that two adjacent nail marks made that.
So you're saying this could be nails or could be scratches? I mean, this could be nail
Like,
scratches
or-
or could be teeth?
Yes, there's a possibility that those could be scratches.
When you were asked on direct examination, that wasn't your testimony, was it?
I
I turned you to page 101, line 13.
On what they,
I'm sorry, the last hearing date is the thickest of the three. Yes, it's page 101, line 13. May I help you on that?
yes. One.
It's the thick one.
Mhm.
You got it.
Okay.
No, that's the wrong site, so we're gonna, you got that one. At that hearing, when you last testified, did you say that teeth made those marks? You were unable to say which teeth, but it was teeth?
Yes, I believe I did.
Okay, so your position from the voir dire and from the trial testimony changed regarding this wound when you last testified at the Lanigan hearing.
I still think that they are probably teeth, but I cannot 100% rule out.
Probably teeth.
Did you say something like, I'm not sure exactly what teeth made these? They could, one of them could, one set of these could be canine, one part of this and an adjacent incisor tooth, but I'm not sure on the second set.
Again, it goes to the fact that the wounds are not very.
looks like he's
specific
stressing. Look at him.
for
Look at him.
differentiating between teeth and claw marks. However, it's in the setting of a pattern, one can get a whole lot more information, and that is supported by the articles.
So getting back to wound number 2, when you described this for Mr. Alisi, he suggested to you, so even though you may not be able to identify the specific aspect of the dog dentition, you're able to identify this is from some aspect of dog dentition. Is that what you're saying? And you said yes. So you were saying at the last hearing, this is from dog dentition.
Mhm.
Dog dentition is different than toenail marks.
Or paw
Yeah.
marks, yeah.
So your testimony
Yeah.
that you offered the jury in this case was different in regards to wound 2 than the testimony you offered the court at the first part of this hearing.
The jury?
Yeah, the jury. When you testified at trial, you said it
Huh.
was claw marks or teeth.
Uh-huh.
You said at the
That's
last
not
hearing
different.
this was dentition, teeth. So the opinion has now changed.
I think for the most, well, I'm sorry if maybe I made a mistake.
I don't think so. I think your opinion has changed. You said this was either claw marks or tooth marks. You weren't sure. There was uncertainty at trial.
Uh-huh.
At the Lanigan hearing, when you were asked by Mr. Alisi, he asked you specifically if this was dentition, and you said it was.
Objection, Your Honor.
Okay, so ask the question differently,
Okay.
without the commentary.
You're saying now this is not claw marks or toenail marks. This is by teeth, dentition.
I actually think it could be either.
Now, would you agree that is different than what you
Jesus.
said the first time you testified at this hearing?
It sounds like it.
So you've gone back and forth kind of a little bit.
It's not a definite, it's not in and of itself, that set of abrasions is not definitive.
Well,
You're the one. You're the
You
one
didn't
asking her to
offer
look
the
at it in a
jury.
vacuum.
the opinion that they weren't definitive or that you had confusion, did you?
I'm getting a little confused because at the jury,
Mhm.
you told me that I said it was one or the other.
Right. And then you changed to it was dentition and now you're back to claws or teeth?
I think it's still teeth, but yeah, I can't rule out the claw.
Yes, CH. That's what this is for. That's what they call a Daubert hearing.
And because you have no comparative standard, you don't have a standard in the industry where you can look at this and say it has 6 points of contact or 6 features of similarity. You don't have anything like that. You're simply relying on your personal empirical experience.
Well, no, I also saw these two punctures, the punctate wounds right there. And that made me think that it was more teeth than claw marks.
this here you're describing
Yes.
as punctate?
Punctate,
Now,
yeah.
you never got the benefit of seeing Mr. O'Keefe, did you?
Personally, no.
Um, Did you know he
I'm just gonna tell you right now, our dog's claws could 100 fucking percent punctate some shit. Like, that dude is
He
punctated
called it
my
a
arm with
den-
his claws, like not in anger when we're wrestling and playing. Like the dude's
Oh,
got,
he's here stretching on the floor. He doesn't like when you say that.
he's so sweet. Ah, who's the fuzzy puppy?
You look behind you like, oh, he's not behind me.
He was here next to me.
No, he's with
such
me.
a fuzzy puppy.
he was Irish,
Oh, punctate.
light skin,
Makes sense with that
Yeah.
name.
freckles, moles. Look at these. They're all over his body. You don't think the dog was puncturing up all over here, did you?
No.
Right. So these are the same. These little things, these skin blemishes, same as these all over the body.
Oh,
I
you're a
think-
doctor?
Ah!
Do you think that what
Sorry,
you're
guys.
describing as dog puncture wounds, you could be mistaken for just his skin and the different types of marks on his skin, like freckles or moles?
I don't believe so, particularly since they're right where those wounds are, the abrasions are.
Well, wouldn't the skin blemishes be there before any abrasions?
I haven't seen a picture of him before this incident.
Okay. So to get back to, we're now at, this is either a dog bite or it's a scratch. What is it about the top two that tell you it's a dog bite?
Would you rephrase that? Or, I mean, would
You're
you say it
saying-
again?
You're saying this, these are either dog bites or scratches. That's what you're saying. You're not
Mhm.
sure which one, but it's definitely a dog. That's your position.
Yes.
Okay. What about these two are telling you that this is a dog bite?
I think I said it already previously, that they're parallel. They're parallel lines that seem to have these punctate lesions associated with them. And they're in and around the other lesions, I believe, are dog bites.
When a dog punctures and pulls, there's not an island of skin and then it goes back to the pole. The puncture starts at the pole and then it goes to the bottom, doesn't it?
There are no complete puncture wounds on this arm.
Well, you just cited puncture wound as a reason why you think this was a dog bite. You said these aren't
That is
these are not a skin condition, rather they're puncture wounds, and that was the basis for saying these are bites.
No.
If you don't know if these are puncture wounds or not, how can you say these are dog bite?
First of all, I did not say, with all due respect, I did not say they were puncture wounds. They are punctate lesions.
Okay. And so
They're different.
the punctate lesion, is that caused by a tooth?
Yes, I believe it is.
And you know when a dog punctures, it then tears and pulls.
Only if they penetrate the skin. They have to penetrate in order to pull,
And, the
to create a laceration and pull.
and a puncture is not a penetration.
A puncture is, a punctate lesion is not.
And so what about these two linear abrasions? What science, what comparative analysis, what evidence do you have that these are caused by teeth
It's part of the pattern,
of this whole pattern?
of this whole pattern.
But just like wound number one, independently, this doesn't tell you anything. You can't give an opinion to a reasonable degree of medical certainty that this was caused by a dog standing on its own.
By itself, it's consistent with, but yes, I cannot say by itself that it's caused by a dog.
Okay.
That
And this-
lesion by
and-
itself.
And there's nothing about these scratches that are consistent with the horseshoe shape of a nail of a dog, is there?
You mean the horseshoe shape of the jaw?
No, the
of a
dog's nail, the dog's nails,
paw nail,
toenail,
toenail?
yeah.
There's nothing specific, no.
So again, to have any real opinion to a medical degree of certainty, you need to look at everything.
Okay, what dog has horseshoe shaped, like horseshoe?
That's what I
mean,
said
the
when the first time he
curve-
said it. Horseshoe.
Get the Nook up and let's look at his claws. Like our dog's claws need to be trimmed like a mofo. They are not horseshoe. Make that guy stand up and grab his leg, which he'll hate.
Together, you cannot look at this and tell us any specific identifying feature that would support an opinion or conclusion to a degree of medical certainty it was caused by a dog bite or a dog scratch.
Mr. Brennan, that's the way medicine is. You know, with in medicine, you don't just look at one complaint or one wound or one test and make a diagnosis. You usually need several supporting tests or other lesions to corroborate a diagnosis. So that's part of medicine.
So you would agree with my statement, what I just said?
Would you repeat it?
Of course. So there is nothing specific
They look like they're all
regards to these
squirming
three
in their
scratches
seats.
in and of themselves, without looking at the entire arm. There's nothing about these three that you can say with specificity that support.
I'm just telling you, AJ's shit right here is patchy as fuck. Like this whole area, you see my cursor right? That is patchy.
Move on.
Sorry.
An opinion that they were caused by a dog bite or a dog scratch.
I disagree. I think the combination of the punctate lesions right there and there,
Mhm.
along with the linear parallel abrasions, supports that assessment.
Do you have any papers, any studies that show that a scratch like this, that would look like this, is a dog bite or a dog scratch based?
I have the same amount of papers, reports, articles that you have that those were caused by a taillight, sir. That's how many,
Sounds like she's got
articles
more.
I have.
She's got
And you
more.
have the burden of proof.
Just on the appearance of these 3 scratches.
Just on the appearance, no. Usually the studies that I've read have pictures of multiple lesions, and in those pictures of multiple lesions, there may be lesions like this, individual lesions.
You can't tell, in your opinion, these are dog bites or dog scratches. So is there anything specific about them that can lead you to a reasonable conclusion, to a reasonable degree of medical certainty that these were caused by a dog? Putting aside the whole panoply of
Can you
scratches
pause it real
beneath
quick?
there, what about them is unique and distinct?
So I have to say, when she was saying those were punctate wounds, and I can't move my mouse above it, but if you look on the right above,
Here, can you see my cursor on there?
you've got to put your cursor on the actual video. Yeah. So
Here,
those,
these two,
but put them on the little things above them.
these
That
two little guys
and that. Now slide over on the other side of the first. Nope, the other side of the first punk.
right
Little
here.
right that, and right, and the one on the other side, right
This.
there. Yeah, that when she first said that, I looked to those 2 things and thought, are she sure those aren't all freckles?
Freckles.
I
They
mean,
kind of look like freckles, or
yeah.
not just like I've got a million of those on my arm.
Well, I mean, that was the point that he was making, but it was I did actually think that before he said it, given those other 2 right on the other side are kind of, at the same light.
Let's not body shame AJ. I'm gonna
It's-
beard shame him. I'm sorry. I'm gonna, but I'm a beardsman.
When you
I'm,
got a beard like my man, I
I'm
guess
very
just
critical. If
can't
you're gonna grow a beard,
do it
come
right.
all the way. Like there's no can't have that patchy shit.
Objection, Your Honor.
I'll just say, this what's been called 2.
What about them?
Okay, again, they're consistent with dog bites and scratches, and together with the overall picture of the numerous wounds, it paints a picture that
Allows me to
makes
find.
sure that this is from a dog attack.
Okay, I won't ask again, but I wasn't asking about the overall wounds. We're going to get to that. I was asking just about these 3, but I'll leave your answer as it stands. Let's move to wound number 3.
Yeah, you
Wound
will,
number
Dick.
3 really is a collection.
Trying to
of
get
scrapes.
sound bites
And you
for
gave
trial.
some testimony about the first 2. So if we look at 1, 2, 3, 4, 5. So in wound 3, we have 5 larger abrasions on the top of the elbow. You see that?
I do.
And then you see a couple of dots down here. Yes?
Oh,
Yes.
At least
And I want to ask you
3.
some questions, and what I'll
I mean,
do,
at
even though
least
this is wound
4.
3, I'll talk about scrape 1, 2, 3, 4, and 5, so we know what we're referring to. Is that fair?
Except that you called it a
Yes,
scrape.
but
okay.
again, any one little tiny part of the image or wound is, it's not going to be sufficient to make a diagnosis. I need the pattern.
You never recognized that in your voir dire testimony or in your trial testimony before the jury that you needed a collection of all abrasions to have an opinion. Instead, isn't it fair to say that you were talking about individual wounds as if they stood on their own?
I believe that
Objection, Your Honor.
Can you answer that? I'm gonna
that
allow
is
you to
unfair.
answer.
That's incorrect.
It wasn't until Mr. Alisi directed you that you started talking about dog attack and collection of wounds as a whole.
That is incorrect.
Okay, so looking at these wounds, wound number 3, and I know it may be a series of wounds, it might not be one wound in your opinion, but let's talk about this collection of abrasions, okay? Do you remember in the voir dire talking about this collection of abrasions and you were saying they were consistent with teeth or claw marks?
Okay,
Is that what you said at the voir dire?
I'd have to look again.
Okay, well, why don't we look at page 38, line 13?
Mine is gone. I don't have it for there.
Okay, we'll have to get you one.
Bloop, bloop.
Fred is,
Yes.
Thank you very much.
Mandy, are you bored?
48,
That's me.
line 13.
I was snoozing him.
Oh,
I
What
keep
page?
snoozing him.
That one's not right either. No. Okay. Well, let me withdraw that question.
Yeah, that's what I thought, Dick.
Did you testify previously that these are consistent with teeth or claw marks?
Did I testify when?
Previously.
Possibly, yes.
Okay. And do you have a
Oof.
different opinion today, whether these are teeth or claw marks?
No.
So you think that these could either be teeth or claw marks?
I think they're more likely teeth marks,
Which one of these 5 do you think are teeth marks?
all of them.
You think all 3 are teeth marks? Do you think a dog bit Mr. O'Keefe and inflicted these at the same time or different times?
I believe that this was this configuration, this collection right
Yes.
here.
Yeah.
I believe this is one bite.
One bite. And so if we were to follow your theory, this was one bite, this would be the arc of the dog's mouth?
Yes, it could be.
Well,
Could be.
is there an arc here?
There appears to be.
Okay. And we know that when a dog punctures it, then from the top teeth pulls down, the bottom pulls up, right?
Push it.
So if this is the arc of the dog right here, and it's like a half of a,
Why is this fucking guy pretending like there's not circumstances that exist in the world where the dog can't get its bottom fucking jaw on the bottom part of the arm? Like in a situation where John O'Keefe's laying on the ground, like how's the dog getting underneath a part of his arm that is laying on the ground? I always thought that that's where it looked like the dog's teeth went in, right?
Yeah, you
here.
thought that
And
Lassie
that
was
those were
dragging him
claw
to
marks
safety,
that the dog was trying to keep his arm still.
or that the
Like our
dog,
dog uses his arms all the time. Our dog's like a human. Like he's
or that
always
Lassie
using
was
his arm.
trying to drag the guy to safety.
Yeah, like I mean, like I catch a lot of shit from my coyote theory, but you know,
It
like I'm still
Can't
there.
be.
I'm
Can't
still
exist
there.
now.
I'm still there with my coyote theory. I don't give a fuck what y'all say.
a sign or a half moon over the elbow. You claim these 2 dots are consistent with puncture wounds?
No, punctate
Oh,
lesions.
punctate lesions, I'm sorry. Which teeth, upper or lower teeth, do you think caused these 5?
I believe those were the upper teeth.
So you
I
believe this is a
find-
canine on the left, number 1, and a
I
canine on the
determine.
right, number 5?
It could be.
Okay.
Oh,
Now, here's the arc of the dog's mouth,
Pokey.
and this is a canine on 1 and 5. Where do the canines puncture and pull? Up or down?
I'm sorry, say that again.
Where do the canine teeth puncture? From the bottom or from the top?
So if these are, let me use my pointer here. If these are canines, and this could, by the way, be two. This also could be 2 separate bites. But if these are canines, they usually would start on the
top.
based on this picture, the upper or higher area and
Right.
pull down.
They would have to start up and pull down if that was a arc of a mouth, wouldn't it? But you see the bottom of these wounds, right? The round part
Mhm.
that is closer to a puncture is on the bottom. Aren't they going in the wrong direction? If this is the arc of the mouth?
No, I don't think that they are going in the wrong direction. You have to keep in mind that presumably Mr. O'Keefe was not standing there and letting the dog just chew on his arm. Okay, that there's
How do you know
relative
that?
move.
Bukaki?
How do you know that?
Bukaki?
No, but she's not finishing her answer, man.
The question's allowed.
How do you know what he was doing?
Because it's normal human behavior that if you're,
How do you know what he was doing? How do you know what Mr. O'Keefe was doing that night?
How do you know what she was
Yeah.
doing,
it's
Brennan?
normal human behavior to pull away from someone that's attacking you, a person or an animal. That's normal human behavior. If he was still throughout this whole attack, I would be looking for a different set of wounds.
You're speculating about all these comments about what he was doing and not doing. You
So
have
are
no
you,
idea.
Brennan? Your
what he
whole
was
case
doing.
is speculation.
I'm just
Your Honor.
There you go, Elise.
Question.
Getting that ass.
Can you answer that question, Doctor?
I'm basing it on normal,
Normal
human
human
behavior.
behavior. Dick.
And so you would disagree with me that if these were dog bites, the part that's thicker, that is more similar, although not a puncture, would start at the bottom and work up, meaning the dog's head was over here on the top. You disagree with me about that?
Do I disagree?
Yes.
Yeah, I believe that that's
Okay.
incorrect.
And if these are canines, did you measure the distance between the canines?
Again, there's no ruler, but the other thing is we don't know what position his elbow was in at the time of this.
Wow. Look
So
at
it could be, although it looks like it's a
what's his
larger,
face?
you know,
He's really
larger
falling apart. He's
configuration
fallen
than a normal
apart.
canine distance into canine distance. That's what you're referring to, into canine distance.
He's pulling on his
it
ear.
almost
He's
flexed.
sweating.
That distance would be shorter. So you cannot make any assessment based on this picture.
Do you know
What? You're muted, babe.
Oh, I just wanted to say I appreciate Ajax's bracelet game.
All right, but what about how much he appears to be sweating?
I think he's fucking bored.
All right, that
And
could
it might be
it.
hot as shit in that courtroom.
I
They
don't really
probably
mean
have-
sweating. I just mean he seems to be shifting and playing with his ear, and
He's fucking
like,
bored. It's
got
been
a
going on
headache.
for hours. He's like, oh my God, how many times is this guy going to ask the same
That could
shit?
be. That could be. You're right.
You know what I mean? And it's like, it's not even his witness.
Right.
You know,
The differences between the left
got
mark
other
and the right
shit to
mark
do.
are a greater distance than wound number 1, where you said that it was 2 canines that caused these linear abrasions.
And there's no elbow between the linear abrasions of
She's trying to look at all the
wound,
lawyers, see how they're
flexion number
reacting.
1. There's no elbow up here to be flexed.
Let me ask again, do you notice the difference between these two? Is wider than the difference between wound number 1 when you said it was 2 canines?
You mean this mark here versus this mark here? Is that what you're talking about?
Wound 1 on wound 3, number 1, number 5, where you said these could be canines. You notice the distance is different than the distance where you claim that wound 1 was caused by 2 canines. Do you notice the difference in distance?
Again, I'm not clear what you're asking me. Are you asking me the distance between this tooth and that tooth? I think what you're asking me is the intercanine distance. Is that what you're asking me about?
Intercanine distance, I've never heard that word.
Well,
Is that a new one?
no, that's
Okay.
well known in medical literature.
Let's just look at simple math or size. The distance between these two wounds is a greater distance than where you said it was canines in wound number 1, isn't it?
Again, I believe I just explained it, that if the elbow was flexed at the time that the wound was inflicted, or the bite was inflicted, you would get these two wounds that are closer to one another than they appear here, because the
Flexed?
arm is partially extended here and skin moves.
Get them closer together, but I thought the whole issue is
Are
they're
you saying
further
this is a full
apart.
bite, puncture wound, top and bottom?
Excuse me?
Are you saying this was a full bite of puncture wounds, bottom?
what I'm saying, sir, is your face is stupid. That's what I'm saying.
I
canine,
thought you
top
said there was
canines?
no full bite
Are you saying
anywhere.
this is a full bite?
I don't believe no, this is not a full bite. There is no penetration, significant penetration of the skin. So this is not a full bite or a complete bite.
Did you say at trial, at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial round small abrasions, again representing upper and lower teeth, in my opinion. Was that your opinion at trial, that this represented upper and lower teeth?
Yes.
And it's
these
still her
lower teeth,
opinion.
what teeth were these?
What teeth?
Yeah.
I don't know.
Were they the canines?
Could be a canine, could be incisors.
There we go. Thank you. And so your opinion at trial is these 4 could all be canines.
Which four?
1, 2, and then the 2 punctures or punctate.
That is a possibility. It is actually, and I think I said this too, that this could actually be a configuration of 2 separate bites. Where you have canine, puncture wound, punctate lesion from so upper canines, lower canines. And then this could be a separate one. Just can't tell. There's not enough specificity in this configuration of wounds.
And you have nothing to compare it to either.
No.
Do you see the distance is different between what you said is a 4-set upper and lower canine and this one here, this canine? Do you see the obvious difference?
With all due
distance?
respect, Mr. Brennan,
Bukkake?
again, the elbow
Bukkake?
moves, so the skin moves. The
Whoops.
skin overlying
I
the
didn't mean
elbow
that
moves, and we don't know the configuration that this arm was in at the time those wounds were inflicted. We cannot make a generalization.
I'm going to ask you one more time. You don't have to answer. Do you see the obvious distance between wound 1 and 3 where you say that it was the canines? Do you see that?
Objection, Your Honor.
So I'm going to strike the part that says you don't need to answer. Can you answer that question, please, doctor? And then we'll move on, Mr. Brennan.
I see the difference, but I
Explained it.
I understand the difference.
Okay. If these were canine wounds, they can't be claw wounds, right?
Yes.
And based on your knowledge and study and whatever you're relying on, you have no way of telling if this is canines or a claw.
Not 100%, correct?
Not even 100%. You don't have an opinion to a reasonable degree of medical certainty whether
Do.
it's canines or claws, do you?
I believe those are canines.
Did you testify at the Lanigan hearing when Mr. Alisi was asking you questions? Did you observe any claw marks with regard to the injuries and you said it's possible?
Possible, yes.
How can you give an opinion to a reasonable degree of medical certainty it was canines and in the same breath and statement say, well, it's possibly claw wounds as well?
Your medical examiner did it.
My opinion about reasonable degree of medical certainty is about the whole arm, the configuration, the pattern of the whole arm, and not any one individual wound.
You son of a bitch.
Wound 4 up here. What do you think this might be?
I don't know. I'm not certain.
Well, I mean, in the totality of a dog attack, it has to be something related to a dog because we don't know that it was there before. Had to have been something, right?
It's probably related to the dog, yes.
Well, you don't think he just had this independent wound and then all these came from the dog attack and this one just happened to be hanging out waiting for them?
That's correct. I don't
Right.
think that he had a separate wound.
You don't think this one maybe was caused by the broken shards of glass from the taillight during an alleged collision, but the other ones were from something totally different? Do you?
No, because it has an orientation about it. It's oriented, again, in a somewhat vertical orientation, similar to many of these other sets of wounds.
I don't know what that means. It has a vertical orientation. How does that help us understand if this wound existed before or after the so-called dog attack?
It has some similarity of pattern.
So you think this was caused during the alleged dog attack?
Yes,
Okay. What caused this wound during the alleged dog attack?
I don't know.
Is that because there's no methodology or comparative standards, so you can't compare it to anything?
No, this because there's not enough specificity in that one particular wound all by itself.
What are the options? How could it have been caused during this dog attack?
By a tooth
Okay.
or claw, most likely.
Could have been caused by the ground?
I doubt it, considering that, again, it's oriented in a similar fashion to the rest of the lesions.
Okay. When you read the background facts of this case, well, let me ask you, if a dog attacks an arm, it's going to create force on the arm, wouldn't it?
It depends on how much penetration. Yes, it depends on how strong the bite is, how much penetration. It gets through the clothing. Clothing that's on the intervening between the arm and the dog is going to present a little bit of a buffer.
Well, let's talk about the force on the arm.
Mhm.
If this was a dog attack, as you claim,
Mhm.
that means the teeth and or the claws penetrated that sweater and caused an abrasion on Mr. O'Keefe's arm, correct?
Yes,
So there had to be an amount of force pulling on the arm to create that friction, which led to the abrasion.
Yes.
Okay. Did you know from any of the facts that you reviewed that when Mr. O'Keefe supposedly left the car, he had a glass in his hand, like a straw in the glass?
I'm aware that there was a glass in his hand.
And you're aware when he was found by the side of the road that glass, the broken part of the glass, was right near him with the straw?
I don't know anything about the straw, but yes, I know.
And so if there's a dog attack and somebody's holding a glass,
Uh-huh.
right, they're not likely to continue to hold on to the glass throughout the duration of the attack and then move somewhere else with that glass.
I don't know if he was.
Wait, he wasn't holding it, jerk off. Like, what is this guy doing? Like, now, see, again, you got to lean into Lucky. That shit was in the fucking road.
Yeah, but what was the glass next to the road?
No,
Or
I'm
was it
saying
on the
Lucky
sand? It was on the
came
snow.
down with the blade. Well, it was near O'Keefe's body,
Right, not in the street.
not in the street, because the
Right.
plow had come through
And he
threw
scooped
all the shit from the street up
on the
onto the
side.
yard. Like if I'm Ajax and Yannetti, I'm hiring an expert, a like biomechanics guy to go with a fucking snowplow driver and to measure how far 4 to 6 inches of snow is thrown off a blade into a yard. Like I'm doing that. Like
Well,
why are
but
they
not if they're sticking with they was planted there anyway.
oh God.
Holding onto the glass during the dog attack.
Well, hypothetically, assuming that the evidence is he supposedly was holding the glass, wouldn't a dog attack rip that out of his hand? Wouldn't he drop the glass?
There are many possibilities here. He could have transferred it to the other hand.
Let's look at wound number 5. Do you remember testifying about this?
Yes,
And you said it looks like an arch.
it does to
Okay.
me.
Are you saying the arch is on the top or on the bottom?
No, I thought the arch was on the bottom. But by bottom, I mean what we call proximal part of the arm. So right here is where I think the arch is.
And if this is an arch and these are dog bites, these would be canines.
They could be. However, I can't rule out that this is because of the curvature of the arm. I can't rule out that this was from a canine and incisor teeth.
Well, this is a different angle than here, right? But there's no flexion like in the elbow on this wound area. This is the bottom of the wrist, right?
That's That's correct. However, that part of the arm has a different configuration than the upper arm. And it's got it's got a bone right underneath it.
So you're
The
saying,
ulnar bone.
I'm sorry, I didn't mean to interrupt you.
Oh, it's got the ulnar bone. So
Okay.
a wound to that area is going to look different than a similarly placed or caused wound to this area, which has a lot of padding underneath it from the soft tissue, subcutaneous tissue, and doesn't have the protuberance of this bone right here.
We have a distance problem when we compare these, don't we?
We have a what?
A distance problem. The distances are different. If these are canines, obviously it's a different dog or something else that caused it because the distances are clearly different, right?
Again, one has to know how wounds occur. And I didn't say that those are definitely two canine teeth on the periphery. I'm saying that I believe that this is a combination of canine and incisor teeth.
When a dog bites and tears, you see a missing tear pattern, don't you? You see the skin gets torn on many occasions.
Yes, but we don't have any of that here. We have no penetrating wounds here.
Right. Is it remarkable to you that if this was a dog bite with canines, there is no tearing of the skin? Is that remarkable to you?
No, because that dog was not able to create the force enough to penetrate the skin through that sweater.
Could I have exhibit 32, please? Okay. You've seen this picture before?
Yes,
Okay. And this is allegedly is a dog bite from Chloe?
yes,
And you see the tearing of the skin, don't you?
yes.
And you can see the corners where the incisors would penetrate through a puncture. Yes?
I'm not sure what teeth punctured this, but yes,
And
I see the skin is all penetrated.
This is consistent with the literature of a tear and a hold and a pull, right?
No,
Okay.
no, absolutely not.
This is not consistent with a dog biting and then pulling the skin.
This is consistent with an avulsion wound caused by a dog.
Very different wound than we looked at on Mr. O'Keefe's arm.
On
Mr. O'Keefe's arm, very different, right?
correct.
Okay. We can go back to 5, please. Now, your opinion that this is a dog attack.
Mhm.
Have you ever had peer review of this opinion with this photograph?
No,
No. You would agree that this dog bite science is what they call a soft science. Would you agree with that?
I don't know what you mean by that.
Okay, well, it's not like DNA. It's opinion-based. It's subjective-based, the science of dog bites, isn't it?
It's based on a lot of training.
Yeah, and a lot of subjective opinion too, wouldn't you say?
There's opinion here, yes.
Uncertainty,
There is some, yes.
right. And being that type of science, haven't you read in the studies about peer review, how peer review works?
What specifically are you?
That you have another qualified professional look at it and question and vet whatever opinions you're giving. Did you go through that process at all?
I've been through that process, yes.
You've been, okay, and who peer reviewed?
You mean
findings?
this case?
Yes.
Oh, no, not this case. No, I thought that this information was rather confidential and I didn't share this information.
Well, you discussed with the defense other information in this case, didn't you, about the accident and about people's opinions? You've discussed that as part of your opinion, haven't you?
Yes,
Okay. Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds of 2 to 3 millimeters up to 7 centimeters were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. Did you get that expert opinion from the United States Attorney's Office when they investigated this case to consider as part of peer review?
Objection, Your Honor.
no, I did not get that, but
Did you say you did get that?
no, I did not get that.
Oh, okay.
However, I have a comment about that.
Please.
Not very medical exam, not very many medical examiners have the experience that first of all, have experience with dog bites, seeing hundreds and thousands of dog bites and treating them. And not very many medical examiners have even autopsied a case of dog bites. So although, some physicians have certain opinions based on what they know, they don't have my experience. I'm
Do you
sorry.
know if Mr. Walsh had your experience or not?
I don't know who
The
is it?
gentleman who gave this opinion that was employed by the federal government, do you know if he had your experience or
What's
not?
his name?
Mr. Walsh,
I
John
d- no.
Walsh.
No, I don't.
So he could have more experience for all you know.
Oh, I'm highly unlikely.
Okay, you have more experience than anybody in the country.
I think I have at least as much experience as any other possible person in the country.
Ah.
And I have it from both aspects, from the clinical aspect and from the forensic aspect.
Did you review the opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
Dr. Who?
Kenneth Kinsey.
No.
No. If you look, I believe Mr. O'Keefe's arm were completely bent when he sustained the injuries. A lot of them match up. They're a continuation of another injury.
And I don't even know who Dr. Kinsey is.
Okay.
Is that
So-
a medical doctor?
So you don't have any peer review at all. You have nobody who's given an opinion similar to yours about this being dog bites, do you?
Is Dr. I'm sorry.
You have no peer review. You have no peer endorsement. Everything that you have no peer endorsement for any of your opinions, do you?
I didn't think I was allowed to show these pictures to anyone.
When you're giving opinions about the teeth and suggesting that there's might be bend, things you don't really know about, you would agree it would be best to look at the dog, Chloe itself, right?
Not necessary.
If you looked at Chloe and examined Chloe, you would know whether or not there are any irregularities in Chloe's teeth, wouldn't you?
Yes, I might.
You would see it.
Also,
wouldn't you?
don't know
Well, if I
was
got close
Chloe.
enough, and
Right.
I don't know if I want to get close enough to Chloe.
Well, why wouldn't you want to? You're a medical doctor. You want to have an opinion to a degree of medical certainty. Why wouldn't you want to see the best evidence of the distance between the teeth and Chloe? Why wouldn't
I
you?
don't.
I'd have to
I'm
make
not
sure
telling
that
you
I
it was
wasn't
Chloe.
putting myself in danger.
Okay. And if you saw Chloe, you could see if there was any missing teeth, couldn't you?
I don't know
Yes.
that it was
You
Chloe.
could actually measure the canines in Chloe, and then you could compare them to what you're calling dog wounds on Mr. O'Keefe's arm.
No.
You could do that, couldn't you?
No.
I would have to get a veterinarian
Mhm.
to sedate the patient, the dog, because that going near that dog would be very dangerous. They'd have to sedate the dog to measure the intercanine distance.
What if you did get a veterinarian to sedate the dog,
Uh-huh.
and then you could safely go and look at Chloe, and you could actually take a mold of Chloe's mouth, right?
Mhm.
Yes? You've read that in the
One-
literature.
yeah,
The
one-
best
yeah,
way to
one
come,
could.
I'm sorry.
Yes.
That's not
You've read in the
allowed.
literature, the best way to
Specific
compare
comparison to a dog, to another
the
dog.
teeth and the mark is you actually do a mold of the dog's mouth. You know how valuable that can be in analysis, don't you?
It can be, but the question, I believe the question here is not,
Am I in
Chlo-
crazy world?
Finally, she's
No
going
one
to say
knows
it.
where the dog is.
Well, now they do, but she's finally going to say it. That I'm not saying this was Chloe.
Wait, they do know where Chloe is now?
Yeah, she went to some farm in some place. I
Wait,
forget.
but some farm in some place
Yeah,
does not
but
mean
I
they know
thought
where she is.
McCabe knew which farm and which place.
Wait a second. Somebody in the chat, make this clear for me. Like,
But
do
let's
they-
see what she's going to say, and we'll wait
Do
till
they know where she
chat
is?
responds it.
I want to know where Chloe is.
which dog created these wounds.
There you
but
go.
Did a dog create these wounds?
That's not my question.
Or
My
a
question
coyote.
is,
That's the only
if
question
you
I'm
took a
answering.
mold of Chloe's mouth, you would see the distance between the canines. And
I
you
don't
could
know that it
measure
was
it,
Chloe
quantify
again.
it, not guess and speculate, quantify it, correct?
But Your Honor, could we approach, please?
Okay.
Thank you.
She's not saying it was Chloe. No one's saying it was Chloe.
She's saying it was probably a coyote.
No, a dog.
Oh, dude, coyotes are 100% canine.
Oh,
You realize that, right?
yeah.
Our
Sorry.
dog is basically a coyote.
Is he up there by you? He's gone.
No, but I know what he looks like. Oh, let's bloop.
Bloop.
Got some blooping opportunities right now. Bloop, 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 bloop. Bloop, 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 bloop. Ooh, look at all this tasty blooping. Oh, wow. Wow. We had lots of blooping available for us right here. Man. This is amazing amount of blooping. I mean, I think we've moved into a slider situation. Oh, wait. See, as soon as I go to the slider, Brian fucks it all up.
Dr. Russell, when you're examining these separate wounds and the distances and the depth between them and guessing whether or not it was a canine or incisor, wouldn't you agree it would be helpful if you had a safe opportunity to actually examine the dog Chloe?
No,
It could
I
be.
don't.
If you had a safe opportunity
Say
to
that
examine
it's
Chloe,
not
you
Chloe.
could look at the size of Chloe's jaw.
It could be, but those wounds on you're shaking your
That's not
head.
my question.
Okay.
My question is,
Let
if you
her
had an
answer.
opportunity to go safely and look at Chloe, you would be able to tell the size of Chloe's jaw. You could measure it.
Possibly, yes.
You could determine the gape of Chloe's jaw, couldn't you?
I don't know what gape of
How it bites, how wide it opens up.
I'm not sure I could determine that.
Okay, you could look at Chloe's teeth.
As they are now, yes.
You could measure the distance between the canines if they still exist in Chloe's mouth.
Yes, from a model or imprint from Chloe's mouth.
You could take a mold,
Right, a mold.
or you could take a tape measure or a ruler, and you could measure. You could
Oh,
do
that
both.
would be very
Oh,
reliable.
Brendan, cut the shit.
You
Do
could
know what
determine whether or
dog
not
is?
she
Jesus.
had 1 incisor, or whether she had 2, 3, 4, or 5, or 6 incisors.
Currently, yes, but I can't tell what the condition of the teeth were during the incident.
Uh-huh.
And
You could
again,
tell-
she
Did
doesn't
Brennan
know it's
just
Chloe.
unilaterally change the pronunciation of incisor to incisor?
Scissor.
Wow, this guy, he's amazing.
There's any missing teeth.
Correct.
You could look at Chloe's paws, couldn't you?
Yes.
You could do moldings of those and measure those as well, couldn't you?
I'm not sure that would be useful.
Well, if you
Measuring
think
them.
if you think that some of these wounds could have been scratches, you could look at the nails and the shape of the nails, couldn't you?
Well, nails are frequently cut on a regular
course.
basis, and the distance between the distance between the nails, as you mentioned earlier, can change depending on whether or
She
not
should say, should I do this
you know,
with
the paw
every
is
dog in the
in a
neighborhood?
compressed state or a more relaxed state. So that wouldn't be reliable.
So you would not even consider measuring the paws because you think that would be unreliable?
I don't think it would be reliable. No.
You wouldn't study the toenails to see the shape of them,
If I could, I'd look to see if there's an abnormal toenail,
right?
for instance. Yes.
And so there would be a benefit to
Hey, I mean, did they trim the nails? So, I
Right.
mean, like, what the fuck is this guy talking about? Like, are they grooming the dog? Are we going to get a grooming? Like, man, like, so we'd have to go back and get all the grooming records for Chloe. We'd have to ask everybody in the Albert house how often they trim the nails or sanded them down if they have that little thing. I mean, what if this dude knows, like, what is this? If I'm Dr. Russell, I'm saying, you know what, Mr. Brennan, by the tone and tenor of your questions, you're making it sound like you found the dog. Have you found the dog? Because if you're asking me if you found the dog and you're asking me if I'd like to test it, sure. Why not? Like, why wouldn't she just
Well,
say
I
yes?
put in there that somebody said that they found the dog and they did something, and I put
Well,
up
the
a
state
comment.
did. The state did.
Well, right. Well, that's
No, well, I mean, like, my point is, I think her answer should be yes. Of course, I'd love the opportunity.
if you could identify. I don't think there's a factual basis to know what dog did this.
Right,
That
'cause
would
it
be
was a
my
coyote.
answer.
Exactly, it was a
Or
coyote.
what canine
Tiger.
did it, I guess, is the better response.
Which coyote did it? I'm telling y'all, Google coyotes in that area back at the time that this took place. They were out of control. It's like, it's no bullshit. They were out of control up there.
doing that. You didn't do that,
They were
though.
like bringing in the federal government to help with the coyote problem right around this area. It's like people were like popping off about that shit like it was crazy. It was not crazy.
Did you? You didn't go see Chloe and take a mold of Chloe's mouth, did you?
Did you?
It wasn't
Brett?
necessary.
Well, did you go up and take pictures or measure the teeth of Chloe?
Wasn't necessary. Say it again.
No,
Did you ask to?
Wasn't necessary.
no. It was my understanding that Chloe was in another state, but again, I didn't think it was necessary, and I have reasons why I didn't think it was
You,
necessary.
you thought that Chloe was in another state. Did you ever discuss going to see Chloe and doing these studies on Chloe so you could see if they were
There's
dissimilar?
no factual basis to
to these
believe it was
abrasions?
Chloe.
I was asked to evaluate the wounds.
Do you know that Chloe exists, that we provided notice to you, that we went up and saw Chloe and took molds? Did you know that?
Objection, Your Honor.
Did you know that? Point allowed. Did you know that, doctor?
I do know that now. Yes.
Did you know that before you testified the last date in this case, that we actually went out and found Chloe and took molds and measured the paws and the teeth? Did you know that we did that?
I don't know. I don't recall.
Before you came in and testified at the last hearing, you don't recall whether you knew that Chloe was available?
I believe I knew that there was a consultant that you hired a consultant, and I didn't know what that consultant was going to be doing.
Okay. Now that you know that Chloe's available, wouldn't those molds be helpful? Wouldn't you want to look at them and
I don't know
compare
that it was
them
Chloe.
to the distances on the abrasions on Mr. O'Keefe's arm?
Objection, Your Honor.
I don't think it's necessary for many reasons.
Yes. BG.
If the distance of Chloe's canines
Yes.
is significantly different than these abrasions in this picture, you would agree that the abrasions in Mr. O'Keefe's arm could not have been caused by Chloe. Would you agree?
No, I wouldn't agree to that statement.
Mhm.
Again, because of various factors such as elasticity of the skin, shrinkage. There's various factors.
So, if I understand, you have no interest in examining or seeing Chloe. It's irrelevant to your opinion?
I don't think I need to see Chloe.
Well, you said earlier when I asked you about particular wounds, it would be helpful to know these.
And I
things
also
about
don't
missing
know what
teeth and
canine
spacing and
inflicted
distance
these
between the
wounds.
canines. Is that no longer helpful to your opinion?
No, I think you're mischaracterizing what I said. I believe I said that it would give information about the condition of the teeth now, but it wouldn't give information about the condition of the teeth when that incident happened.
In the spirit of medicine and science, isn't more information good?
Generally,
Generally. But you generally would not want to go see and examine Chloe.
It's too late,
I don't
sir.
think it's necessary, and there's so many reasons why.
Okay. Thank you for your time.
Yes.
All right, Mr. Lassie, go right ahead.
Oh God, I'm tired.
If I could have a motion to
Sure.
organize the exhibits, thank you, Your Honor.
I think we need to stay on track here that this is a Daubert hearing and not
They're
get
organized. I
sucked
just wanted to
into
make
what
sure I got
they're
it right. Thank you, Mr. Brennan.
trying to do.
Dave, I can
Pause it.
Thank you.
In Your Honor, and
I'm saying that I think we need to keep an eye on the fact that this is a Daubert hearing and not get sucked into what the state wants to do and keep some stuff in your back pocket for trial.
back pocket.
Oh, you're going to get Mandy to play Hot Pocket with that.
Hot
Jeez.
pocket. There, I did it. I sound just like Gaffigan anyway.
and thank you, Mr. Sullivan. I have provided the court and offered to counsel, but counsel already had the copies, a notebook that has exhibit numbers.
Thank you.
You're welcome. Mr. Brennan has agreed that all the exhibits in the notebook can be in evidence. So that's number 2. And so if I'm remembering correctly, Your Honor's previous direction that if they're in evidence, just refer to them as such. So that's what I
Yes.
plan on doing.
Yes.
And what I also plan on doing, Your Honor, is taking the exhibits that are in the notebook. I've got non-binder ones individually for the witness that are
Okay.
pre-marked. Does that work also?
Sure, you can just put them up on the stand with Dr. Russell.
In my approach to do that?
Don't make any faces. We all have to stay faceless and expressionless. Oh boy, but your eyes got wide.
May I
They
talk
got
to the
wide.
witness and
Oh,
just find out
wider.
where they are?
I think you can give them to her. I think
Okay,
she can
that's-
figure
okay.
out numerically what's what. All right, Mr. Leslie, I'm not rushing you at all, but is it safe to say that you won't finish in 20 minutes?
That is safe, Your Honor.
Okay, so we will plan on breaking at 1. Mr. Clerk will have to cancel our afternoon list. What, how long do you think it might take?
Boy, you can be on here
And I'm
all
not
day.
holding you to this, just curious.
I appreciate the question. If I can just have a quick moment, because I knew what my redirect was going to be until Mr. Brennan went, and I'd like to consider what he did. My best estimate is approximately 2 hours.
Oh Lord,
Okay,
just
I'd like
break
us to
now.
finish by 14.
Yes, Your Honor, understood.
Mr. Brennan, I know you have no idea how long recross might be, but we'll try and finish by 14.
Understood, Your Honor.
Jesus, you hear that, babe?
What?
He's got 2 hours. Sorry. Better take a 40-minute lunch. Let's go.
May I now proceed, Your Honor?
Please.
Thank you. Dr. Russell, during cross-examination at this Daubert hearing on December 12th, you were asked whether you believed you were an expert in the areas of orthopedics, accident reconstruction, biomechanics, motor vehicle accidents, and defensive wounds. In your 29 plus years of experience as an emergency medicine physician in training emergency medicine physicians, are you aware of any emergency room or emergency department physician being board certified in orthopedics?
I
No,
don't think we need this.
Are you aware of any emergency medicine physician being required to be an
This is
expert?
exactly
in
what you
overall
keep in your back
orthopedics?
pocket.
no. General orthopedics, no.
But do emergency medicine physicians nonetheless routinely evaluate and treat people injured in motor vehicle accidents?
Yes,
And did you, in your 29 years of experience as emergency medicine physician, routinely evaluate and treat people injured in motor vehicle accidents?
yes. I worked at a busy level 1 trauma center.
During your cross-examination in response to a question, you stated that you were an expert in emergency orthopedics. Can you please explain that?
Yes, so emergency orthopedics is a subset or just a part of the overall field of general orthopedics. So in emergency orthopedics, physicians care for, evaluate, diagnose, treat patients who have acute injuries and that don't need operative care. So acute fractures, acute dislocations, those types of injuries are done in many busy emergency rooms, right in the emergency room. And that's what I have expertise in.
Did the rotation at you just said busy hospital that you were at, did the rotation when you were training, were you required to take a part of the training in emergency orthopedics?
I was required to take a 1-month rotation in orthopedics.
Now, you were asked during cross-examination at this voir dire about one particular specialized training that you had involving motor vehicle accidents. And you, in response to a question from Mr. Brennan, agreed that that particular course was rudimentary. Do you recall that?
Yes.
When did you take that course that you referred to as rudimentary?
It was around 1979.
And what profession did you have when you took this rudimentary course that you were asked about?
Oh my God.
I was a police officer.
Lisi pronounces rudimentary very strangely.
Yes. Rudimentary.
It's definitely rudimentary.
Right.
And since that one rudimentary course that you had,
Pronouncing it correctly.
have you had further training with regard and experience to humans injured in motor vehicle accidents?
Yes, much.
And describe the experience and training you've had in that area.
Well, during my 29 years working in the emergency department, we saw motor vehicle accident victims on every shift. And usually there were multiple victims on every shift. So that was part of it. Plus we had lectures.
Thanks, Helen.
And seminars on motor vehicle accidents, victims.
See, there you go.
And is your focus in your testimony, both in June of this year and in December of this year, on wounds from motor vehicle accidents or how motor vehicle accidents occur?
So as a physician, my focus is on the wounds and injuries caused by motor vehicle accidents and how to diagnose and treat them.
So are you sitting as a medical doctor giving opinions on medical causation of the injuries to Mr. O'Keefe?
Yes.
Agreed.
During cross-examination, in this hearing, you were asked about whether you were an expert in accident reconstruction. Is being an expert in accident reconstruction necessary to practice emergency medicine?
No.
Does an emergency medicine physician need to be an expert in accident reconstruction to evaluate and treat people injured in motor vehicle accidents in the emergency department?
No.
This is back pocket shit. It's back pocket shit. The judge doesn't need to hear this. He's just showing the state how he's going to respond to all the bullshit the state just threw out. I was hoping they wouldn't fall into that trap. And I know if I was sitting there doing it, I would want to just come at him with all of his shit right then and there. So it's definitely, hard to do. But I think that they would have had this little powwow, all right, don't fucking give in to any of his shit. Just stick with Talbert. Was that you or Mandy?
It's definitely me.
Oh, Lord. And thanks for your generosity, Lisa. And I couldn't agree more. I would give anything for her to ask him if he can tell her which edge of which piece of broken taillight caused each wound, since apparently that's what we're doing now.
Can I ask you one more question?
Oh, Hank Hill, I love you.
29 years experience as an emergency medicine physician and training emergency medicine physicians. Are you aware of any emergency medicine physician being an expert in accident reconstruction?
The judge doesn't need this.
Is accident reconstruction even relevant to the practice of emergency medicine?
No.
Is whether an emergency medicine physician and expert in accident reconstruction a reasoned question in the field of emergency medicine?
No.
During cross-examination in this hearing, you were also asked about whether you have a degree in biomechanics.
Come on,
In
buddy.
your 29 years experience as an emergency medicine physician and training emergency medicine physicians,
Fell right into
are
it.
you aware of any emergency medicine physician who is an
Gone
expert
to the
in
scene?
biomechanics?
No,
Is being an expert in biomechanics necessary to practice emergency medicine?
No.
Is whether an emergency medicine physician is an expert in the field of biomechanics a reasoned question in the field of emergency medicine?
no,
In your 29 years of experience as a medical doctor, where do most people go for the treatment of acute injuries from motor vehicle accidents?
to the
Come
emergency
on.
department.
Do you know, or have you had any experience where a person who has an acute injury from a motor vehicle accident goes to an expert in biomechanics?
No,
Do you know whether anybody who's injured in a motor vehicle accident, acute injury, goes to an expert in
Just get a
expert
fucking
in
store
accident
right now.
reconstruction?
no.
On cross in this hearing, you were asked about your expertise in, quote, self-defense. Was your direct testimony in this hearing in your report of December 9 about self-defense or defensive wounds?
Would you repeat that question?
Sure. Was your direct testimony in this hearing in December and the report that you prepared dated December 9th, was that about self-defense or defensive wounds?
My testimony was about defensive wounds, not self-defense.
What's the difference between self-defense and defensive wounds?
Well, I believe self-defense is something like martial arts and the study and techniques of defending oneself from an attack. That's what I believe self-defense is.
You were also asked on cross in this hearing about whether not observing how a wound to the posterior side of a forearm occurred provided you with sufficient context to determine.
Did Bob pause this remotely?
Yeah, I paused it. So this, like Andy asked a good question. Could some of this be to recalibrate Dr. Russell? I have to harken back to what Allison just said in terms of putting it in your back pocket. Like you don't want to give the state the opportunity to know how you, as the defense, would rehabilitate your witness. But, you know, you've got, like, if Elise's feeling like, all right, did Brennan make enough headway with this bullshit that he just put up there that Bev is going to lean towards excluding her as a witness? I mean, so he's probably got
none
that.
of this. Bev was never going to think she needed to be an accident reconstruction. She needed to be a bioengineer. She needed to go to the scene. None of that is relevant to the Dahlberg motion at hand.
I agree. I
So
agree.
none of
But
it's changing Bev's opinion.
I just
But
can't.
who
see
knows?
her
She can
excluding.
be dense.
Right.
So
I mean, she's got an eye booger right there.
I'm going to
right?
have to turn off my screen so I can rock in my chair some.
Bev's eye booger.
whether a wound was a defensive wound. What context did you have with regard to the wounds on the right arm of the decedent to reach your conclusion that those wounds were defensive wounds?
Well, the context is the configuration, the location of the wounds, and the presence of a dog.
Oh,
In the cross in this hearing, you've been asked whether
saying dog, babe, not
you
canine.
have observed how wounds are created. In your experience, do emergency physicians or forensic pathologists get to observe how wounds are created?
No,
Do emergency medicine physicians and forensic pathologists nonetheless often reach medical diagnostic conclusions without observing how the wounds are created?
yes, they do.
And is that a common or uncommon practice for emergency medicine physicians?
Well, that's common.
How common?
Guess what? Judge Bev knows
Fairly
this.
common.
He's getting a
You were
snooze.
also asked whether someone could, and this is on cross in this hearing, whether someone could incur wounds to the posterior side of the forearm if they fall to the ground backwards. Did the wounds to the right arm of the decedent in this case arise from him falling to the ground backwards?
No.
Why not?
Because of the configuration and the pattern of the wounds.
And what's
And
missing?
you come to that conclusion to a reasonable degree of medical certainty.
Yes,
You were also asked on cross in this hearing about when someone hits a moving or a floating object, whether the patterns are dynamic and changing all the time, and the hitting concept. Can you please explain the question that was posed to you about moving, floating objects and hitting objects and how you evaluated those issues with respect to the decedent in this case?
Sorry, I don't understand the question.
You asked it.
Understand the question?
Not exactly.
Okay, ask the question differently.
I wasn't
Not
sure.
really.
I thought he must have asked it.
On cross, you were asked about when someone hits a moving or floating object, whether the patterns are dynamic or change. Can you please explain those concepts in that question and how you analyze them with regard to the wounds of the decedent in this case?
Okay. When there is movement and there is contact, there is movement of the, for lack of a better word, inflicting object, such as a tooth or something else. There is movement along the skin during the period of time in which they are in contact. That's what I understood that I was being asked.
On cross-examination, you were asked several questions about pattern recognition and pattern recognition methodology. And you were asked about the development, that's what I want to start with, of your pattern recognition skills with regard to dog-inflicted wounds. How did you develop your pattern recognition skills with regard to dog-inflicted wounds on humans?
Well, as I testified earlier, I've seen many, many, many dog bite victims. And sometimes I was able to talk to, I closely examined their wounds. And not only examined, but evaluated, treated. But in many cases, I was also able to talk to them and ask them about how the wounds were inflicted. And I did this over and over and over again, hundreds of times. I think I testified about at least 500 times over the years. So as you do that, you learn. You know, you recognize, you get sharper. So that's how I did.
And did you also edit any peer-reviewed publications that were relevant to pattern recognition and pattern recognition methodology?
Yes, I did. Now, pattern recognition in general, first of all, pattern recognition in general is a really important feature of medicine. It's critical. It's so important. And we start learning pattern recognition from medical school, from the beginning of medical school, learning how to recognize patterns of cells in pap smears and biopsies, patterns of cells. That's what a lot of pathology is, pattern recognition. And so, and even radiologists use pattern recognition when they look at x-rays of pneumonia, for instance. Different pneumonias have different patterns. So pattern recognition is something that I've been doing since, beginning of medical school, and actually a little bit before medical school. So that was 50 years ago, I think. 40 years ago.
Is pattern recognition some novel or unscientific process, or is it rooted in evidence-based medical science?
Oh, it's definitely evidence-based medical science. And in fact, there are textbooks on how to recognize certain patterns. So there, for instance, in pathology and, in medicine, there are textbooks on how to tell if somebody's got liver cancer or somebody's got, some other disease. This is pattern recognition for the most part. And x-rays too. It's in textbooks. There are huge textbooks and numerous textbooks written about this.
Is pattern recognition methodology that you've been testifying about, is that generally accepted in the medical community?
Pattern recognition as a methodology? Absolutely.
All right, Mr. Alexi, we're going to take our break. We'll be back at 2 o'clock.
Thank you.
All right. Perfect timing, babe. So Mandy just sent me a petition that was filed today.
Yeah, I saw it. It was Dizzy.
Oh, Dizzy. Well,
Yeah.
Dizzy and Mandy.
I was just getting ready to pull it up before
Go
we
for
dip for
it.
lunch.
Yes. And then we need to eat and stretch and
Need to stretch, swivel in our chairs, do all those things.
Yeah.
Swiveling in my chair.
especially because you moved the microphone up so high, I had to elevate the chair, which keeps me off my feet
Hey,
off
I
the
meant to
ground.
ask you, did you use pliers?
You made it so tight, I could not undo it.
Destroyed the mic stand thing with that thing, dude. Like, just calm me down. Like, I felt like I was getting little microscopic, like taillight shards.
I can't
size
move it.
of
That's why I had
metal in
to
my
lift the
fingers
chair.
trying to.
And you
Babe,
hid
that
the
thing just tightens like that.
you hid the
Used to
pliers on me, I
feel
think.
it when Darren tightens it. Like I feel like I need a vice grip to undo it.
Well, that's what I
His
was
big
doing.
meat hammer
Ugh.
fingers, man. He tightens that thing. It's like holy shit.
You
All
mean
right,
his
let me pull
strength?
this thing up real quick. I got to email to myself. The girls sent it via text. Can you pull it up through
Yes,
the
I
text?
can.
Oh,
Yes, I
good.
can, sir.
You do it.
Yes, I can.
You do it. You
'Cause
do it.
I have my shit set up like a normal human being, so
So just a reminder, tonight, Jennifer Auger, the first
Oops.
of our series of our interviews with the defense team for Rick Allen. So that starts tonight, 6 p.m. Central Standard Time, 7 p.m. Eastern Standard Time, and same time for Andrew Baldwin tomorrow. And I had to move it up an hour for Brad Rosie on Thursday because he needs to be watching Notre Dame in the college football playoffs. So do that. Also, I have a big favor to ask you guys. Okay. And I'm serious. Like it's free and it'll take you literally 2 minutes, maybe a minute. Go into Apple or Spotify podcasts and go to Murder on Songbird Road. And please, please review it, rate it. If you haven't listened to the episode, you should. I think it's a great, great podcast. It's going to get better and better as it goes. I know because I was there. I'm part of it. But I'd really appreciate that. Like two people. Like there was a shill one. there was a shill review, and there was all Delphi related, and that
people are just so thick.
murders.
I can't understand how people still hold on to this shill thing when literally every other lawyer in the free world is saying the exact same thing.
It's so weird.
It's like, hello, people, use your own brain.
Yeah, they listen to other
Yeah,
creators.
we know. I know. We're not gonna.
It's like
we don't need to hear
but
about it.
like the bigger thing is like why are you trying to just because we have a difference of opinion on a case?
Right.
It's strange. Like I don't do that. I don't do that. But if you guys, even if you haven't listened to it, which I only want people that have actually listened to the first episode or first couple of episodes when the second one drops, or if you subscribe, you can have the second episode now to leave reviews because I like genuine reviews because it's the same thing. It's like people are just trying to pull the overall rating down because they disagree with the Constitution and due process. It's like, oh, yeah, I can't argue about that anymore if people are too thick to understand what we're talking about, due process and the Constitution. I can't help them. Like that's where their brains are at. So, but that would be huge for us. We'd really, really appreciate it. It's just a little gesture that you can do to thank us for all the time that we spend on YouTube lives, trying to entertain and educate. So it's a small ask, but I'm going to continually really kind of bug the shit out of you guys.
All right, babe, you read. I'll scroll.
Okay. So notice of Commonwealth's intention to exclude the ARCA witnesses, Daniel Wolf and Andrew Rensler.
Crash daddies. They're no good. They suck.
For what does that expect? What is,
expected inability.
For expected inability to comply with Massachusetts rules of criminal procedure, 14 discovery obligations. So now the Commonwealth now comes the Commonwealth and respectfully provides notice to the defense and this honorable court that at some point prior to trial, it expects to preclude ARCA witnesses Daniel Wolf and Andrew Rensler from testifying at trial. It is possible the defense may intend to call one or both witnesses at trial. As proponents of the witnesses, it is incumbent upon the proponent to comply with Rule 14 discovery obligations. The obligation is not dependent upon best efforts or fault. Rather, it is simply the obligation of the proponents of its witness to comply. The history and complexity of the ARCA witnesses' employment and directives are muddled and unnecessary to recount for the purposes of this notice. Rather, it is expected that if the defense attempts to proffer either or both potential witnesses, it will be unable to comply with Rule 14 obligations. Commonwealth does not allege that the defense will be negligent or unwilling to comply. Rather, it is expected that given the handling and employment of these witnesses, the defense will simply be unable to meet its obligations. The Commonwealth provides this notice prior to any hearing or filing a motion to preclude and prior to a ruling on DK 442, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. The purpose of the notice is to alert the defense and the court of the Commonwealth and the court of the Commonwealth's expected position, given the trial date and the impact exclusion would have upon the defense.
So there you have it. The prosecution clearly, truth doesn't play into anything. It's just about, we got to knock out all the defense's evidence, and that's the name of the game in the legal world. So I'm not faulting him for it. I'm just saying.
Yeah. Let me see.
All right, let's go let the people eat. But we did not listen, so you might need to go back, or maybe somebody else did. How long she said the break was, or did I just miss it? Did she say when we'll be back?
She said 2 hours.
No, no way. She wants to be out of there
no, she said
before.
2:00. So, I mean, frankly, it's not that far down the
Right,
road.
so we got to go eat. Or do you want to leave it open? I don't know. I want to
What do you guys think? Should we leave the chat open or should we
leave the
restart?
chat open with the thingy. Do we have a
'Cause
thing
it's
that
one,
says?
it's 24 minutes away.
So do we have something that says we'll be right back? Talk amongst yourselves.
Yeah, see, they cut the stream, so it's like I can't even fast forward.
What do you
So,
need? I'll grab them.
all right, we'll leave the chat open and we'll go eat. So you guys talk amongst yourselves. Allie, can you come up with? Oh, she left. I was going to come up with a coffee talk discussion. Let's see. What's a good coffee talk discussion? Linda Richmond style. Let me think about this. Drones or aliens? Discuss amongst yourselves. We'll see you in a bit.
Go right ahead, Mr. Leslie.
Thank you, Your Honor. Welcome back, Dr. Russell. We left off talking about pattern recognition in your pattern recognition methodology. Are there patterns to dog-inflicted wounds from civilian dogs?
Yes.
What are the patterns?
Oh, there are several patterns. There could be just simple abrasions and grouped abrasions. There can be, depending on the depth of the injury, there can be what they call the hole and tear pattern if the teeth penetrated through the skin. There can be a variety of patterns, including parallel lines and others.
And others.
Your support in the medical literature for these patterns and your pattern recognition methodology.
Yes.
Can you name the authors of any peer-reviewed studies supporting the patterns and pattern methodology?
Yes. So the two come to mind right now, and one is written by DeMunich and et al. And there's another one with Dr. Pollock et al.
And to help our stellar stenographer, DeMunich is DEMUNNYNCK. If you could please turn to exhibit number 33 that is in front of you.
Yes.
Let me know when you have that
I have
exhibit.
I have it.
Do you recognize, is this the DeMunich peer-reviewed article that you were just referring to?
Yes.
What I'd like you to do, Dr. Russell, is to point out where in this article there is the rooting of the pattern and pattern methodology, recognition methodology that you've been testifying to. Where is it located? And with the court's permission, I'd like you to read the specific sentences and paragraphs where that methodology is rooted in it.
Tell us first, because if it's a whole page, we're not going to do that.
It's not a whole page, Your
So
Honor.
let's just see
Yeah.
where it is. Okay.
Okay, on page 298. The second paragraph on the left-hand side. Okay,
Your Honor, it's not going to be reading a whole page, it's just the portions of this. Is that acceptable
So
to
you
the
can read a
court?
portion of that paragraph, Doctor? Because what you're trying to do is convince me, right? And these are
Understood.
in evidence, so could you
Okay.
tell me where it is, please?
okay, so left-hand
Right, first
column,
paragraph, second paragraph. Where do
second
you start?
paragraph. So it's part of the second, the third, and the fourth parts. So it says, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower jaw. Usually the mandibular dental arch is narrower and shorter than the maxillar, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed.
And then if you could skip to the next paragraph, because we want to follow the court's direction not to read everything,
Right.
just trying to focus on the key aspects. Is there something in the next paragraph that also supports it?
Okay, yes. Okay, the above features attribute to the characteristics of dog bites.
Can you tell us what that sentence means? And does that sentence have any relation to the concept of pattern recognition?
Yes, it does.
Explain how.
Okay, well, so they're talking, well, first of all, the previous paragraph was talking about the dentition of the dogs and how there's some variation in the dentition. And then this next sentence says the above features attribute to or relate to or are relevant to the characteristics of what the dog bites would look like.
And then as you continue on in that paragraph, again, not reading every sentence, but is there another part of the paragraph that continues over on to the next page that also supports your testimony that this is talking about pattern recognition methodology?
Yes. So it goes on to say that the puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretch lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to each other, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals which are not accompanied by pulling and shaking, nor by the usage of the prominent canines, and with stab wounds caused by sharp instruments.
Does what you just read establish the pattern and the pattern recognition methodology for dog bites?
Objection.
Oh,
Objection sustained. Ask the question differently.
did she just ask him why?
What do you
What?
conclude from the language you just read with regard to patterns and pattern recognition methodology?
Well, I conclude that patterns are important, and they are what I call highly representative, but they call pathognomonic, meaning that there is nothing else that causes those.
Let's focus on the word, people pronounce it differently,
Yeah.
pathognomonic. What does pathognomonic mean in medicine?
Pathognomonic, to me, I believe it means that you can make a diagnosis based on these factors that are present to the exclusion of any other diagnosis because they are so specific.
So we talked about on your direct, and it was raised on cross, the concept of a differential diagnosis, right?
Yes.
When you have pathognomonic features, is it required to even have a differential diagnosis?
Not really,
Why?
because the pathognomonic features mean that you have the entity or the condition that that is explained.
Does pathognomonic mean that the features themselves rule out other possibilities?
Yes, that's what I believe it means.
And is that how you interpret what the author is saying in this article?
Yes.
Please proceed lastly to the next two paragraphs, and then we can move on to the next study, I believe.
In conclusion, to identify a lesion as a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff abrasions, include a puncture wound and sometimes an avulsion with irregular borders resembling a dental arch print.
And could you please, as the last paragraph we'll focus on, read what you consider important in the next paragraph?
The shape of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it mean to you when the author says, and will differ whether or not the full dentition was used to produce them?
So what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes.
Is this support for your pattern recognition methodology?
Yes.
Is it direct support for the pattern recognition methodology you have applied in this case?
Yes.
Is there another article? You mentioned two, you mentioned DeMunich and Pollock. So let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34. And is this the Pollock, P-O-L-L-A-K, study that you have mentioned multiple times in your testimony and that's in your report?
Yes.
please, like we just did with the DeMunich article, please identify the portions of this study that support, you've testified, support your pattern recognition methodology.
Okay.
And let's
Well,
do
start
a
at the beginning.
seriatim from the beginning.
Yeah,
Yes,
I'll do it
please.
from the beginning. So, the dog's front, so the first paragraph
Okay,
here.
the summary?
Yeah, this says summary. Yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, arranged in curved lines. There seems to be a word or two missing.
No, you missed a word. That's
I
okay.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds on humans, there's a pattern?
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of key words when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time and with the court's permission, to the next section of this article that supports your opinion that there is a pattern to dog bite wounds on humans and that there's a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2,
And what is the title of that section?
morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically means form.
And could it mean something in addition to form?
Form, pattern, appearance, yes.
So with regard to morphology section, please identify the sections, the parts of the article under this section that you believe that you have concluded support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is interposition of textiles in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the deceased?
Yes,
And what clothing specifically was that?
it was a hoodie type sweater.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth,
And keep reading, please.
On the next page.
Yes.
The spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and/or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it direct or indirect support these studies?
I believe this is direct.
And do you believe it's robust, these studies, or do you believe there's equivocation with regard to pathognomonic features?
No, I think it's robust, and these articles are cited elsewhere.
And are these articles, particularly the DEUX article, is the citation ubiquitous in the medical literature, or is it sporadic? Are there a lot of citations to DEUX in the medical literature, or are there only a few?
There are quite a few.
And do you recall the book that Mr. Brennan showed to you earlier on in the hearing?
Yes.
Does that book cite to DEUX as support for a section in the book?
It does.
Now, there was confusion. You can put those studies to the side for now, Dr. Russell. Thank you. Now, there was some confusion on cross-examination regarding where these articles could be found. Some were looking for them in your CV. I'm sorry, Mr. Brennan.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Redirect.
Sure, I will, Your Honor. Where are the references? Well, are the references to these articles in your CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an accurate statement about how you develop your pattern recognition skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay.
And just ask the question, please. Again, this is redirect, it's not cross-examination.
Understood. Yes, understood. Thank you. Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of a wound?
No.
Would that be an accurate statement at all about how you develop pattern recognition skills?
No.
And why is that not accurate?
Because pattern recognition skills are again taught in various subjects in medical school. And I actually started even before medical school, but in medical school, they're taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please give some examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break, right, doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Rizzo. This is about you, and so you've heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
No,
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
no,
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
no,
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
no.
Is that a rational proposition?
I don't believe so.
She doesn't need this either. Look at her face. She needed all that methodology shit.
There was much discussion. Well, let me strike this.
Reading.
You were asked a number of questions about whether your testimony
I was working, sending a
here for this
email to
hearing
opposing counsel.
and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So what I would like to do is to have you have Exhibit 35, which is the transcript of the December 12.
Yep.
Do you have that? It's a thick.
She could just chime in and say, you know what,
It's the
counsel, can
December
you all
12,
please approach?
2024. You should
Pause
have
it,
that.
babe.
I do.
Okay.
Babe.
And what I would like you to do is to also have available.
Sorry, I was napping.
Yeah, I'm gonna have to cut out soon to go with your father. But I think she could, if she wanted to save herself some pain, she could tell them to approach and say, I've heard enough. I'm ready to rule. Why don't we just wrap this up? But the lawyer might want to get some stuff on the record in case opposing counsel tries to use this transcript during trial, so he might want to clean some shit up. So
Well, I think, that's not his call. That is Bev's call. But I think that only works if she's ready to rule in favor of the defense.
well, yeah, obviously.
Well,
Sorry, I should have made that clear. Only if she's, I'm assuming she's letting her in. So that's why I'm saying that. But
wow, it's a mighty big assumption there, Allie.
I don't know. But when I got to go, I'll just give you guys a wave and leave.
Aw.
And then see everybody tonight.
Exhibits 35 and 36 and 37, because that's what we're going to do side by side comparisons. So let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
They're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Now, at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to tab 36, pages 1-30, line 13 to 1-31, line 1, stop at 1-31, line 1, These were questions in response to what you were asked on direct by Mr. Jackson. And I would, with the court's permission, like you to read the question in the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
Ooh, can't bloop, bloop, bloop anymore. I hear a lot of movement upstairs. All right, I'm gonna depart from you now. So, babe, you've got to talk to the people while she's on the sidebar. Well, you're on mute, so it's hard to talk to the people when you're on mute.
Thanks, babe. Yeah, I was definitely talking on mute.
Ooh.
I had my cough button depressed.
Well, you can thank some people. I don't know if those are all old or some
I think
new.
they're pretty old.
Well,
Gail,
not
appreciate you.
not
Marissa, appreciate you. Dr. Vonda, 7-month OG member. She's been a member longer than that. I think she just re-ups.
not
Appreciate
Sinead. Sinead's comments new.
it is.
Yep.
Melinderp. Appreciate
Thanks
you.
for your generosity.
Appreciate you. Chloe Alberts, bits, bites, and bites. Appreciate you always. Wendy DeBee. Appreciate you.
Wait, what'd she say?
Wendy DeBee coming in hot.
Alyssa better bring up what? I missed it.
Elise better bring up the lack of blood DNA evidence. I agree. We'll see.
That's a closing argument.
Karen Jones, family hug. Welcome to the fam. Love having you. Lisa M, appreciate you.
I read that out. Thank you.
Kraken, member for 9 months. Appreciate you. And then Sinead.
Critical thinking and common sense is
Allie,
selective.
buckle up. That was back in the
Thank
coffee
you.
times. That was back.
Well, she must have been watching behind time then because it came in at 1:15.
All right.
All right. I love
Hey,
you.
while you're there, sitting there waiting,
Yeah.
look through all the
I might bring my computer.
the questions from the community page for tonight.
Where do I find those again?
On the community page.
No, you said that it would. All right.
Well,
I might come back. I don't know.
They're also in Discord as well.
Okay. Love you.
Love you. Long time.
See you guys tonight.
Bye.
Yep.
Boop. Yes, they do, Lisa Shelton. We have Jennifer Auger. I'm gonna when I get Jen backstage, I'm gonna 100% clarify the pronunciation of her last name. When she first came on, I was definitely calling her Jennifer Auger because it's Auger. And then I remember I was in court and I heard it was like Auger. Sounds French, so that would make sense. Auger. Yes, my name is Jennifer Auger. So yeah, I'm looking forward to it. It's going to be very interesting. Next 3 nights are going to be very, it'll be interesting to see what they're willing to talk about and what they're not. I mean, in the sense that Richard Allen has an appellate case that's going to be happening in the near future. There's going to be limits, I'm sure, but we'll see. Yeah, exactly, Spoogies. We'll find out. I mean, we had an unbelievable turnout with questions, though, on the community page. It was phenomenal. That's where I wanted you all, because I'm going to be turning off the chat. I sound like I'm in a fishbowl? Oh. Maybe because my mic is muted. I don't know. I think it could be on your end there, Bracken.
Yes.
Dr. Russell, could you First of all, do you recall in questions on cross the claim by Mr. Brennan or the statement in his question by Mr. Brennan that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion? Do you recall those questions?
Yes.
Do you recall? Well, let's go and look exactly at what you said in response to the question that Mr. Brennan raised that was raised by the judge. If you could turn to.
I think I fixed it. Is it better? I think it had switched over to my Mac microphone for some reason. Does it sound better now? You like AJ's facial hairs? Let's I'm gonna ask you to wait until we get a close up, and then we'll see. We'll see what's up. See what's up. A little patchy. It's a little patchy, and I I love AJ, fellow
Tab,
defense guy.
excuse me, Exhibit 36.
Thanks for the heads up, y'all.
And if you could read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct citation. I want you to go to, did I say 37? I wanted to say 36. Did I say 36?
You said 36, but you said page 151. You might have meant page 131.
Right. That's what I want to go to, Your Honor, which I will. Okay. Bear with me a moment, Your Honor.
Sure.
This is going to be one of only 2 questions in this area.
You may have meant page 130. That's where we started before we came to Cyber.
Thank you, Your Honor. What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150. Thank you, Your Honor.
151.
Can you go to page 151 and read the questions from the court, Judge Cannoni, and what your answers were?
Yes, from line 10. The court, question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion? Answer, yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches. Question, do you know what kind of animal? Answer, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty. Very sure, high degree of medical certainty. Question, reasonable degree of medical certainty? Answer, yes, definitely. Question, and okay, and another question.
No, that's
it. That's it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as you know, any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer review studies, and I was convinced that I was correct.
And had you looked at, well, what caused you to go look at the peer-reviewed studies? What were you doing?
Well, so I looked at the peer review studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No.
But you were asked to write a report after June of 2024.
Correct.
Now let's go to is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is. Is that something that's common or uncommon in the medical community?
That's very common.
I only have a few more questions, Your Honor. I'm just looking at them to conclude. On cross, you were asked about whether you were aware of or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes.
Was that necessary?
No.
Why not?
Because first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue, is I wouldn't even know who to send it to because I don't know of anybody with such experience.
I am going to, let's assume hypothetically that Mr. Walsh has stated that these injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, the wounds to the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern. And so thus couldn't really even make that opinion and, just didn't recognize the features.
In the hypothetical that I just gave you, do the facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree with that statement? Or the conclusion? Would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
Sorry.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up until the point, the mention of the taillight.
But what is it that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found on the decedent? Are you aware?
Not on the decedent.
On any aspects of the decedent's clothing?
Yes.
Do you know from your experience with regard to dog-inflicted wounds, your many emergency room evaluations and treatments of them, whether or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that the dogs, some dogs eat treats that have the pig chews and other kinds of chews. So yes, they do. Some dogs do eat things that contain pig.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm
Why don't
done.
you come to sidebar instead of having
Okay.
a discussion across the courtroom?
Sidebar. Everybody loves a sidebar. So he say he's done with his questions? All right. All right. All right, so yeah, I don't know how much recross there can be from that. I mean, look, at the end of the day, she's got to let him in or let her in. Like it's just not they can't keep her out. You know, but ultimately I think there's going to be, just how much weight. Like the curative thing that she can do is give an instruction. But to bar them from being able to put an expert on, that's no bueno. It's no bueno. I mean, look at it this way. We all got a general sense of how Judge Bev felt about the third party culprit stuff leading into trial. Like if you were following it, you had a pretty clear understanding that she was not a fan of it, wasn't buying it, and it all came in. So MB, I want to say it was 8-9
All right,
weeks.
so recross examination.
Say the magic word briefly, Your Honor, briefly.
You need a moment?
I'm holding Mr. Brendan up. I just
That's
want to
okay.
move my stuff and I'll be ready in a moment.
Okay.
Dr. Russell, Attorney Lisi, pardon me, asked you about Dr. Walsh's statement about the cause of injuries. Do you remember? He just asked
Yes.
you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons and known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection, Your Honor.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes.
The documented changes in color, swelling of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis is a passive accumulation of blood around the eyes secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes. The 1 centimeter laceration of the right upper eyelid, laceration of the anterior right tongue, then abrasion of the anterior and left aspect of the nose are documented, considered nonspecific, and may have occurred to a variety of mechanisms. Do you agree with that?
Yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted from impact of hand with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Okay. When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that up, you said individually, none of those wounds could you say to a reasonable degree of medical certainty were caused by a dog. It's only if you looked at them collectively.
Yes.
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
No.
It doesn't tell you if they're all incurred at the same time, does it?
They were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No.
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart, table 2?
That's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing is, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case.
That's
isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim. Does it also say examination of the victim?
I don't have it in front of me anymore,
Well,
but.
you relied on it. You don't remember
Yes.
this?
I think we have it. We don't have it.
Dude, don't be such a dick. Bring it up to her. You know, like that's the kind of shit that's irritating about this guy. Like he can pocket all that shit and save it for another day. But like those kind of like snide remarks, like you relied on it. Well, you know what, dickhead, bring it up here. I'll read from it again.
Do I have it? Oh, yeah, just a minute. Okay,
Table 2,
okay.
page 98, examination of the victim. You did not examine the victim, did you?
Table 2.
Yes,
No.
table 2, page 90. And the last part is examination of the,
I examined photos.
the last part is examination of the dog. You did not examine Chloe, did you?
No,
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
those, again, the purpose of this article was about the fatal, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those 3 things, did you?
No,
Okay. The shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what you
shards,
say.
how many shards were in that sweater?
Objection, Your Honor.
So I'm sorry, you said that's what you say, doctor? Is that what?
yeah,
Is
and
that
he
what your
he
answer
said,
is?
Mr. Brennan said that the shards were in the exact same location as those wounds.
Okay,
And
let me
that's-
rephrase that. The shards in the right arm of the sweater, the shards from the taillight that was
Mhm.
shattered,
Yes.
those shards, how many were there? How many
I
microscopes?
believe there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told.
This is you were told by who?
Why do you believe that they were shards? Why does he keep using that word? Does he not know what a shard is? A shard is not a microscopic piece of anything. A shard is a big ass chunk of shit. You could use a shard in a prison to shank somebody. That's how big a shard is. This guy doesn't know what a shard is.
By
I want a shard emoji made immediately. Thank you, mods. Love you.
defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I was told, yes.
Wouldn't it be more prudent to actually look at the criminalistics report and make your own determination objectively and medically rather than regurgitate a point of the defense?
Well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
I see. Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before you offered this opinion.
No.
No. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater and a fabric, can puncture it, and it can cause an abrasion to skin. Have you done any tests or studies to rule out that the broken taillight that was in the arm sleeve?
Why does he keep calling clearly plastic material glass? Like, I'm not sure why Alici's not objecting to that. Am I missing something? Am I missing something? I'm not sure. He keeps referring to it, the microscopic pieces, okay, as shards, and he's calling plastic glass. Why is he conflating shit in a hearing with no jury present? It's bizarre.
Of Mr. O'Keefe, did you do any studies to rule out?
What the hell just happened? What? What happened?
Effect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground.
Wait, how did that happen? That was not me. I didn't touch shit. Bro.
The part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Did I go back too far?
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
All right, so there was that.
Is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing. The arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those holes. The defects in the sweater mostly were round. They were not slit-like defects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater?
No, I didn't say that. I said they would not, especially on multiple sites, the same exact type wound, defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look like that.
So from your perspective, the glass just remained dormant in the sweater, but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
Sidebar. This fucking guy, like calling them shards is beyond. I hope he tries to do that shit at trial. Like there's no quicker way to get yourself recognized as a full of shit lawyer by conflating facts into something that they're not. Like the jury is going to be able to look like you can't even see what they found in the sleeve of John O'Keefe's hoodie. They're that small. So I hope he keeps calling them shards because the jury will take exception to that. They're going to be like, what shard? I can't even see it with the naked eye, bro. But bro.
Dr. Russell, when I'm referring to these shards, and I've said glass shards in Mr. O'Keefe's sweater, a more accurate way to define it would be that these were plastic shards, the plastic covering at the taillight, not glass.
Thank you, Elise.
Okay.
Okay.
Shards.
Thank you.
Dr. Russell, you are all set. We're
Right.
done. We're done. You're done. We're done. You're done. You can step down, Doctor.
Good job, Doc. She never lost her cool. He was coming at her hard.
If council really can keep your, Mr. Lessie, if council really can keep your arguments to 15 or 20 minutes, I'll give you 5 minutes to pull them together, 5 or 10 minutes to pull them together.
Thank you very much, Your
I
Honor.
really
All right.
can't keep the arguments.
All right, so I'll be back out at 3:15.
All right, please.
So we got a few minutes. Got OnlyFan. OnlyFan. Oh, we love OnlyFan. All right. Enough of that goofiness. All right. So what are you guys thinking? I guess the question is going to be, is she going to rule from the bench or is she going to take it under advisement? To me, it's a no-brainer. I mean, she's got to let Dr. Russell in. I don't see any grounds by which she can bar Dr. Russell from testifying. I mean, it really, it's like saying, you can challenge any expert. You can challenge every single expert. The question becomes like, I don't know, because here's the problem from the Commonwealth's perspective is that they didn't put anybody on the stand from the Commonwealth's perspective to say, okay, there's no such thing as a dog bite expert. It just doesn't exist. Like essentially they're making a junk science argument, because in terms of her qualification, she's as qualified as anybody else is going to be. I mean, like how can there exist somebody who's a dog bite expert who hasn't viewed dog bites? Like that's what makes you an expert, right? So, this kind of concept that anybody other than a doctor who is going to be in the best position to see more dog bite wounds than anybody else on the planet, and I'm talking about doctors in general, if it's not a doctor who worked in an ER whose testimony is that she's seen thousands of dog bites, if she's not an expert, then they don't exist on the planet. So I think Bev's going to be very hard pressed. Like I said, I mean, they've got, she can admonish the jury. There's instructions in terms of weight, and that the jury is obviously allowed to give her testimony whatever weight they deem that it merits, and that's it. So to me, she should be just ruling from the bench. What's more interesting is and more problematic, especially if you're me, considering I've been talking about how I would only put Rensselaer and Wolf on, and maybe Dr. Russell, maybe one other witness, but I would pretty much abandon a vast majority of the whole. He was beaten inside the house, whether or not it happened, because then you've just got to get 12 people to buy into a whole shit ton of people have been able to keep a secret about them planting evidence and doing other nefarious shit, which certainly could have happened, but it's going to be really, really difficult to get 12 people to believe that it happened. That's the problem with juries. So, but this newest motion that was filed today, and if you were late and didn't see it, the state or the Commonwealth has filed another motion seeking to bar the testimony of both crash daddies, Rensselaer and Wolf, based on the fact that they believe that the defense will not be able to abide by the Rule 14 discovery guidelines, which require them to turn over reports. So I don't know exactly, like I'll have to hear that argument fleshed out. It was my understanding that both sides got copies of the report from both these gentlemen. And so in terms of what they're looking for additionally in discovery, I'm a little bit of at a loss. We read the motion. It's very bare bones. There's no specificity in terms of what they are asking for and what they anticipate that the defense is not going to be able to turn over. Now, I mean, that obviously brings up TUI. You know, I mean, are we in a situation where TUI is going to come into play and they're going to have to go to the feds again and say, look, man, we're trying a case. Are you about the truth here? Or, you know, are you about playing games? Like, you know, whatever we need to call these guys, and you know, whatever they turned up in terms of their investigation, in terms of their testing, we need it so we can turn it over. So we're afraid that Bev might bar them from testifying. So that one's tough. Because I don't know what her position would be. You know, in terms of looking up what the remedies are, if you're in violation of, you know, discovery statutes, they can be pretty severe. They can be pretty severe, you know, which certainly could include barring testimony from witnesses. I mean, you saw it in Lori Vallow when the state was slow playing, turning over discovery in that case, that they took the death penalty off the table for the state. You know, I mean, that's a pretty extreme remedy as far as the state's concerned. So, you know, I mean, they take the reciprocal discovery rules very seriously. So I'm a little bit nervous about that one in terms of, because look, I always just want the best factual, like no matter what the side, like because these aren't games to me. Like I've done this for a living for a long time. I'm always searching for the truth. And in terms of trying to get to the root of the truth, if the best evidence out there is going to be two independent guys who went out who are highly qualified and did their own independent testing, not being hired by either side, that's what makes them such beautiful witnesses. They're not state lackeys and they're not hired guns by the defense. They're truly independent. They had no dog in this race. They had no reason to form an opinion that wasn't completely objective. So, you know, the concept of those two guys not being able to testify is frightening to me because we really want to get to the truth here if we can. You know, it's like the whole phone thing. I am so sick and tired of nobody being able to answer that goddamn question about the Cellubrite extraction. Oh, Google search.
All right, did council have enough time to pull your thoughts together?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, Mr. Brennan, it's your motion, so I will hear you.
I agree with the judge, Mr. Brennan.
I'd like to start with a couple of very important cases for your Honor's consideration. The first is one out of the District of Massachusetts Federal Court. It's Hines 55 Federal Supplement, second, page 62. It's a 1992 case authored by Judge Gardner. It had to do with a soft science handwriting analysis. It was a very thorough and thoughtful case that talked about soft sciences, methodology, and when there is an absence of methodology. In that case, I'm sure Your Honor is aware, it had to do with a proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science. Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, it's not a science. It's not a methodology. It's not medicine. It is a personal aside. A potential expert has to be in a better position to understand and explain to jurors rather than a simple layperson. That means there has to be some level of methodology, some type of guidance, some type of study so that they can assist the jury in better understanding what they believe their conclusions are. empirical is not enough because a subjective opinion without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something.
Okay, no, it's not. We all know which star is which. That is a perspective of fact. The fuck is this guy talking about? This is what I'm saying. If you've got a situation where if there exists such a thing as a dog bite expert on the planet, it's going to be a doctor. And that doctor is going to be an expert based on the number of times that doctor has viewed dog bites. This dude is trying to turn this into like a tool mark analysis type of situation, and it's just not. Like there is no methodology to being able to recognize what a certain wound was caused by. Like it's apples and oranges. But if I'm going to play devil's advocate, they have absolutely just destroyed the concept of bite mark analysis and bite mark comparisons. Like that, it's basically been tossed. There's probably a couple of jurisdictions in the country that allow for it, but that was where, they bring dentists on, say, oh yeah, those, yeah, I looked at the x-rays of this person's teeth, and yeah, the bite mark on that person's arm, it appears to be a match to me. Like that's what the counter argument is. So I don't know.
Like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experiences.
Like this is the part that drives me nuts. And I'm sorry to keep pausing, but look, it can put it in the chat. In what situation, but for this exact situation, is somebody who is namely alive not going to know they've been bitten by a dog? Like this is like really, in my estimation, in our business, they call it a case of first impression. It's first blush. I don't like people that are coming in with dog bites. They knew they've been bitten by a dog. Oh, I'm at the ER. Well, what happened? I got bit by a dog. They're not trying to figure out what the injury was caused by. Like, in what other circumstance are you ever going to have a situation where you're trying to figure out what the injury was caused by, or if it was caused by a dog? I mean, it has to be post-mortem. So how many times, and if it's a situation where the person was killed by a dog attack, they're still going to know. So you have to, like, that. It's got to be limited to, like, I don't know, a very, very small number of times that in the history of jurisprudence that they've ever had this issue pop up. He's making a weird argument. I don't know.
As an ME, she treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education. She doesn't have the qualifications. She doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book. She doesn't have a study that teaches her how to do. She never took a training. She never took a class. She never got a degree or certificate. She's looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there's nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity, what is the standard, and we still don't know. After all of this testimony, we don't know. In Commonwealth versus Rintala, that case had to do with a prosecution expert talking about paint spill. And this is, could not fit more closely to this case. The conviction was overturned because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites, a person with their past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or a particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi, pardon?
Rintala.
Thank you. In Rinaldi, direct the court to page 39. And it talks about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Commonwealth versus Franceschi. I'm probably saying that wrong as well. But what that quotes is, while training and experience to which the expert referred might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out a methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody go before a jury and portray themselves as an expert when they have no methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based. It can't be compared. It can't be analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what they're saying. A witness is prone to change their opinion because there is no standard of methodology to confine them. A witness can just change their mind without new information because it suits their purpose. When we looked at Exhibit 5, and we actually broke down the wounds into separate wounds, 5 wounds, the doctor, I believe, concedes when you look at each of those abrasions independently. She cannot say with scientific certainty. She can't say with any certainty that those were caused by a dog. Her fallback was when you look at the entire series of wounds, that equals a dog attack. No basis, no reason why we reached that bridge from uncertainty to dog attack other than just because she said so. That can't be challenged because there's no methodology. And so the risk we have is you have an expert who gets up in a voir dire and they give opinions that wound number 1.
Okay, well, then the Commonwealth can't put on one person that's going to say that plastic taillight bits caused those injuries on his arm. They can't put anybody on there. If she can't do it, then they can't do it.
One could have been teeth marks, could have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3, the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report and consulting, and she is emphatic that these are not scratches, but that they are dog bites. Think about the posture of death. If she is now saying that these are dog bites, that impliedly concedes that her testimony in front of the jury, for which she was allowed to testify as an expert, not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they, later on, without any real changes in information, changes their opinion for whatever reason. They're not constricted because there's no methodology or standard. And so the fact that this witness was allowed to testify at the last trial with opinions she no longer endorses or stands behind, and the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support, and she does not. There is no doubt about one thing, she has no idea. When I walked her through the different wounds on Exhibit 5, I invited her to explain to your honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal empirical history dealing with dog injuries in the ER. And when I asked her for wound 1, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of those wounds, how could she reasonably and fairly say they were caused by canines? Any indication, any support, any pattern recognition that would tell us that was caused by canines, and she couldn't give us any information. Not weak information, not information that I could fight with another expert, not information that I could say, wait, not the admissibility, none. She could just fall back on, well, when I look at everything at the dog bite. Same thing with number 2. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is in any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally different. And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? She would only give us a conclusory answer. It just is. There was nothing about teeth or detention or about the dog, about anything that would support the claim that that was a dog bite and why she changed it from scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could have moved, would have moved, but yet she has no idea. She has no factual support for this, none. And she vacillates between this being potentially bites, scratches, all 5 of the different points on wound number 3 could be canines on both sides, or maybe there was a 4-point canine in the smaller fraction of number 1 and number 2 in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle, the depth. The canines are not going to move. Then we get to wound number 4, equally baseless. Wound number 4 at first wasn't sure if it even had to do with the dog attack, but then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And then wound number 5, again, a 4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim it's a dog bite. Not just that there was no opportunity and that there was no dog that touched her, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence that wholly contradicts the fact that this is a dog bite. She didn't know that there were plastic shards in the sleeve of his arm. The
Shard.
fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there isn't mere coincidence. It isn't mere coincidence. It's exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the stand and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the criminalistics reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support. This witness has the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. Knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free rein of an opportunity to look at the exhibit and tell us anything she wants to support as a dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 has 0 value. So 5 times 0 is 0. Cumulatively does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding to car accidents. She may have been a police officer, she treats injuries at the hospital. She is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she
You know who else doesn't know? This guy or the police. No one knows. I'm not muted anymore. Allie was yelling from the basement or the first floor. Like, this guy has no idea. He has 0 idea. Neither did the police. They weren't there. He keeps acting as if it's a foregone conclusion, that it is a fact that John O'Keefe was struck by a vehicle. That's what the entire controversy of this case is.
she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology, no facts, and ignore reality and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone, whatever the statements were. All the various statements. An expert like her, if she proposes to be, would consider the witness statements to try to determine the cause of mechanic of injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with any no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works. And so when we consider not only what she doesn't know, but what she chose not to know, it is overwhelming. This is not a qualified person to come in and talk about dog bites. From her perspective, she's probably one, if not a few people in the country who can even do this kind of thing, which suggests that there is no real methodology. If she is the only expert in the country, it is not generally accepted in the community. It can't be. It can't be. And as much as the defense may want her to testify to promote this theory, she does not have the credentials and qualifications to do that. She didn't even take the basic steps that you see in some of the literature of going to the dog. Chloe, they knew we found Chloe. They know we've done molds. And she says they told her. And she tried to fight with every posturing angle that may be important, but she didn't need to do that. I dare say, if she had taken some steps to try to do due diligence, it wouldn't have ended well for her theory. Perhaps that's why she didn't. She doesn't have the qualifications. She doesn't have the experience. She doesn't have the methodology. Her willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA. There is plastic shards in his arm. She has done no due diligence. And she can't describe any methodology because there is none. And she, most importantly, has changed her testimony from hearing to hearing, and we should not let that happen again. Thank you.
Thank you very much. All right, Mr. Lessie.
Thank you, Your Honor. The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and tell you exactly where I'm going to go. I am going to go to why we're here and what the issues are for this motion. So I'm going to start my argument with what is the legal standard that Your Honor faces to answer it. And I know Your Honor knows it. I'm just doing it for the logic in the presentation. I'm going to go through that. I'm going to identify specific case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced. It's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going to go through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology. I'm going to go through and say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. So let me start out with the baseline for this hearing. The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked at that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it, and went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law. Mr. Brennan and I agree on one thing. The Rottola case is relevant. But respectfully, Mr. Brennan went off in a tangent, because what does Rottola stand for that's relevant here? Quote, the crucial issue, in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony? It's what are the cause of the wounds to the decedent's right arm. I submit that if you ran an artificial intelligence program, you couldn't come up with a more perfect witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, forensic trained pathologist who has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Vail that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% your favorite, and I don't believe you could find another witness more qualified. And that's the crucial inquiry. What's the second prong of the inquiry? After qualifications, is the methodology reliable? That's the second. Whether Mr. Brennan agrees, and 95% of what he argued, that's for cross at trial. But more importantly, that's for a jury to determine. That's the job and province of a jury, to determine whether, assuming Mr. Brennan ever gets a doctor to come in and counter Dr. Russell. It's for a jury to decide which expert do we give more weight to. But the focus of this hearing, why are we here? The second prong is the methodology. Mr. Brennan, 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology. Your Honor sat and heard the same thing that all of us heard. She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. DeMunich and Pollock. And we walked through, with your Honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic. This pattern is so specific that it almost by itself rules out anything else. That's the definition of pathognomonic. And that's the definition. And Dr. Russell used highly characteristic, but she did note and explain what another study said was pathognomonic. It's incredible to me that it can be stated that there's no methodology here and that there's no basis for it. It is generally accepted in the medical community. That's the purpose of the Pollock and the DeMunich article, is to establish that it is accepted. Dr. Russell is not coming here to the court and just testifying, it's my subjective empirical statement. Mr. Brennan tries to do in his argument exactly what an expert rejected and for which he has no support. And that is to say, we got to look at these wound by wound by wound. And he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is the pattern. You look at these all together, and it's the pattern that matters. And the authors, Pollock and DeMunich, say that pattern is pathognomonic. You really don't even have to go to other causes, although Dr. Russell said she did, because that's what good, thorough doctors do. So it is incorrect that Dr. Russell didn't explicate a methodology. It's incorrect that she didn't explicate that there's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan cited to a paint case, etc., but interestingly, and in contrast, in our papers, which Mr. Brennan has had for almost a month, and he didn't respond, interestingly, we cited to the Lobello case, the Brinker case, both of which are dog wound injury cases, not pain cases. I know a little bit about Lobello because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations, including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so there is a dog bite case from the Southern District of New York, not an insignificant court, as recent as 2023, saying a doctor that sees and treats all these, that's reliable. And this was a Daubert challenge, Your Honor. This wasn't an incidental question. The challenge was defendant's motion to preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts, it's Daubert, Lanigan. You can satisfy Daubert, the federal, but you also Lanigan, and under Davis, you can have generally accepted in the medical community as well. There's one case. Another dog bite case, we cite Brinker that Mr. Brennan didn't address is a federal court case in Indiana where same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason, which is a good segue now to Massachusetts cases. Mr. Brennan's hypothesis is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog bite case. I want to be clear about that, but it's a burn pattern. And here's what the court said. The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case, I've already given you 2, but a firearm examiner in that case. The court said, a judge, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, accepted,
Son of a bitch! Son of a bitch!
Never mind. I'm just playing it. I swear I hit unmute.
etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the 2 cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology. And that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor is required, a medical doctor that is required under law in Massachusetts. I also, your honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, the Commonwealth further attempts to criticize, or excuse me, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. How does that square with your honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what your honor might do. So in terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now, a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it and sustained it and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted.
By what?
Where's the medical profession to support that?
By
Those
who?
are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunich and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis, but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident. And she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied, beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth.
It looked like Yannetti wanted to stand up and give him a rousing applause. I did. He was great. He was great. Like I was trying to read y'all Elise's background a little more. He looks young, but I think he's in his 50s. I think his dad started the firm, big time New York firm, super lawyer. He's Martindale Hubble EV, like super pimp lawyer, preeminent lawyer. He's argued successfully before the United States Supreme Court, the United States Court of Appeals, the New York State Court of Appeals. I mean, the dude, like you can hear, he put together an argument. And he came on pro bono. I mean, Jacqueline, I'm 55. So, I mean, I don't feel old or look old-ish.
Another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's docketed, but I filed a notice to the court regarding my concerns about ARCA witnesses. And the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
All right. So let's set a date for a Daubert hearing. Any idea how long you expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say that a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
Well, I can't
set
do
it,
it tomorrow.
or, well, then we'll stay now and do that. Are you ready to do that, Mr.
No,
Jackson?
we just got this on January 31st.
Okay,
We've not had an opportunity to respond to it.
December 31st, probably.
What did I say?
January.
On New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
You know, so what I'm saying is file your paperwork.
Okay,
All right, we'll set a date for a hearing.
okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them
Okay,
on Mondays or
that's fine.
Fridays
I
for you,
misunderstood.
thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so.
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all council have that date cleared because it was a trial date at one point in
Right.
our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
On all witnesses, not just that you said you're filing.
The only one he's got is for Rick Green.
What did you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARCA witness to failure to comply with Rule 14. It's not a Daubert hearing.
Okay.
It's compliance with Rule 14.
Okay, so
Notably-
that's different.
Yes, I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay.
If that changes my position, I'll notify the defense in the court. If it doesn't, then I'm going to pursue that.
Ajax is like, what the fuck's he talking about? Like they've been in court. He's probably not aware. He's probably not aware that he's filed this motion trying to boot Rensselaer and Wolf.
Okay.
May we be seen briefly at time about scheduling?
Hey. Come here, give me a hug.
I gotta go.
Gotta go where?
I'm taking the guy for a walk.
Aw.
It's my day today.
I love you.
Love you.
All right, let's see if we have any bloops.
Bloop 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 bloop. Bloop 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 bloop. Bloop 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 bloop.
Wow. Why do they have to have a sidebar right now? Like, all right, I think that's it. That's it. It's done. It's done. All right. So I guess she's taking it under advisement, which is good. Which is good. I thought Elise put up a really strong argument. So, all right, y'all. I'm gonna relax for a couple hours before we are back. 6 p.m. Central Standard Time. And I'm excited for it. I hope you guys are excited for it. And it should be interesting. We'll see. We'll see what the lawyers can talk about when they can't. You know, you just have to keep in mind their clients' appellate rights are paramount. Like nothing is going to top that in terms of what they're willing to talk about. So, you know, and if Jennifer tells me that's scenario I'm not willing to go into, I'm not going to push it. And, you know, like this isn't going to be like a softball thing. Like, cause I would have loved to have gotten into some kind of trial strategy type conversations. But when you have an appeal pending, putting anything on the record, and even though this is not under oath, y'all know how this works out in this world. You know, if anything lawyers or anybody says on any kind of recorded instrument, that can be used in terms of trying to prove points in legal proceedings. So, you know, they're not going to, none of them are going to do anything that could potentially hurt Rick's appellate chances. So, you know, but there's going to be plenty to talk about. There's going to be plenty to talk about. So I'm looking forward to it. I hope to see you all there. Once again, thank all of you for your incredible generosity. As always, you guys are always the best. We so appreciate you. Pammy, the feeling's mutual, 100%. All right, you guys. So thank you. I thought it was a really interesting day in court. It's like, this is like an interesting hearing. You know what I mean? It's like, you got to be a real law nerd to really like this kind of stuff. That's why I love you guys. You know, it's like, you got to really kind of dig this kind of stuff, even when it seems a little dry. And this is a pretty snarky hearing, but I think ultimately the way this thing's going to go down, I thought that Elise's argument was correct, mostly because it was what I was arguing. I mean, the state just said she can't because I say so. Like they didn't put their own doctor on and Daubert to dispute anything she was saying. So that in and of itself, Commonwealth loses in my estimation. All right, you guys, I love you. And just remember, without y'all, I'm just an old man talking about a whole bunch of old cases and new